Lo contigo. Hello. Court officer, sir.
That's okay. 2:30 minutes. Sir. 2:30 minutes. Echo ಆಗ್ತಾ ಇದೆ ಸರ್. ಏನ್ 2:30 ಇವಾಗ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಏನ್ ಹೇಳಿ? ಕೊಡಿ, ಸರ್ವ್ ಮಾಡಿ.
Commercial OS matter. Attachment has not been given by the trial court. There is urgency, you may sell the property.
I had a memo for disposal in the matter. I had sought for a mandamus.
Disposal Bharat.
Any date, madam.
Adjournments, list 1, page 60, 52, 17.
ಹಿಂಗಾದ್ರೆ ಕರೀರಿ.
Next week.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರ ಬೇರೆ ಎಲ್ಲಾರ್ಗು? 60 at the request of counsel for respondent number 1 released on 6th February. Interim order earlier granted is extended till next date.
Page 90, 64 to 7.
Number 12th of March. Connect to so and so and released on 12th March. Interim order earlier granted is extended till next year. Yes. Dated matter. Okay. 66 at the request of counsel for the petition released on 6th. It is made clear that no further adjournment would be granted.
Page 20, 72 to 77. Page 21, 78 to 83. Page 22.
Serial number 89, my lord. For respondent number 1 and 2.
Just a moment. 85. ನಿಮ್ಮ mic work ಆಗ್ತದೆ.
I appear on behalf of petitioner's counsel. I appear on behalf of petitioner's counsel.
Off ಮಾಡಿ. 85. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Representing the respondent.
85 at the petition released on 6th.
Interim order.
Hello. Serial number 89, Your Lordship. Serial number 89 for respondent number 1 and 2. Kindly 3 weeks time may be granted, my lord. I will file my statement of objections.
88.
Other side 89, my lord.
89. Have you informed the
Yes, Your Lordship, I have informed the other side. Earlier interim order was granted to the petitioner. It may be extended till next date of hearing.
89.
And fair enough, I'm also making submissions.
Counsel for respondent number 1 and 2 2 weeks time.
3 weeks, Your Lordship, kindly. I have to send the papers from Bangalore. 3 weeks, my lord.
On.
Your Lordship, one humble submission. 3 weeks time may be granted, kindly.
Yes, 14th file ಮಾಡಿ.
Grateful, Your Lordship.
53, 90 to 90.
Lord. Lord. Serial number first list, my lord. Serial number 50, 56 and 61, my lord. Short accommodation, my lord. Kindly be request, my lord.
56.
Yes, my lord.
ಯಾರಿಗೆ ನೀವು
I am for respondent, my lord. On behalf of Gurudev Gachinamat, my lord.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Yes, my lord. I informed, my lord.
56 at the request of counsel for respond number 2 released on 6th. 61
61, my lord. Please.
at the request of counsel for respondent number 1 and 2 released on 6th.
Yes.
Your Lordship, serial number 2 in list to Your Lordship, representing the respondent for Srivatsa Hegde.
Hmm.
I request for a week's time, Your Lordship. My senior is not in station. He has
This
been to
too, serial
Kumbh.
number 2 at the request of counsel for respond number 1 to 4 released on 7th February. Interim order earlier granted is extended till next week.
Your Lordship, list to serial number 5, Your Lordship.
Yes.
Personal inconvenience, Your Lordship. Kindly have it tomorrow. I'll be there, Your Lordship.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Your Lordship, some trial court advocate. I don't have the contact number.
DK Jadhav, ML Desai, Tilak Jadhav. Inform ಮಾಡಿಲ್ಲ?
I don't.
Don't mention, please. Sure.
But I'm filing memos, my lord. Memos for dispensation of notice.
ಯಾರಿಗೆ dispensation?
For R3 and 4, my lord. I have given up the claim, therefore I don't want to proceed with other.
R3 and 4.
Yes, ma'am.
What about the remaining?
Remaining are 10 also, my lord. Rival claimant I sought for dispensation. And 5 to 7 also, my lord, is dispensation.
ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ರೆ ಆಯ್ತಲ್ಲ, ಯಾಕೆ ಇಷ್ಟು ಮೆಮೊ ಆಗ್ತಾ ಇದೀರಾ?
Separate.
Counsel for the
Telling the
petitioner has
separate
filed a memo dated 27/1/25, accepting the said memo, notice to respond number 3 and 4 is dispensed with the sole risk, cost and peril of the petitioner. Another memo dated 27/1/25 has been filed, seeking for dispensation notice to respond number 10, accepting the same. 27, another memo.
5 to 7. 5 to 7.
Five to 7 will have to defend it.
They have sold the land and the person.
I am the
whom he
subsequent
sold,
purchaser.
He's appearing.
Lord, I am the purchaser.
Seller matter.
ಹೌದು.
Yes.
ಅವ್ರು ಡಿಫೆಂಡ್ ಮಾಡದೆ ಇವ್ರು ಹಿಂಗೆ, he is only stepping into their shoes. We can't hear him more than
What happened is, they did not challenge the order for last 30 years. 2003 I have purchased. Subsequently 2015 is the Lord.
5 to 7 dispense ಅಂತ ಹೇಳಿದ್ರೆ petition ಹೋಗುತ್ತೆ. Memo dated 20, another memo dated 27/1/25 is being filed seeking for dispensive notice to 5 to 7 who are the landlords on the ground that the property has been sold to respond number 14. The said memo is rejected. Counsel for the petitioner is directed to take notice to respond number 5 to 7.
And my lord, respond number 9 and 12, they have died. And
9, 11 and 12.
same, my lord, other kuda property is acquired, because they have taken.
Yeah, 9, 11 and 12 ಯಾರು?
9 and 11.
ಯಾರು?
They are also rival claimants. Rival claimants they are.
ಮತ್ತೆ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ. ನೀವು ಹಿಂಗೆ ಈ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಿಮ್ಮ petition ಹೋಗುತ್ತೆ.
Property itself is acquired, my lord.
But who is going to defend the rights?
They have taken amount and adukena claim.
No, what happened is, now the property is acquired. I am the purchaser in the, Lord, I have purchased the land in the year 2003.
From 9, 11 and 12 also.
Yes. Original owner. And Lord,
That
property.
is 5 and 6.
Yes,
9, 11 and 12.
they are rival 10. Their claims.
Compensation
Rival
ಯಾರಿಗೆ
claimants.
ಹೋಗ್ಬೇಕು?
ಅವರ ಓನರ್ ತಗೊಂಡಿದ್ದಾರೆ. Guys, I
What
want.
the entire property is.
Yes.
You have to take notice. If they contend otherwise, his rights will also go.
And without, in fact, hearing the original owners, Lord, it itself is, Lord, would not become Lord maintained.
Counsel for the petition seeks fund is granted 2 weeks time finally to make payment of necessary process fee and furnish copies in respect of the other unserved respondents. As also to file necessary application to bring the legal representative of deceased respondent number 9, 11 and 12 on record. If needful is not done by 14th, the petition will be liable to be dismissed for non-prosecution. Records bandidiya?
Records ಬಂದಿದೆ.
And AGA submitted the records are yet to be received. He seeks for and is granted 3 weeks' time to secure the same. Released on 19th February.
Please.
Akilva? None appears for the petitioner. Amended cost title has also not been filed, nor has the Vakalatnama filed in MSA 1000058 of 2015. If none were to appear for the petitioner in WP 100264 and the appellants in MSA 10058 of 2015 on the next date of hearing, the same would be liable to be dismissed for non-prosecution. Relist on 7th February. 2.1 ಏನಿದೆ? ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಕೋರ್ಟ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Please.
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
No, ma'am.
ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ.
Court notice agreement.
You'll appear
So I'll seek instruction and appear, my lords.
for the respondents.
Please, my lords. In the connected matter.
He so also submit that he would seek instructions as to whether he can appear for the respondents in MSA 1000058 of 2015. Release so and so.
May I request 4 days time to need.
My lords, one request, one submission, my lords. Lords, it appears that not respond number 17 arrayed in this petition is not party before land tribunal, my lords. I could not find her name in the impugned order, my lords.
That I will file a memo to regarding that clarification.
Counsel for the petition seeks for 4 days time to furnish process fee in respect to unserved respond number 17. And
Regarding
counsel for
compliance
respond number 12 to 15, submit that respond number 17 was not a party before the tribunal. Counsel for the petitioners seeks 4 days time to verify the same. Then in the IA 1.
That I will comply, my lord.
Ella petitioners ಇದೆ.
LR's application.
In compliance ಏನಿದೆ?
That
Copy service ಏನ್ ಬೇರೆನಾ?
If it is copy service, then my lords, he has already served.
delay days another mention.
Copy ಅಷ್ಟೇನಾ? IA 1 to 3 of 24 and 6 to 8. IA 1 to 3 of 24 has been filed to bring the legal representatives of deceased petition number 9 on record. Accepting the reasons stated in support of IA 1 of 24, the delay of applications ilva
ಇಲ್ಲ ಡಿಲೇ
ಬರ್ದಿಲ್ವಾ? ಅದು ಒಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರಬೇಕು. Counsel for the petitioner seeks for and is granted 4 days time to comply with the office objection raised on IA 1 of 24 to 8 of 24. Released on 6th. It is made clear that if process fee is not paid and or the compliance not made, the said application will be liable to be dismissed for non-prosecution.
Please.
Pass over.
Lord, Senior Counsel Mr. Nayak is online. Lord, amended petition, my lord, I have filed it on the very next day, my lord, 21st only I filed it.
Case, please, my lords. I am for the petition, please, my lords, in this case.
I can't stand.
Malas, this is a case arising under the ULC Act, please,
Just
my
a
lords.
moment, Mr. Nayak, just a moment. Ready?
Respondent, ma'am.
Ready na?
Please, my lords.
Yes. What is this, IA 1 for impleading?
Malas,
Lord, that has been.
I have filed,
Tried along with, heard along with the main.
Agidya order.
Agide, order.
Yes. Yes, Ms. Nayak.
please, my lords, the matter arises under the Urban Land Ceiling Act, please, Manoj. Plus, way back in the year 1981, please, Manoj, a notice came to be issued as per Annexure A to my grandfather Annappa, please, Manoj, saying that he holds excess lands. He, please, Manoj, being an illiterate person and a blind person, please, Manoj, had made an application for exemption of the land under the Urban Land Ceiling Act, not knowing the consequence of the enactment, please, Manoj. In respect of an agricultural land, he had made an application, please, Manoj. Pursuant to the same, please, Manoj, a notice came to be issued holding that he holds excess lands as per Annexure C, page number 31. He was called upon to surrender the lands as provided under section 510 of the Act, please, Manoj, and a notice came to be issued. Well, subsequently there too, please, Manoj.
Where is this land situate?
Well, in Dharwad, please, Manoj.
In the urban agglomeration.
Please.
No, not in the urban agglomeration, please, Manoj. It is an agricultural land exempted from.
Maybe an agricultural land. Is it in the urban agglomeration or outside the agglomeration?
Not in the urban agglomeration is my humble submission, please, Manoj.
Yes.
Well, subsequently there to after issuance of a notice, please, Manoj, the authority concerned had to take possession of the land in question, and it is the revenue inspector who has taken the land in question, please, Manoj, on page number 41. All along my contention was the revenue inspector is not an authorized officer to take possession of the land, plus it is the assistant commissioner or somebody else should take possession of the land who would be an authorized officer. There are umpteen number of judgments which have been produced by me along with the petition itself that revenue officer is not authorized to take possession of the land. Yes. On page number 41, the typed copy, the last 5 lines. ಮೇಲ್ಕಾಣಿಸಿದ ಎರಡೂ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಕ್ಷೇತ್ರವನ್ನು ಛಬ್ಬಿ ಭಾಗದ ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸಾಕೇಟ್ ರವರು ನಮ್ಮ ಸಮಕ್ಷ ಸರ್ಕಾರಿ ಕಬ್ಜಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿರುವರು. ಕಬ್ಜಾ ಕಾಲಕ್ಕೆ ಶ್ರೀ ಅಣ್ಣಪ್ಪ ಬಸಪ್ಪ ಬಾವಿಕಟ್ಟಿ ಇವರು ಸದರ ಜಮೀನದಲ್ಲಿ ಹಾಜರಿದ್ದನು ಅಂತ ಹೇಳಿ ಬರೆಸಿದ ಪಂಚಯಾದಸ್ತ. Malas, in support of my contention that the revenue inspector cannot take possession, please, Manoj, I have produced the judgment of His Lordship Justice B.S. Patil on page number 57. The fourth part, please, Manoj, the last 3 lines. The revenue inspector was not competent authority to take over possession. The same had no effect in law and in fact. The petitioners continue to enjoy the property to ascertain the same. This is in respect of some other property by some other petitioners, please, Manoj, only to buttress my arguments that revenue inspector is not the competent authority. I have produced this particular judgment, please, Manoj. Well, there is one of the judgments of this honorable court, please, Manoj.
Plenty of judgments, Mr. Naik, not necessary.
There are a number of judgments, please, Manoj. Well, on an earlier occasion, please, Manoj, in fact, I had approached this honorable court, saying that it is not an agricultural land and the revenue inspector had taken possession of the land. As such, please, Manoj, the order came to be passed subsequent to a remand by this honorable court on page number 125, please, Manoj. The earlier writ petitions have been extracted in the order on page number 127. The last paragraph in English. The petitioner Annappa Basappa Bavikatti has also filed OS number before the Additional Civil Judge Hubli against the state and the respondent number 3 ex-serviceman association for permanent injunction. The said suit by the petitioner has been dismissed, and on the other hand, the counterclaim of respondent number 3 has been decreed. It is submitted that said order was challenged by the petitioner by way of an appeal, and the appellate court has set aside the decree passed by the trial court and remitted the matter for fresh consideration. Learned counsel for the respondent at the time of arguments has produced a copy of the order passed by the civil judge on remission from this court. It is seen that the suit of the plaintiff for permanent injunction has been rejected on the ground that the petitioner is not in possession of the land in question, and on the other hand, respondent number 3 has been in possession of the land. From these proceedings, it is seen that the petitioner Annappa has not been in possession of the property. This clearly indicates that I have not been in possession according to the injunction order. Subsequently, there was one more please notice order by this honorable court saying that please notice, I have not marvelous that it is not an abated proceeding, please notice in the case of WP number 27920, which has also been reflected in this very order by
Page
this
number?
by the Malas, on page number 128, please notice.
No, that is the extract. Where is the order?
That is the exact page notice.
WP 41, writ appeal
No,
415.
27920 of 2000.
27920.
Please notice, this is the first credit petition wherein I approach this honorable court, Malas contending that the land in question is not an agricultural land, and after coming into force of the Malas Repeal Act, the proceedings came to be abated. That has been held against me, please notice. Well, shall I read the order, please notice?
So you have been held not to be in possession when the repealing act came into force.
Not to be in possession. That has been clear. This order has been affirmed by the division bench plus of this honorable court. Plus all along those the proceedings are plus are to the effect that whether it is an urban land act or not, please, whether the provisions of the Urban Land Ceiling Act are applicable or not have not been considered. And with regard to the issue, whether the position of the land has been taken by the competent authority has not been taken into account at all in respect of all other proceedings held earlier, please, plus ultimately I approach this honorable court where under please, the revenue entry is made pursuant to the earlier orders where a subject matter of challenge by me before this honorable court as per the writ petition order dated 12th February 2016 on page number 111.
101.
111 page.
111.
The operative portion of that particular order may kindly be looked into, please. Para 13. In view of the aforesaid reasons, the writ petition is allowed. The Deputy Commissioner is directed to consider the representation of the petitioner stated 5/11/2014 with reference to the document produced and the judgments relied upon by them and pass appropriately within a reasonable period of 3 months in accordance with law. Unless this order was not complied with by the Deputy Commissioner, I had to file a contempt petition. A direction came to be issued in the contempt petition, please note, that he shall consider. Pursuant to that, Annexure L came to pass by the Deputy Commissioner, rejecting my claim with regard to the position of the property and with regard to the issue raised by me that it is not an urban land, that the provisions of Urban Land Ceiling Act are not applicable. Well, subsequent to the passing of this particular order, I filed a review petition as per Annexure N, please note, the order came to pass. My grievance now is in respect of Annexure L and Annexure N. This Annexure N has been passed, please note, without hearing the parties in question. Annexure N, please note, on page number 130. ಸದರಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಿಂಬರವನ್ನು ಪ್ರಶ್ನಿಸಿ ಸಲ್ಲಿಸಲಾದ ರಿವ್ಯೂ ಅರ್ಜಿಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಅಂಶಗಳು ನಿರಸನಗೊಂಡು ಸದರಿ ಭೂ ಕಾಯ್ದೆ ನಂಬರ್ ಸೋ ಮತ್ತು ಸೋ ಸಂಬಂಧಿಸಲ್ಪಟ್ಟಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ರಿವ್ಯೂ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಲು ಕಾನೂನಡಿ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿ ಹೊಂದಿರುವುದಿಲ್ಲವೆಂದು ಸದರಿ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. Plus, there is no opportunity of hearing in respect of this particular review petition filed by me. If an opportunity was given, please note, there is a prejudice caused to me because there was no opportunity. I would have established before the authority concerned, please note, that the taking of position by the revenue inspector is not a procedure prescribed by law. And the
Are you
revenue
referring to 11, 12, 13 and 14?
11, 12, 13 and 14, please note. They are
Connected.
well, the reading of 11, 12, 13 and 14, please note, should go to establish that, please note. 11 is
Compensation. 12 is
compensation.
constitutional tribunal. 13 is second appeal.
Please note.
14 is mode of payment. How are they?
They are not relevant. They are not relevant in my humble submission.
Now in
And on an earlier occasion, please note, one more event that I want to bring to the notice of this court is Annappa, please note, when a compensation came to be awarded, he challenged that order of awarding compensation, saying that it is not an adequate compensation. Well, that order came, well, it
all
did not
that
reach the
would
final.
have to be considered in the revision, but in the revision, you're only challenging annexure N now.
Annexure N, please note, annexure L and annexure N, please note.
L and N.
L will be subject to the revision.
Yeah, subject to the revision.
So
Revision
L
is not heard on
is
merits.
already subject to the revision, which has been dismissed.
Yes, please.
What is in question is only the revision right now.
Yes, please.
Lord, statement of objection which has been filed by the state.
How are this provision of 11, 12, 13 and 14 relevant to reject the revision without hearing?
Lord, at the time of initially filing the writ petition, there were certain suppression of facts which has been made by the petitioners. Subsequently, the statement of objections having been made, they have sought for amendment of the petition and they have further clarified with regarding to whatever the fact that has been narrated. So, my lord, may I take it to the statement of objection at page 6, internal page number 3 of.
Even if there is suppression, it
Yes,
is the
my lord.
revisional authority
Since
which has to consider it.
that has to be.
But the revisional authority is dismissed on the basis saying that it doesn't come under 11, 12, 13 and 14.
But annexure ನನ್ನ ಕಡೆ ಇಲ್ಲ ಅದು annexure N is not
130.
ಅಲ್ಲ ಅದು ನನ್ನ ಕಡೆ ಇಲ್ಲ 127 is the last page which we had ಅಲ್ಲ annexure N ಇಲ್ಲ ಅದಕ್ಕೆ just ನಾವು
paper ಕೊಟ್ಟಿಲ್ಲ. The endorsement issued, it's not even an order.
Yes. ಭೂ ಮಾಲೀಕರ ಪರಿಗಣಿಸಲು ನಿಯಮಗಳಿಗೆ ಅವಕಾಶವಿಲ್ಲದ ಕಾರಣ ನೀಡಿ ರಿವ್ಯೂ ಅರ್ಜಿಯನ್ನು ಪ್ರಸ್ತುತ he has to pass an order ಮಾಡಿಲ್ಲ
11, 12, 13, 14 are completely irrelevant.
Irrelevant. It pertains only to section 10 ಅಂತ ಅಷ್ಟೇ ಆಗಬೇಕಿತ್ತು 11, 12 and 13 may not ಅಲ್ಲ but insofar as annexure L is concerned, my lord,
L will be subject to the revision.
ಹೌದು but in the revision, my lord, he has
is passed on merits, then we'll have to consider
yes,
that.
yes, yes.
Not now.
Now yes, unless and until that has to be decided on merit. Allah, if simply, my lord, that endorsement shall be caused and it had been remitted and that can be adjudicated as stay.
But with so much of litigation, will you do it properly?
Litigations bala idave.
ಇಷ್ಟೆಲ್ಲ ಇದೆ ನಾನೇನು ಮಾಡೋದು ಬೇಡ ಒಂದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಬಿಡೋಣ ಅಂತ.
That is the wrong which has been committed by the authority while passing this, issuing this endorsement. Limited ground ಮೇಲೆ it if
Grantee of that land.
ex-servicemen association has been granted to them and they are utilizing the possession of the property since
Possession
1980.
of that land, it has been granted to the ex-service.
You can agitate it before. This is a wrong order.
Yes, that order is wrong. It can be.
You can't consider your when the order is palpably wrong.
Allah, that is totally wrong, man. That is totally wrong.
Petitioner is before this court seeking for the following release. Though several grounds have been urged, as also arguments advanced before this court by Sri Ravi Binayak and senior advocate. What is under challenge essentially is Annexure N, the order passed by respond number 1 in the revision petition filed by the petitioner, which before being numbered has been rejected with the endorsement that the same does not come within the purview of section 11, 12, 13 and 14 of the Urban Land Sealing and Regulation Act 1976. The revision petition, suffice it to say, was filed challenging in respect of Annex L being an endorsement dated 13/9/2017, rejecting the representation of the petitioner that the land of the petitioner, being agricultural land, would not come within the purview of the Act of 1976, and that the revenue inspector did not have the power to take possession of the same. Instead of answering those allegations and contentions that the order at Annex L is not passed in accordance with law, by way of Annex N, respond number 1 has issued an endorsement that the same is not coming within the purview of section 11, 12, 13 and 14. Section 11 deals with payment of compensation for vacant land acquired under the Act of 1976. 12 speaks of the constitution of the Urban Land Tribunal and appeal to the Urban Land Tribunal. 13 speaks of second appeal to the High Court, and 14 speaks of mode of payment of amount. None of those provisions would be relevant for the purpose of considering the revision petition filed by the petitioner. In that view of the matter, I am of the considered opinion that the order passed by the first respondent on 16/2/2018 at Annex N is not in accordance with law, and the revision petition has not been considered on merits and in accordance with law. As such, I pass the following order. Writ petition is allowed. A certiorari is issued. The endorsement order dated 16/2/2018, so and so, passed by respondent number 1 at Annex N is quashed. Matter is remitted to the first respondent for fresh consideration after providing necessary opportunity of hearing to the petitioner and the impleading applicant who has sought to come on record in the present proceedings. Both the petitioner and the impleading applicant are permitted to produce such documents that they wish to rely upon before the revisional authority, which shall be considered by the revisional authority in accordance on merits in accordance with law. 3 weeks' time is granted to the petitioner and the impleading applicant to submit those documents, which shall be submitted on or before 17th February. The revisional authority shall fix a date for hearing, hear the petitioner and the impleading applicant and pass necessary orders within 60 days thereafter.
Highly ordered.
Impleading application, my lord.
Impleading application
Lord,
is
since
permitted.
my lord, they may not be the parties before the court. They have to file application as
By the daily order of the world. Accepting the reasons stated in support of IA1 of 23, the impleading applicant, along with the main ಅಂತ ಹೇಳಿದಾರಲ್ಲ, daily order ಬೇಡ, main order ಅಲ್ಲಿ first ಅಲ್ಲೇ petitioner is before this court seeking for following relief. An impleading application has been filed by an association contending that the land subject matter of the above petition has been granted to the association.
We are in possession of that.
And they are in possession of the property without adverting to the veracity of those averments, considering that any order passed in the present matter would have an impact on, would affect the impleading applicant and its members. IA1 of 23 is allowed counsel for the petitioner to carry out necessary amendment and file amended cause title. Amilad.
Please.
Please.
In view of urgency, my lord.
IA1 of 25 allowed. Ready na? Ready?
They are seeking urgency on the ground of not a contempt petition is pending. Contempt petition.
Urgency now, it's 2020. Are you ready?
Since 2021, the respondent is working pursuant to the order passed by this honorable court. And
are you ready to address arguments on merit?
One date may be fixed on that date.
Lord, on submission, my lord. It's very urgency. In the 29th, my lord, as per the interim order, we have filed a writ appeal. That writ appeal has been dismissed as withdrawn to the, there is no intra-court appeal has been entertained in the labor court matter. That has been withdrawn. And now the contempt is pending, my lord. How they are,
When is the contempt listed?
or not, 29th, my lord.
29th, my lord. My lord, the contempt petition pending since for the last 2 years, my lord. My lord.
You make a submission that this is being taken up.
Please.
IA 1 of 25 is allowed, relist on 29th for hearing.
Please.
It's made clear that no further adjournment would be granted.
This case, I filed the applications for the
Yavak file madam.
day before yesterday, madam.
Bandidya?
Seeking permission to bring the LRs of the murder.
Bandidya? Pass over.
Please.
I will furnish the fresh notice to the respondent number 3, my lord. The consignment not available in the file.
First one R3, second one 8 telling. Counsel for the petition seeks for and is granted 3 days time to make payment of necessary process fee and furnish copies in respect of unserved respondent number 3. If needful is done by 31st, registry is directed to issue notice to unserved respondent number 3 returnable by 3rd April. If needful is not done by 31st, relist on 6th for dismissal. 8.1 R2 and R3.
Interim order may kindly be.
Interim order in both the above matters is extended till next date.
Okay.
Same process fee and copies. R2 will.
My lords, seeking for short adjournment to comply the office objections.
K. Kapoor has entered appearance for the petitioner. Hence, memo of retirement filed by Shri M.C. Ukeri is accepted. He is discharged from the matter. Registry is directed to delete his name as that appearing for the petitioner. Notice issued to respondent number 7 to 10 and 12 has been returned with the endorsement refused. Service in regard to them is accepted as sufficient. Registry is directed to print the name of respondent number 7, 8, 9, 10 and 12 in the cause list with the endorsement refused. Counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application to bring the legal representative of deceased respondent number 6 on record, as also to make payment of necessary process fee and furnish copies in respect of the others unserved respondents and to comply with the office objection. If needful is not done by 14th, relist on 19th for dismissal. 25.
Lord, I appear on behalf of the respondent. R25 is the co-defendant number 2. The present application petitioner is defendant number 1. Lord, we have already filed a memo for having pursuant to the direction issued by this for having served a copy to the counsels who appeared before the court.
Dispensation.
Yes, Lord, I will file memo.
Counsel for the petitioner has filed a memo seeking for dispensation notice to respondent number 25 on the ground that respondent number 25 is a co-defendant. Accepting the said memo and the submission of counsel for the petitioner, notice to respondent number 25 is dispensed with at the sole risk, cost and peril of the petitioner. Where is Mr. Zirali? None appears for the respondents. Relist on 7th February to enable the respondents to be represented. If none were to appear for the respondents on that date of hearing, the matter will be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Please.
Interim order, Idya? Interim order earlier granted is extended till next date. Counsel for the petitioner, none appears for the petitioner. The petitioner is granted a week's time to make payment of necessary process fee in respect of respondent number 1, 2 and 6. If needful is done by 3rd, registry is directed to issue notice to respondent number 1, 2 and 6 returnable by 4th April. If needful is not done by 3rd February, relist on 11th February for dismissal.
That's IAP. In this case, but insofar as respondent number 3 is concerned, I may be permitted to take hand summons. Since counsel is not here, the standing counsels are not there, so I may be permitted to take out hand summons in respect of R3.
What about R1?
My lords, R1 and my lords, the family, my lords, which belongs to my lords, one Nidgundi, is my lords represented by my lords Harsh Desai in other writ petition, which is connected. But I'll just verify my lord, whether he is going to appear. Because in the earlier,
If he is already appearing, we'll direct him
yes,
to
yes,
appear.
yes. His
Doesn't
name is
mean-
Appearing for respondent 5.
Then you appear for 1A to C.
yes, one family. That is all belongs to Nidgundi.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದಾರೆ ಇದರಲ್ಲಿ.
He is appearing for Mainuddin.
For respondent 5, my lord.
Who is respondent number?
Illa, in connected matter, my lords, he is appearing.
Family is different
R5.
from the party.
Party name, please. That is
ಇನ್ನೊಂದು ಕೊಡಿ.
Mainuddin Hafiz Abdul Karim, son of Modin Sahib.
ಮೊಹಮ್ಮದ್ ಅಮೀನಾ ಬಿ. ಇನ್ನೊಂದು ಕೊಡಿ. ಮೈನುದ್ದೀನ್ ಹಫೀಜ್ ಅಬ್ದುಲ್ ಕರೀಂ ಅವರೆಲ್ಲ ಇಲ್ವಲ್ಲ ಬಶೀರುದ್ದೀನ್ ಅಹಮದ್ ಇದು.
Bashir Ahmad is, he died. His legal representative there on the record.
Where is respondent number 5 here? Respondent number 5 is respondent number 2. He can appear only for respondent number 2.
One, that is my instruction is Bashir Ahmad and Mainuddin are brothers.
So,
and Bashir Ahmad is died.
We'll ask your brother to appear in this matter.
ಇಲ್ಲ ಅದರಲ್ಲಿ only Bashir Ahmad ಅವ್ರ ಮಕ್ಕಳಿಲ್ಲ. Only in so far as Bashir Ahmad
ಆಗ್ಬೇಕ್ರಿ. ನೀವು process fee ಕೊಡಲ್ಲ ಅಂದ್ರೆ
ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. I have paid the process also.
Furnishing ಅಂತಿದೆ.
Acknowledgement is not yet received ಅಂತಿದೆ.
Furnishing.
Acknowledgement is not yet received in so far as the LRs are concerned. I'll take I'll furnish today.
ನೋಡಿ.
I'll furnish today.
Sri Harsh Desai, who appears for respondent number 5 in 12.1, accepts notice for respondent number 2 in 12. Who is the same party?
I'll take fresh.
Counsel for the petitioner seeks for and is granted 1 week's time to make payment of necessary process fee in respect of respondent number 1A to 1C and respondent number 1E, as also respondent number 3. If needful is done by 3rd February, issue notice to the said respondent written by 4th April. If needful is not done by 3rd February, released on 12th February for dismissal.
Please.
Accepting the reasons stated in support of IA 1 of 24, the production certified copy of Annexure A is dispensed with. 12.1, Mr. Gangadhar.
Name should be deleted. His name should be deleted.
Sharan Basaraj appear ಆಗ್ತಾರಾ?
Yes.
12.1, registry is right, delete the name of Sri Gangadhar JM as that appearing for the petitioner. 12 ಅಲ್ಲೂ Gangadhar JM delete ಮಾಡಿ. 12.1, counsel for the petitioner seeks for and is granted 2 weeks time, 10 days time, 2017, 10 days time to file necessary application. R4 is the same as R1C, na?
ಹೌದು.
Bashir Ahmad. Yes. So one application, same application is the ಹಾಕ್ಬೇಕು.
ಖಂಡಿತ.
Weeks time to file necessary application, bring the legal representative to deceased respondent number 4, who is respondent number 1 in 12. If necessary application is not filed by 3rd, relist on 12th for dismissal.
Right.
Counsel for the petitioner seeks for and is granted 1 week's time finally to comply with the office objection. If not complied by 3rd, released on 6th for dismissal. Who is the impleading applicant?
I have filed, my lord. Impleading application, I have filed, my lord.
Appealing for whom in this matter, Mr.?
Lord, for the proposed respond number 8 to 11, my lord. Respond number 8 to 11 and respond number 6 to 7 in the writ petition, they are brothers and sisters, my lord. The respondent number 6 and 7, my lord, they created certain unregistered partition deed, my lord.
Any objection?
My lord, I am for petitioner. The petition is against the impugned order of the deputy commissioner. He has cancelled the NA order given by himself.
They claim an interest in the property.
Without, they are not at all concerned, your lordship.
Partition ಆಗಿದೆಯಾ?
My lord, there was no registered partition my lord, and they denied the share. Therefore, OS number
Bas.
28 of 2020 was instituted, my lord. That I have produced along with my impleading application at page number 6, my lord. 6.
And which came to be decreed.
Yes, my lord. And
And you are entitled to 1/10.
yes, daughters are entitled for 110 shares.
Has
Sons
that been
to-
challenged?
No, my lord. This has attained finality, my lord. Yes, ma'am. And my lord, suppressing all these shares, my lord, belonging to the other two brothers and sisters, this NA conversion order was passed. Therefore, this very response number 8 to 11, they submitted an application to the deputy commissioner to cancel the NA conversion order
You
obtained.
don't want the NAC. You submitted the application.
We submit because we are omitted there. Only
That basis it was cancelled.
it is cancelled, which is impugned, and petitioners have no right title interest in respect of these two agriculture lands belong.
ಆಗಿದೆಯಲ್ಲ, Mr.
My lord,
Jetty?
deputy commissioner has no power to
That
withdraw.
will consider.
It becomes.
But if all the owners are not there, and if the owners object to the conversion, then the deputy
Lord, he
commissioner
would-
can, it's fraud.
He should have
Except on
objected.
fraud.
He should have objected at the time of the permission, my
How
lord.
did you file it without their consent? Who are you to file?
No, my lord, myself,
Page number, my lord, 50, my lord, 54 may be referring to, my lord. Page number 54, it is approved, my lord, layout plan.
it has been approved, my lord.
Approved, 54, my lord. There are, my lord, below 147, my lord, your lordship kindly, that is below, my lord, the upper portion is the layout plan of the, my lord, petitioner.
Yes.
Below, my lord, it was the approved plan of the approved layout plan of the, my lord, the respondents. Now at the time of granting, my lord, approval, it was there, my lord. Now therefore, my lord, the lines, my lord, here, these are the per roads it has been given up to, my lord, the money up to this, my lord, main road, it was, my lord, granted. Now they are saying that, my lord, it is not in our, there is a dispute between us. Therefore, my lord, I don't want to, my lord, conversion order may be
No,
cancelled.
they also applied for conversion.
Yes, ಅವರು ಮಾಡಿದ್ರು ಇವ್ರು ಮಾಡಿದ್ರು.
ಇಬ್ರು ಮಾಡಿದ್ರಾ?
ಹೌದು, ಅವ್ರಿಗೆ ಕೊಟ್ಟರು. Only based on this, my lord, their approval plan, it has plan layout, my lord, road has been formed up to this. By virtue of cancelling
Where
this.
is the application submitted by the impleading applicants?
Please, my lord.
ನೀವು ಅಥಾರಿಟಿಗಾ?
ನಾ authority, my lord.
ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ ಕಾಪಿ?
Our application, my lord, it has not been, my lord, ನಮ್ application.
We have not moved any.
application.
ಅಲ್ಲ, earlier ಅಂದ್ರೆ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು impleading applicants ಅಲ್ಲ, ಅವ್ರು, my lord, ನಾವು the respond number 6 and 7 ಕೊಟ್ಟಿದ್ದು.
6 and 7 alone moved, my lord.
7.
ಅವ್ರು they are the, my lord, owners. Now they are impleading
Now
applicants
these
are
people
saying
are
that
claiming.
they are the sisters, therefore they have got, my lord, a share in that property.
Now they were respondent 8 to 9.
My lord.
8 to 11.
8 to 11.
had filed a suit in OS number 28.
Yes, my lord. Page number 6,
That
my lord.
suit has been decreed.
Decreed, my lord.
They have been held to have a right.
Prior to that, my lord, it
Prior
has
to
been,
that
my lord,
only
granted.
this has happened. Now there
Prior
is.
to it.
Prior to that, if it has been granted also, the declaration that they have a right will go back to what date?
In fact,
So far as, my lord, their approval has been done based on the, my lord, roads was were existing. Since they have got the approval, their approval plan, in that, my lord, approval plan, there was already roads are existing. Now by virtue of cancelling this, my lord, they sought for cancellation of the, my lord, NA conversion. By virtue of that layout has no road at all.
No,
there is a
and the
layout will also not exist
ಅಲ್ಲ,
if the conversion goes.
ಅದು
You layout has no road alla, layout ಹೋಗುತ್ತೆ.
myself, so far as this is the facts that only I have brought it.
Correct. But now that layout could also not have been formed
already
without their interest. There's a decree which has not been challenged by
yes,
you.
my lord. In fact, respond number 6 and 7 are different number 1 and 2 in the
these
suit.
people must have gone before the deputy commissioner.
They have suppressed, my lord.
regarding- No,
Why
total
should they have
concealment.
kept
Silent, your
Deputy
lord.
commissioner is going to give partition.
No, my lord, they have kept silent at that time while the DC has permitted us.
ಅವ್ರಿಗೆ ಹೇಳಿದ್ರ ನಾವು ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ನೋಡಿ ಅಬ್ಜೆಕ್ಟ್
Nothing,
ಮಾಡಂಗಿದ್ರೆ
they
ಮಾಡಿ
have
ಅಂತ.
not come before the authorities.
Now there is a decree
After a
which has
long
been
gap, now these people have approached this, that too, we have approached.
failed in the suit, Mr. Jetty.
Yes.
You have failed in the suit. A decree has been passed against you. It has attained finality. You have not challenged it.
But at the permission of the, any order was passed, accordingly we have formed the layouts.
ನಿಮ್ದು agriculture land ಇದೆಯಾ? You own. We'll ask Mr. Kannur to file an application for conversion and Mr. Mandgani will convert it. And Mr. Rangdi will sell it. ಆಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು cannot be cancel
Already
ಮಾಡಿ
buildings have come, your lordship. Already buildings have come.
But they have a share in that too.
How they have to go approach the main road, your lordship.
FDP file ಮಾಡಿದೀರಾ?
This is only for the roads, your lordship. Nothing more than that.
My lord,
We are not claiming their property, nothing more than that.
that my lord,
are
have to
claiming
seek
only
instructions,
roads.
my lord, because this.
For that, these people are.
If there are
This was
third-party
decree-
interests which have been created,
No, my lord,
up construction.
no, my lord, I am instructed that no further subdivision has taken place, no construction has taken
The
place.
photographs ತೋರಿಸಿ.
Photographs is there.
Then you work out your remedy in the FDP proceedings.
My lord, here, my lord, the two petitioners, my lord, their land is totally different, my lord. They are not concerned with the suit properties in OS number 28 of 2020. My humble submission, the petitioners who are challenging the order of cancellation of the earlier NA conversion order, their land is totally different, my lord. They don't have any right title interest in the two survey number agriculture lands involved in OS number 28 of 2020. They don't have any locus at all, my lord. They are not the owners of these two suit schedule properties.
There's a suit for partial partition.
No, not there are two agriculture lands and two house properties, and after the original owner died, there is proposed respond number 8 to 11 and respond number 6 to 7 in the.
Only your claim as regards item number 3 and 4 is dismissed. 1 and 12 you have.
Yes, my lord. One and 2 are the.
This property is item number what?
One, my lord, item, the two agriculture lands are survey number 220D bar 2A, 220D bar 2B. Whereas the property belonging to the petitioners, it is 220D bar 1. It is totally different, my lord. Petitioners have no share or they are different persons.
No.
This layout has been formed in.
My lord, kindly see page number 55, my lord. We have produced the photographs.
Petitioners are not at all concerned with the two survey numbers in 220 D2A and D2B.
Item number 1 and 2 were 220 D2A, 220 D2B.
Yes, ma'am. They are the suit schedule properties in OS number 28 of 2020.
So the petitioners were also parties to the suit?
In this suit, they are not parties because they are not the sharers. They own, my lord, the survey number 220D bar 1. They are not at all concerned with. In fact, they have no locus to question the order of cancellation. In fact, it is at an application moved by the proposed respond number 8 to 11 to the deputy commissioner by suppressing, by creating the unregistered partition deed, mutation got effected, and only the names of respond number 6 and 7 came to be entered. And these the respond number 6 and 7 who are different number 1 and 2 in the suit, my lord, they have not taken any such defense at all. They just say that they made certain improvements, but.
My lord, kindly see page number 55.
One nimsham. Chinna Sahab Satyamma. Where is the impugned order?
95, my lord.
Okay.
Page number 95.
95.
I have produced the certified copy also, my lord. On 14/2.
You are the owner of the land in 220D1.
Yes, my lord.
That has not been cancelled.
That has not been cancelled.
Only
Only
220D2A.
the land belonging to respondent 6 and 7
has been cancelled.
Because of that cancellation, we have been affected. When the
Because you don't have
permission was
access.
granted prior date, on prior date, how can it be cancelled, my lord? And there is no access to us to main road, my lord.
No, my lord. There is
Because
a
already
roads are
buildings have been come, gardens have been formed. It is very visible in the map itself, my lord. Map is in page number 55, my lord.
ಇದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಈ ಪ್ಲಾನ್ ಅಲ್ಲಿ. ಆ ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲಿ ಬರುತ್ತೆ?
Annex D1 ಅಲ್ಲಿ
D1.
page number 54 ಮೇಲೆ. D1. Yes, right side top ಮೇಲೆ. 220 D1 ಅನುಮೋದನೆ ವಿನ್ಯಾಸ T20 D1 and next minute last one 3 column ನಲ್ಲಿ third column ಅನುಮೋದನೆ ವಿನ್ಯಾಸ number D20/D2.
We'll have to allow the impleading application.
Yes, my lord.
Impleading application we'll have to allow. Then we'll have to deal with these issues. Because you are a third party to the family. You are not a family member.
Yes, my lord. But we have all together have applied for the non-agriculture.
ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. You chose the wrong friends.
But there is it seems there is a collusion, my lord, but
incorrect
I need not say that collusion between themselves, because these people should have gone before the deputy commissioner. They have objected. They have not done that.
Who are you appearing for?
When they had interest.
6 and 7.
What is your stand?
There are roads existing alternate, my lord.
Alternate.
Yes, ma'am.
What do you have to say about the conversion?
Conversion, my lord, there are the co-person among the impleading applicant and the 6th and 7th response, my lord. And subsequently they approach the civil court, my lord. And thereafter, ultimately with the advice of the elders, they have given the representation to the deputy commissioner, and it is not developed, my lord. And ultimately, deputy commissioner, after issuing notice to both the parties, he has set aside the order, my lord.
So you support the impugned order?
Yes, my lord. And moreover, my lord, he is not agreed person, my lord. I have filed a survey map, my lord. There are alternative roads, my lord, as per the city survey, my lord.
Why did you file the application with him jointly for conversion?
No, my lord. There is no question of filing a joint application.
Application joint ಇದಲ್ಲ. Petition and respond 5 and 6.
He cannot say that jointly filed, my lord. He may be filed separately, and the 6th respondent and 7th respondent is filed separately, my lord.
Joint application or separate application?
Separate applications.
Separate, of course, separate applications were there, but whatever he is saying that it is Gudda Sutti Mailar Pandrantre on proverb is sir.
Access that
is not the correct.
There are access, my lord. 3 sides there is access, my lord.
He is misguiding the court.
I filed the survey map, my lord.
I will show the map itself.
2024, my lord.
The conversion has happened, plan has been sanctioned,
Yes, my lord.
and you have assessed all these plots for,
First.
you work out in your FDP proceedings.
My lord, insofar as the lands of the, this proposed respondent number 8 to 11 and.
Fact that you are getting so much support from respondent number 6.
No, my lord, in fact,
ಅವ್ರು ಈಗ ಬಂದಿದಾರ. They are filed
we have submitted independently application.
ಅದಕ್ಕೆ ಅವ್ನು ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ.
No, my lord.
ನೀವು ಬಂದಿದ್ರೆ ಏನು ಆಗಲ್ಲ, ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಏನಾದ್ರು ಆಗ್ಬಹುದು ಅಂತ ಬಂದಿದ್ದೀರಾ?
No, my lord. Good, my lord. There is an.
ಇಷ್ಟು ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇರೋದು ನೋಡಿ ನಾವು ವಿಲ್ ಬಿ ಮೇಕಿಂಗ್ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಆಲ್ಸೋ. It's clearly categorical that you are colluding with each other.
ಇಲ್ಲ.
My lord,
Just on the
only
basis of
that
facts,
that
I am arguing the matter.
You should have
Not supporting
the fact that you are not supporting your conversion and the plan sanction, and you are now supporting the impleading applicant is clear.
His application may be dismissed, my lord. There is no problem.
ಇವಾಗ ಇದೆಲ್ಲ ಹೇಳಿದ್ಮೇಲೆ ಇಷ್ಟೊತ್ತವರೆಗೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನ್ ಇರೋದು ನಿಮ್ದು?
ಅಲ್ಲ, I am.
You are clearly colluding. You work out in your final decree proceedings. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of the land in survey number 220D1, measuring to an extent of 1 acre 10 gunta, situated at HB Halli, to the southern side of the said land. Respondent number 6 and 7 claim to be the owners of survey number 220 stroke D2 capital A, capital D2 capital A, measuring to an extent of 00-60 acres, and D2B measuring 220 D2B measuring 63 acres, 00-63 acres, and 224 capital B stroke 1 measuring 00-87 acres. The petitioner and respondent number 6 and 7 by way of separate applications to the Deputy Commissioner sought for conversion of the aforesaid land from agriculture to non-agriculture purposes, which was allowed vide orders dated 23/11/2015, 3/11/2014, and 3/3/2016 and 30/10/2019 at Annexure B series. In terms of the conversion granted, the petitioner and respondent number 6 and 7 applied for and obtained plan sanctions. The manner in which the plan sanctions were obtained were, in fact, by treating the entire lands of the petitioner and respondent number 6 to 7 to be one single composite unit with roads leading from one property to the other property, which have been described in the petition as link roads, leading up to the Tumbralli to Agribomanalli road, thereby providing access to the petitioner. The petitioner claims that the petitioner has implemented the plan sanction, formed the sites and sold it to third parties who have purchased the same and put up constructions thereon. While things stood thus, the impleading applicants in IA number
1 of 2024.
1 of 24 had filed a suit in OS number 127 of 2022.
Well, it's 28 of 2020.
128
Annexure R1, page 6, my lord.
Is 127 ಏನಿದೆ?
That is another suit filed by petitioners.
Filed OS number 28 of 2020 seeking for partition and separate possession against respondent number 6 and 7, which came to be decreed on 30th January 2023. In terms thereof, the impleading applicants and respond number 6 and 7 were each declared to have 2/10 share.
So far as sons are concerned, my lord.
The plaintiffs and number 4 and 5 therein, that is proposed respond number 11 and 12, were declared to be entitled to 1/10 share in item number 1 and 2 of the suit schedule B properties therein. And the plaintiffs 2 and 3 and defendant number 1 and 2 each were declared to be entitled to 2/10 share over item number 1 and 2 of the suit schedule properties. Item number 1 of the suit schedule therein
that is survey number 2.
Suit schedule B therein is survey number 220D2A measuring 0.60 acres, and item number 2 is survey number 220D2B measuring 0.63 acres, which was the subject matter of the application for conversion filed by respond number 6 and 7 as detailed above. On the said suit being decreed, the decree having attained finality, since respond number 6 and 7 did not challenge the said decree, the proposed respondents submitted an application to respond number 1 seeking for cancellation of the conversion granted on the ground that they had not consented to or acceded to the conversion, and as such the conversion order cannot bind them. The respond number 1 accepting the said statement, while it is ordered dated 3/6/2023 at annexure K, allowed the same and set aside the conversion in respect of the property bearing number 220D2A and survey number 220D2B. It is challenging the same. The petitioners are before this court seeking for the aforesaid relief. Shri S.M. Jetty, learned counsel for the petitioner, would submit that in terms of the conversion order of survey number 220D1 belonging to the petitioner and survey number 220D2A and 220D2B belonging to respond number 6 and 7, as also the impleading applicants, a layout has been formed after obtaining necessary permission. Sites having informed if the conversion in respect of survey number 220D2A and survey number 220D2B is cancelled, the conversion order in respect of survey number 220D1 belonging to the petitioner would be adversely affected. The access to the said property as per the layout plan sanction will be negated, depriving the petitioner of such access. Lastly, he submits that the suit is a collusive one filed by respond number 6 and 7 and the impleading applicants to deprive access to the land of the petitioner and to extort monies from the petitioner. He therefore submits that respond number 1, having granted conversion order, does not have revisional powers and has been rendered, he having been rendered functus officio after passing of the conversion order, could not review his own order, review his own administrative order, and cancel the conversion on the basis of the submission application filed by the impleading applicants in collusion with respond number 6 and 7. He therefore submits that the impugned order is required to be quashed. Shri M.M. Patil, Learned Counsel for Respondent 6 to 7, supports the order of the Deputy Commissioner and submits that the Deputy Commissioner, having taken into consideration that the impeding applicant's rights had not been taken into consideration when the conversion order was passed, has now taken the same into consideration in terms of decree passed in OS number 28 of 2020 and has cancelled the conversion order, which cannot be found fault with. His submission is that the conversion order of the petitioner and the conversion order obtained by respondent number 6 and 7 are distinct independent orders, and the conversion orders in respect of lines of respondent number 6 and 7 being cancelled, it does not give any right to the petitioner to challenge the same. Shri C.V. Angvi, Learned Counsel, appearing for proposed respondent number 8 to 11, who are the plaintiffs in OS number 28 of 2020, contends that the conversion having been obtained without the consent of the impeding applicants is non-est. The land originally belonging to one
Ibrahim Saab.
Ibrahim Saab,
After
who is
demise,
the father of the impeding applicants, who are plaintiffs in OS number 28 of 2020, and respondent number 6 and 7, who are defendants in the said suit. The trial court has come to a conclusion that the impeding applicants and respondent number 6 and 7 were tenants in common.
Yes.
Thus, the impeding applicants always having a right, title, and interest over the property. Without their consent, no application could have been filed for conversion, and a conversion order obtained behind the back of the impeding applicants is non-est and cannot be binding on the impeding applicants.
One more submission. Further, it's a specific case of these impeding applicants in the suit, my lord, which is observed in para 2 of the judgment, that unregistered partition deed was created, showing that the property is allotted to the respondent number 6 and 7, on the basis of which mutation entry bearing number 33 of
his further submission is that
was caused.
False and fabricated documents have been created by respondent number 6 and 7. Depriving the impeding applicants of their right, title, and interest in the property. And on that ground, he submits that the conversion order has been rightly cancelled by the first respondent deputy commissioner, and the release which have been sought for by the petitioner cannot be granted. Heard so and so peruse papers. The facts, as aforesaid, are not in dispute. The ownership of the lands in survey number 220 D1 of that of the petitioner is not in dispute. The ownership of land in respect of 220 D2A and 220 D2B being that of late Ibrahim Saab is not in dispute. Respondent number 6 and 7 had applied for and obtained conversion of the aforesaid land without the consent of the impeding applicants. Which led to the impeding applicants filing the aforesaid suit in OS number 28 of 2020, which came to be decreed. The suit was filed in the year 2020, where the conversion orders were obtained on 23/11/2015, 3/11/2014, 3/3/2016, and 30/10/2019, in pursuance of which a layout approval was also obtained on 31/5/2016, 31/7/2020, 31/5/2016, and 30/7/2016, in furtherance of which the petitioner claims that he has developed the layout in his property. So also there's a development of a layout by respondent number 6 and 7. However, in order to deprive the petitioner of access to the main road through the lands of the petitioner in terms of the layout plan sanction, a collusive suit has been filed and a decree obtained. This aspect is what would have to be considered by this court on the basis of the submission and the pleadings which have been filed. A perusal of the decree in OS number 28 of 2020 would indicate there being no contest by respondent number 6 and 7, inasmuch as on a suit having been filed by the impleading applicants, the respondent did not lead any cogent evidence, did not place on record any evidence as regards the layout approval, the conversion order, and the like, which are undisputed to have taken place in the year 2015 and 16. If at all, the respondent 6 and 7 were not colluding with the impleading applicants who were the plaintiff in the said suit, it was required of respondent number 6 and 7 to have placed these details on record. Except for bare denial, except for taking up a bald contention that a layout had been formed, no documents had been produced by respondent number 6 and 7, which came to be observed by the trial court. At para 10 of the judgment. And it is on the basis of such non-production that the trial court came to a conclusion that there was no layout formed and or sites were not sold to third parties. It is that fact which resulted in the trial court passing the said judgment. If at all the trial court had been brought to, if it had been brought to the notice of the trial court that the conversion had occurred, if at all it had been brought to the notice of the trial court that in pursuance of the conversion, a layout had been formed, and that the said layout plan was in conjunction with the layout plan of survey number 220 D1 belonging to the petitioner, in my considered opinion, it would be unlikely for the trial court to have passed the said judgment as regards item number 1 and 2 in totality, but the trial court would have considered the layout plan and granted the relief sought for in respect to the sites which have been formed. The roads which have been formed in the land in survey number 220 D1, D2A, 220 D2B have already been surrendered and relinquished in favor of respondent number 5. And those sites, including those civic amenities, roads, etc., are now belonging to respondent number 5 and thus to the general public. The benefit of the conversion order, once a land is converted from agriculture to non-agriculture purpose by the deputy commissioner, the deputy commissioner is rendered functus officio as held by this court in
WP number 387/2023.
Third. First judgmentally, as held by this court way back on 14 November 2013 in WP number 2456/34 of 2013, when this court has declared the deputy commissioner to be functus officio after the exercise of powers under section 95 of the act converting the land from agriculture to non-agriculture purposes, and has further held that there can be no review of the administrative action unless specifically provided in the statute. The statute not providing for the same, the deputy commissioner could not have, on the basis of an application submitted by the impleading applicants, review the order of conversion and cancel the same. The said judgment in Ratna's case has been subsequently applied in several cases and has been approved by the division bench of this court wide order dated 23rd November 2023 in WA number 387 of 2023. That being the case, the first respondent deputy commissioner ought to have been aware of the said order and rejected the contention of the impleading applicants seeking for cancellation of the conversion order. Be that as it may, the conversion of the land from agriculture to non-agriculture purposes would inure to the benefit of all the family members. In this case, even if there is no collusion between the impleading applicants and respondent number 6 and 7, the conversion order granted by the deputy commissioner only enhances the value of the land and as such the rights of the parties. It is only in the remaining land that they can claim their interest in the as declared by the trial court. As however observed above, in the present matter, I have come to a conclusion, categorical conclusion, that there is collusion between the impleading applicants and respondent number 6 and 7. And it is respondent number 6 and 7 who did not contest the said suit and who are now supporting the order of the deputy commissioner passed on the basis of an application filed by the impleading applicants, which, as aforesaid, being collusive, the impleading applicants cannot take advantage of such a collusive judgment passed in OS number 28 of 2020 to the detriment not only of the petitioner but of respondent number 5 and the general public, who are now vested with the right to make use of the roads which have been surrendered / relinquished to the respondent number 5 authority. In that view of the matter, I pass the following order. The impleading application in IA number 1 of 2024 stands rejected. A certiorari is issued. The impugned order dated 30/6/2023 bearing number so and so passed by respondent number 1 at annexure K is hereby quashed. The conversion orders dated 8/9/2014, 17/11/2015 and 6/2/2014 at annexure B series and the layout approval at annexure dated 31/5/2016, 31/7/2020, 31/5/2016 and 37/2016 at annexure C series are declared to be valid and subsisting. Rights, if any, of the petitioners, of the impleading applicants, are to be adjudicated in the final decree proceedings as and when filed in pursuance of the preliminary decree passed in OS number 28 of 2020. Pending IS and dispute.
My lord, I place short recommendation to comply office subjection. I will comply office subjection, my lord. In date may be fixed next week.
Petitioner seeks fund is granted. Dismissal agogidya. 10 days time to comply with order with the office objection. Office objection if not complied by 7th relist on 12th for dismissal.
Please, my lord.
I am appealing for petitioner, my lordship. I will take necessary steps, my lordship. Kindly week's time.
Counsel for the petitioner seeks fund is granted.
My lords.
2 weeks time to make payment of process fee in respect of unserved respondents, as also to file necessary application to bring the legal representative of deceased respondent number 23 on record and comply with the office objection raised by the NIMNA. The counsel for respondent seeks for.
I request for 2 days time to.
And is granted 2 days time to comply with office objection raised on IA 1 of 24.
Yes, my lords. Yes, my lords. The writ petition is not maintainable because the execution petition stayed by this honorable court. It is outcome of the preliminary decree passed in the year 1977, my lords. Therefore, the partition has been suit has suit for partition is decreed.
ಕೊಡಿ. Yes, ಹೇಳಿ.
Yes, my lord. The suit for partition is decreed in the year 1977 in OS 239/1977, my lords. The petitioner and other respondents of same, the preliminary decree has been challenged by the petitioner and other respondents in RA 94/1982, my lords. The said appeal also came to be dismissed. Thereafter, I have moved an FDP proceedings in 5/1996, my lords. That came to be allowed in the year 2017.
Where is the decree copy?
Yes, my lords. At annexure R1 is the preliminary decree, judgment and decree.
Page
6, my lord. 6, 7, my lord.
ಏನು ಕಳ್ಸಲ್ರಿ ಹೆಸರು?
Yes, my lords. That is the objection has been raised.
ಬಾಬು ಯಾರು? ಸಿದ್ದಪ್ಪ ಆಮೇಲೆ ಏನ್ ಹೆಸರು? ಟೈಪ್ ಕಾಪಿ ಕೊಡಿ. We
Yes, my
can't
lords.
make out.
I request for 2 days time.
6 for so and so. Relist on
29th, my lords.
let him also pay this and then get dismissal.
Please.
Relist on ಏನ್ ಹೇಳಿದ್ದು? ಎಷ್ಟು ದಿನ? 1 week's time to ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ to make payment of process fee? 2 weeks. Relist on 11th February.
Please, ma'am.
Meanwhile, entry matter.
Entry mod earlier granted is extended. Yes.
Your lordship, objections are
27
complied.
Copy to be served on Keveta. Copy
Copy has served.
Counsel for the Keveta confirms receipt of the petition along with annexures. Hence, office objection at CL number 27/5 does not survive for consideration. Yes.
I'm filing a statement of objection.
Counsel for respondent Keveta, respondent number 5 to 7 has filed a statement of objection.
Your lordship.
ಓ ನೋಡಿದೀರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸಾಹೇಬ್ರ.
ನೋಡಿದೀರಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ರೆಡಿನಾ?
ಅಂದ್ರೆ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ಮಾಡು.
ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು, ಆಮೇಲೆ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್.
ಲಿಟಲ್ ಮಾಡು. ಹಾಫ್ ಆಫ್ ದ ಆರ್ಗ್ಯುಮೆಂಟ್
ಹಾಫ್ ಅಲ್ಲ, ಫುಲ್ ಮಾಡಿ. ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಪ್ಲೀಸ್.
ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ಮಾಡ್ತೀರಾ?
ಪ್ಲೀಸ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಯೋಚನೆ ಮಾಡಿ ನೋಡ್ಬಿಟ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ, ಆಮೇಲೆ ಅವ್ರೇನಾದ್ರು ಹೇಳಿದ್ರೆ ಯಾಕೆ?
Lords, on last date of hearing only I served it to them.
ಲಾಸ್ಟ್ ಡೇಟ್?
Last date of hearing on 20.
ಕೊಟ್ಟಿದ್ದೀರಾ? ನೋಡಿದೀರಾ?
ಇಲ್ಲಿ ನೋಡಿಲ್ಲ ಸರ್.
ಮತ್ ನೋಡಿ ಸುಮ್ನೆ ಯಾಕೆ ರಿಸ್ಕ್ ತಗೊಂಡು?
ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್.
ಹಿಂಗೆ ಎಂಟ್ರಿ ಮಾಡರ್ ಬರಲ್ಲ.
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗೆ ರಿಸ್ಕ್ ತಗೊಂಡಂಗಿದ್ರೆ ಮಾಡಿ, ನಮ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
ಇಲ್ಲ, ದೇ ಆರ್.
ನೀವು ಓದಿಲ್ದೆ ರಿಸ್ಕ್ ತಗೊಂಡ್ಬೇಡಿ.
ಓದಿದ್ದೀನಿ.
ಓದಿದ್ದೀರಾ? ಮತ್ತೆ ಹೇಳಿ.
Your lordship, respond number 5 and 5 to 7. They have filed the appeal before the deputy commissioner by the ex officio deputy director for land records on 2022, your lordship. Whereas the petitioner's property mutated in the year of 1957, your lordship. More than 65 years, they have challenged the Podi Hissas before the deputy director for land records. In that authority, they have rejected their appeal with instruction, given the instruction, if your rights and positions are available not here, you have to approach the civil court. We have no jurisdiction at all. Page number 16, your lordship. May I read, your lordship?
Yes.
Your lordship, from bottom to top, second line start. ಸರ್ವೆ ದಾಖಲೆಗಳನ್ನು 60 ವರ್ಷಗಳಿಂದ ತಯಾರಿಸಿದ್ದು, ಆದರೆ ಮೇಲ್ಮನವಿದಾರರು ಇವತ್ತಿನವರೆಗೂ ಸುಮ್ಮನಿದ್ದು, ಈಗ ಅವು ಸರಿಯಾಗಿಲ್ಲ ಅಂತ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಕ್ಕೆ ಕಾನೂನಿನ ಅವಶ್ಯಕತೆ ಇಲ್ಲದಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಅಲ್ಲದೆ ಮೇಲ್ಮನವಿ ವಿಳಂಬ ಮಾಡಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, ವಿಳಂಬಕ್ಕೆ ಯಾವುದೇ ಸೂಕ್ತ ಕಾರಣಗಳನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಕಾರಣ ಕರ್ನಾಟಕ ಭೂ ಕಾಯ್ದೆ 1964 ಕಲಂ 49A ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರದ ಮೇರೆಗೆ ವಿಚಾರಣೆ ಮಾಡಿ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಆದೇಶ ಮೇಲ್ಮನೆಯನ್ನು ತಿಳಿಸಿದೆ. ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ದಾಖಲಿರುವ ಕ್ಷೇತ್ರ ಪ್ರಕಾರ ಕಬ್ಜಾ ಪಡೆಯಬೇಕಾದಲ್ಲಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹಾಕಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಬಹುದಾಗಿದೆ ಎಂದು ಮೇಲ್ಮನೆ ತಿಳಿಸುತ್ತಾ ಮೇಲ್ಮನೆಯನ್ನು ವಿಲೇ ಮಾಡಲಾಗಿದೆ. In these circumstances, JDLR not appropriate the, please.
Revision ಏನಾಯ್ತು?
Revision.
You challenge the revision number.
Page number 21, Your Lordship. Revision petition.
Yes.
First para from bottom to top 4 line. ಇಷ್ಟ ದಾಖಲೆಯನ್ನು ತಯಾರಿಸಿ ನಿರ್ವಹಿಸುವ ಅವಶ್ಯಕತೆಯನ್ನು ಕಂಡು ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. ಎಂಟ್ರಿ
ರೀಸನ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ರೀಸನ್ ಹೇಳ್ತಾರೆ.
ಅಭಿಪ್ರಾಯ ಪೇಜ್ 20.
Page number 20 here. ಬೆಳಗಾವಿ, can I, may I read?
Yes, please.
ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ಮೂಡಲಗಿ ತಾಲೂಕು ಸುಂದೋಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 254/1 ಮತ್ತು 254/2ನೇ ದರಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಭೂ ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕರು ಬೆಳಗಾವಿಯವರ ಪ್ರಕರಣ ಸಂಖ್ಯೆ APL ಪೋಡಿ SR 221/220/22021 ದಿನಾಂಕ 30/9/2022 ಹೊರಡಿಸಿದ ಆದೇಶದಲ್ಲಿ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ದಾಖಲಾಗಿರುವ ಕ್ಷೇತ್ರದ ಪ್ರಕಾರ ಕಬ್ಜಾ ಪಡೆಯಬೇಕು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವಾ ಹಾಕಿ ಪರಿಹಾರ ಕೊಂಡುಕೊಳ್ಳಬಹುದು ಎಂಬ ಮೇಲ್ಮನವಿ ಅರ್ಜಿ ತಿರಸ್ಕರಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸದರಿ ಆದೇಶದ ಬಾಧಿತರಾಗಿ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ಮೂಡಲಗಿ ಕ್ಷೇತ್ರ ವಗೇರೆ. ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ಮೂಡಲಗಿ ತಾಲೂಕು ಸುಂದೋಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 254ರ ಆಕಾರ ಬಂದ ಪ್ರಕಾರ ಕ್ಷೇತ್ರ ಈ ಕೆಳಗಿನಂತೆ ಇರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 254/1 11 ಎಕರೆ 19 ಗುಂಟೆ, ಖರಾಬ್ 3 ಗುಂಟೆ, ಸಾಗುವಳಿ ಕ್ಷೇತ್ರ 11 ಎಕರೆ 16 ಗುಂಟೆ. ಕ್ಷೇತ್ರ ಇದು ಸರ್ವೆ ನಂಬರ್ 254/2 ಕ್ಷೇತ್ರ 4 ಎಕರೆ 21 ಗುಂಟೆ. ಖರಾಬ್ ಇಲ್ಲ, 4 ಎಕರೆ 21 ಗುಂಟೆ. ಟೋಟಲ್ ಮೆಜರಿಂಗ್ ಆಫ್ ಲ್ಯಾಂಡ್ 16 acres. ಸಾಗುವಳಿ ಕ್ಷೇತ್ರ 15 acres 37 gunters. This is the property, suit property.
Yes.
This 254ರ ಪ್ರಸ್ತುತ ಪಹಣಿ ಪತ್ರಿಕೆ ಡೈರಿ 21/3/2030 ದಿನಾಂಕ 18/11/1957 ಪ್ರಕಾರ ಕೆಳಗಿನಂತೆ ಕ್ಷೇತ್ರ ಹಂಚಿಕೆ ಮಾಡಿರುವುದು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಯಿಂದ ಕಂಡು ಬರ್ತದೆ. ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 254/1 12/27 ಮೆಜರಿಂಗ್ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿ ನಂಬರ್ 1-2 ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 254/2 ಸರ್ವೆ ಮೆಜರಿಂಗ್ 3 acres 10 gunters, total 15, 13, 37. There is no differences between the mutation and earlier edict.
Total extent illa, but 254/1 is 11 acre 19, ಇಲ್ಲಿ 1227 ಆಗಿದೆ. ಡಿಫರೆನ್ಸ್ ಹೆಂಗ್ ಬಂತು?
ಡಿಫರೆನ್ಸ್ ಈ ಸಾಗುವಳಿ ಕ್ಷೇತ್ರದಲ್ಲಿ ಸೇಮ್ ಇದೆ ಸರ್. 15 ಎಕರೆ 30 ಗುಂಟೆ ಟೋಟಲ್ ಮೆಜರಿಂಗ್. ಇಲ್ಲಿನ ಕೆಳಗ 15 ಎಕರೆ 30 ಗುಂಟೆ ಇದೆ ಸರ್. ಹೀಗಾಗಿ ಐ ಥಾಟ್ ದೇರ್ ಇಸ್ ನೋ ಡಿಫರೆನ್ಸ್.
ಖಂಡಿಕೆ 2 ಮತ್ತು
5ನೇ ಪ್ಯಾರಾ 1964ರಿಂದ 2001ರವರೆಗೆ ಕೈಬರ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಡೈರಿಯಲ್ಲಿ ನಮೂದಿಸಿದಂತೆ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿದಾರ ಹಾಗೂ ಇದರ ಕ್ಷೇತ್ರ ಕ್ರಮ 12 ಎಕರೆ 20 ಗುಂಟೆ ಹಾಗೂ 3 ಎಕರೆ 10 ಗುಂಟೆ ಕ್ಷೇತ್ರಕ್ಕೆ ಪಹಣಿ ಪತ್ರಿಕೆಯು ಚಾಲ್ತಿಯಲ್ಲಿ ಇರುತ್ತವೆ. ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ ಸರ್. ಟಿಲ್ ಟುಡೇ mutations and are in favor of our names, but is petitioners names. ಆಮೇಲೆ ಪ್ಯಾರ ನಂಬರ್ 6 ಕೆಳ ನ್ಯಾಯಾಲಯದ ಖಂಡಿಕೆ 4ರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ರಿಸ ನಂಬರ್ 254 ತಯಾರಿಸಿ ಇಷ್ಟ ದಾಖಲೆಯಲ್ಲಿ ದಾಖಲಿಸುವ ಕ್ಷೇತ್ರಕ್ಕೂ ಪಹಣಿ ಪತ್ರಿಕೆ ದಾಖಲಿಸುವ ಕ್ಷೇತ್ರಕ್ಕೂ ಹೊಂದಾಣಿಕೆ ಇಲ್ಲದೆ ಇರುವ ಬಗ್ಗೆ ವಿವರಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಆಕಾರ ಬಂದಲ್ಲಿ ದಾಖಲಿರುವ ಪೋಡಿ ದಾಖಲೆಗಳ ಪ್ರಕಾರ ಕ್ಷೇತ್ರ ಹಕ್ಕು ದಾಖಲಾಗಿರುವುದು ಕಂಡು ಬರ್ತದೆ. As per mutation and R of records they have mentioned. ಆಮೇಲೆ ಇವರು ರಿವಿಷನ್ ಆರ್ಡರ್ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ ಸರ್, ಲಾಸ್ಟ್ ಪ್ಯಾರ್.
There is a difference between the actual extent and what has been entered.
Yes.
Is what has been taken into consideration.
Please. ಡಿಫ್ರೆನ್ಸ್ ಇಲ್ಲ ಸರ್, ಡಿಫ್ರೆನ್ಸ್ 4 acres 32 ಗುಂಟ ಇದೆ, ಅದು ಒಂದೇ ಡಿಫ್ರೆನ್ಸ್ ಸರ್.
254/1 11 acres 19 guntas.
ಪ್ಲೀಸ್.
ಅದು ಎಂಟ್ರಿ ಆಗುವಾಗ ನಿಮ್ ಫೇವರ್ ಅಲ್ಲಿ 12 acres 27 guntas ಆಯ್ತು.
ಹೌದು.
ಅದು ಎಲ್ಲಿ ಬಂತು ಬ್ಯಾಲೆನ್ಸ್ 1 ಎಕರೆ 9 ಗುಂಟೆ?
If permit, I will submit, sir.
ಆಮೇಲೆ 254/2 4 acre 21 guntas 3 acres 10 guntas ಆಗೋಯ್ತು.
ಇಲ್ಲಿ ಕೆಳಗಡೆ 3 acres 10 ಗುಂಟ, ಇದು ಡಿಫ್ರೆನ್ಸ್ ಆಗುತ್ತೆ. ಇದು ಡಿಫ್ರೆನ್ಸ್.
ಅದು ಅವ್ರ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ 1 ಎಕರೆ 9 ಗುಂಟೆ ಕಮ್ಮಿ ಆಗೋಯ್ತು. ಹೆಂಗಾಯ್ತು? ಅದಕ್ಕೆ ಸರ್ವೆ ಮಾಡಿ ಕ್ಲಿಯರ್ ಆಗಿ ಡಿಮಾರ್ಕೆಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಸರ್, ಅವರು ಈ ಹೆಸರ ಬದಲಿ ಮಾಡಂತಾರ. ಆರ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ನಲ್ಲಿ ಮತ್ತು ಮ್ಯೂಟೇಷನ್ ಖಾತೆ ಬದಲ ಮಾಡಿ ಹೆಸರು ನಾನಾ ಓನರ್ ಅನ್ನೋ ಲೆಕ್ಕಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಸರ್.
ಪೊಸಿಷನ್ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ.
ಪೊಸಿಷನ್ ನಮ್ದಿದೆ ಸರ್.
ಪೊಸಿಷನ್ ಅವ್ರು ತಗೊಂಡ್ಬೇಕು ಅಂದ್ರೆ ಸಿವಿಲ್ ಪೊಸಿಷನ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
ಅದು ಆರ್ಡರ್ ಆಫ್ ಸರ್. ಪೊಸಿಷನ್ ಅದು. ಆಮೇಲೆ ಒನ್ ಮೋರ್ ಯುವರ್ ಲಾಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇವರು ಆರ್ಡರ್ ನಲ್ಲಿ ದಿನಾಂಕ 30/9/2022 ಹೊರಡಿಸಿದ ಆದೇಶ ರದ್ದುಪಡಿಸಿದೆ. ಭೂದಾಯಕ ಸಹಾಯಕ ನಿರ್ದೇಶಕ ಗೋಕಾಕ್ ಅವರಿಗೆ ಪ್ರಸ್ತುತ ಹಕ್ಕು ದಾಖಲೆ ಕ್ಷೇತ್ರದಂತೆ ಈಗೇನು ಪ್ರೆಸೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ಅದ್ರ ಪ್ರಕಾರ ನಿಯಮಾನುಸಾರ ಪೌಡಿ ದಾಖಲೆ ತಯಾರಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳ ಆಗಿದೆ. ಅವ್ರೇನು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಮಾಡಲಿಲ್ಲ ಸಾಹೇಬ್ರ. ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ಹ್ಯಾವಿಂಗ್ ಪೊಲಿಟಿಕಲ್ ಇನ್ಫ್ಲುಯೆನ್ಸಸ್, ಲೋಕಲ್ ಲೀಡರ್ಸ್, ಲೋಕಲ್ ಮಿನಿಸ್ಟರ್ಸ್. ಪೌಡಿ ಮಾಡಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟರು ಸಾಹೇಬ್ರ, ವರ್ಷಗಟ್ಟಲೆ ಕೊಟ್ಟರು ಪೌಡಿ ಮಾಡಕ್ಕೆ ಬರಂಗಿಲ್ಲ ಸಾಹೇಬ್ರ. ಈಗ ಇತ್ತಿನ 15 ಡೇಸ್ನಾಗ ಪೌಡಿ ಮಾಡಕ್ಕೆ ನಾ ಬರ್ತೀನಿ.
Yes. Lords, the true facts of the case is that the property, as they are claiming that it is ancestral property of their father, my lords, that is false, my lords. The property has been given by the father of the respond number 5 to 7 to the father of the petitioners, my lords. As there is no any sale deed was executed, my lords. Only one simple paper he has written that they are cultivating it to the extent of 3 acre 10 gunta. That to be their name to be entered, my lords. That is reflecting in my diary entry, my lords, which I have produced at page number 7 of my statement of objection, my lords. R1, my lords.
Yes.
After this, my lords, when this diary number 213 was affected, the survey department has made some error in subdividing the lines.
When was it affected?
My lords, this was mutation entry was done by the Tahsildar, my lords.
When was it affected?
It was in 1957, my lords.
ಅವಾಗ್ಲಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನೀವು?
My lords, the facts is when this subdivision was entered, the survey department, instead of entering a 3 acre 10 gunta, they have entered some
ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
Yes, my lords. I will submit.
57 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
I will submit in that regard, my lords. In the RTCs, there is no any difference, my lords, from 1957 to till date, my lords. That has been observed by the
RTC.
My lords, in this revision petition order.
Where is the actual RTC?
Actual RTC they only produce, my lords, at page number.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ RTC? No difference ಅಂತ ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು. Where is the RTC?
My lords, at page number 11 of their own petition, my lords.
RTC ಎಲ್ಲಪ್ಪ?
RTC only they have produced.
Produce ಮಾಡಿದಾರ?
ಮಾಡಿದಾರ, my lords. Page number 11, annexure A, my lords. Wherein it is mentioned that
3 acres 10 guntas.
10 gunta, my lords. We are not disputing that, my lords. We are accepting that they are eligible for this 3 acre 10 gunta. The thing is that while making the subdivision in the survey department, my lords, they have made a
RTC for 254/1.
That has been not produced, my lords. They have not.
ಇದೆಯಾ?
Yes, my lords. It is.
These are the manual notices of the respondent law.
254/2, 254/1 ಅಲ್ಲಿ.
Lords, they are my RTCs, Lords. This fact came to the knowledge of the respondent number 5 to 7, Lords, only when after the death of their father, they have partitioned the property, Lords, and they have filed an application for a POD, Lords. When the POD application was filed, there is a mismatch in the Akarband and the revenue records, Lords.
Yes.
So the ADLR directed this respondent number 5 to 7 to approach the DDLR, Lords. I approached the DDLR, but in spite of making considering all the documents, the proper order was not been passed by the DDLR, Lords. Against that, I have filed a revision petition, Lords.
RTC ಅಲ್ಲಿ 3 acre 10 ಗುಂಟಾಸ್ 12 acre 27 ಗುಂಟಾಸ್ ಇದೆ ಅಲ್ಲ.
RTC correct.
Your Lordship, RTC correct. ಎರಡು ಪ್ರಾಪರ್ಟಿ ನಮ್ಮ ಸರ್.
ನಿಮ್ದು 3 acres 10 ಗುಂಟಾಸ್.
ಇನ್ನೊಂದು 12 acres 21 ಗುಂಟಾಸ್ ಅವರ್ಸ್ ಆಲ್ಸೋ.
ಬಟ್ ಅದು ಸರ್ವೆ ನಂಬರ್ ಕರೆಕ್ಟ್ ಇಲ್ಲ.
ಸರ್ವೆ ನಂಬರ್ ಕರೆಕ್ಟ್ ಇದೆ ಸರ್.
254/1 12 acres 27 ಗುಂಟಾಸ್. 254/2 3 acre 10 ಗುಂಟಾಸ್. ಇರೋದು as per the records. ಅಲ್ಲಿ ಒಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಆಗಿದೆ. ಅದು 4 acre 27 ಆಗೋಗಿದೆ.
3 acres
ಮಾಡ್ತಾ ಇದ್ದಾರೆ. The rest of the dispute between both of you as regard possession, otherwise will have to be by
while making the entry, survey department has made a mistake, Lords. That has been observed in the revision petition order, Lords.
Entries will reject the petition.
Yes,
but if you have any right over the property, if you are claiming against them, you will have to go to a civil court.
Yes, Lords.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the revenue entries in the mutation register in respect of survey number 254/1 and /2 having been made in the year 1957, having made on 18/1/1957,
please,
indicating survey number 254/1 to be 11 acre 19 guntas,
please,
and 254/2 being 4 acre 21 guntas, has been directed to be changed by respondent number 2 while the impugned order dated 18/7/2024,
please,
to indicate that the land in survey number 254/1 measures 12 acres 27 guntas and 254/2 measures 3 acres 10 guntas. The submission of Shri Ashokai Biradar,
please,
learned counsel for the petitioner, is that the mutation entries having been on record from 18/1/1957 could not have been so directed to be changed on 18/7/2024 after more than 60 years, which causes harm and injury to the petitioner, since on the basis of such change, the petitioners apprehend that respondent number
3,
5 to 7 will interfere with the possession of the petitioner and seek to take over possession from the petitioner. His submission is therefore that the MR entries which were made in the year 1957 could not have been directed to be disturbed by respondent number 2 in a revision petition filed against the order of respondent number 4, where respondent number 4 had rejected the claim of respondent number 5 to 7. The submission of Shri Manjunath as Torgal Learned Counsel appearing for respondent number 5 to 7 is that though the MR entries were made in the year 1957, the other documents, more particularly record of tenancy and crops, indicates survey number 254/1 to measure 12 acres, 27 guntas, and 254/2 to measure 3 acres, 10 guntas,
Yes,
which is the correct measurement.
yes,
The entries in the RTCs having been in existence from even prior to the MR entries, the taxes having been paid in relation thereto, those entries are the final entries which are required, which have been taken into consideration by respondent number 3, and it is the correction of the extent which has been directed to made in terms of the RTCs, and as such he submit that no fault could be found with the said order.
Yes, my lords. RTCs are correct, and they are also admitting, my lords. Only the fault was in survey records, my lords.
Correct.
Yes, my lords. Survey records, they have committed a
Now,
mistake.
on that basis, I submit that the petition is required to be dismissed. Both the councils are in agreement as regards land in survey number 254, measuring 15 acres, 37 guntas, with the addition of 3 guntas of Karab.
Yes, ma'am.
Totally measuring 16 acres.
Yes, ma'am.
The only dispute is as regards the MR entries and the survey entries made in relation to the sub numbers of survey number 254/1 and 2.
Yes.
The petitioners contending that 254/1 measures 11 acres 19 guntas, 254/2 measures 4 acres 21 guntas,
Please.
while respondent number 5 to 7 contending that 254/1 measures 12 acres 27 guntas and 254/2 measures 3 acres 10 guntas.
Lords, in the operative portion of the revision petition order, my lords, at page number 21, they have observed that the petitioners have not produced any document to show that they are the owners for a 4 acre 11.
That will be in the suit, not here. He
In
cannot
civil
decide.
court.
Yes,
He cannot decide that.
yes.
The petitioners further contend that the petitioners are in possession of the entire land, irrespective of the measurement,
Please.
where the respondent contend that they are in possession of
12 acre.
12 acres 27
27
guntas in
guntas.
survey
Where?
number
Yes, ma'am.
254/1.
Yes, ma'am.
Your Lordship, kindly explain.
Our contention, Appa,
Please, please.
254/1.
Yes, ma'am.
And by doing so, it is contended that the petitioners are only in possession of 3 acres 10
10
guntas.
voters. Yes.
Insofar as the possession is concerned, the respondent number 2 could not have gone into the matter to determine the possession. In fact, respondent number 2 has not determined the possession, but has only directed the correction of the entries. Insofar as the entries being corrected, being in accordance with the other documents, namely the RTC, the IL,
Yes.
Akarband.
and Akarband,
Yes, ma'am.
the survey records and the mutation entry being corrected will not in any manner cause any adverse impact on the petitioner, nor confer any right on respondent number 5 to 7.
Please, ma'am.
The correction of the extent is only for the purpose of revenue entries, which would not confer any title on either the petitioner or respondent number 5 to 7.
Please, ma'am.
If at all the respondents were to contend that the respondents are the owners in possession of any portion of the said land, the respondent would be required to file necessary suit seeking for such reliefs. They cannot make use of the entries made in the revenue records or the correction now made to contend that they are in possession and or they are the owners of the land. In that view of the matter, I do not find any infirmity in the order passed by respondent number 2. The petition stands dismissed in view of the above observation it is made clear that the aspect of title and possession will have to be considered in appropriately instituted suit and has not been adverted to by this court in the present order.
Please.
For the petitioner in this matter, my lord.
Yes.
Office objection, page 43, my lord.
Really, AGA accepts notice for respondent number 1, 2, 3, 17.
Office objection, page 43, my lord. Readable and legible. The impugned order is readable and legible. May kindly be overruled.
43. Na?
Please, your lordship.
The submission of counsel for the petitioner is that the impugned order is at page 46 to 50, and he would not place any reliance on the manuscript portion of annexure H. His submission is accepted. Office objection of CL number 16 is overruled.
Please, your lordship.
Yes.
Dependent bar before this court, my lord, wherein, my lord, rejection of clubbing of suit application rejected, my lords. On hyper-technical ground, page 47, may I request your lordship. Initially, my lord, the plaintiff filed suit for, my lords, declaration and the possession, the declaration injunction, my lords. Subsequent to that, my lord, they amended the suit, my lord. They sought relief of, my lord, the mandatory injunction and the recovery of possession, my lord.
Issue notice to, emergent notice to respond number 1 to 9, returnable by 5th March. The further proceedings in OS number 78 of 2017 and ಇನ್ನ ಒಂದು ಯಾವುದು
ನಮ್ದೇ OS ಅದು ಇದರ ಸ್ಟೇಕ್ ಹೇಳ್ತಾ ಇದೀವಿ ನಾವು
ಎರಡನ್ನೂ ಸ್ಟೇ ಮಾಡ್ಬೇಕಲ್ಲ
ಪ್ಲೀಸ್ ಅದು ಮಾರ್ಚಿಗೆ ಹೋಗಿದೆ ನಮ್ಮ
ಎರಡು ಸ್ಟೇ ಆಗ್ಬೇಕು ಒಂದೇ ಅಲ್ಲ
ಇಲ್ಲ ಪ್ಲೀಸ್
78 of 2017 pending on the file of the senior civil judge Ramdur and OS number 24 of 2021 pending on the file of
same court, my lords, senior civil judge.
OS number 78 of 2017 and 24 of 2021 pending on the file of the senior civil judge Ramdur is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29 January and acknowledgement of service on the counsel, respective counsels appearing for the respondents to be filed on or before 4th February 2025, failing which the interim order will stand automatically.
Please, your lordship. Oh, bless.
Please. With respect to the objections, my lords, court fee I've paid my today.
Curator has filed memo of retirement.
Please. Yes, fine. There is writ petition filed against the order, my lords. You have sought for amendment of the written statement that came to be rejected.
A memo of retirement has been filed by the Curator Council, signed by the GPA holder of the Curator. Accepting the said memo, the Curator Council, Sri Chandrasekhar R. Iremat and Sunita C. Iremat are permitted to retire from the matter. They are discharged from the matter. Registry is directed to print the name of respondent number 1.
Please.
In the cause list with the endorsement earlier counsel retired.
Please.
Permitted to retire on today's date. Bracket close. ಹೇಳಿ ಏನು ಇಷ್ಟೊಂದು objection ಇದೆ?
ಇಲ್ಲ, those are the minor, my lords. I will only with respect to the
court fee ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದೆ.
Counsel for the petitioner submit that court fee has been paid, registry to verify. Yes, ಹೇಳಿ.
This is, my lords, suit for, my lords, declaration and partition filed by the plaintiff. Defendant filed the written statement and subsequently at the stage of cross of PW1, defendant filed applications for the amendment of the written statement, saying that, my lords, the plaintiff claiming to be the wife of one Kandeppa, my lords, of our family, she was taking the widow pension since 2002 with respect to the other person, my lords. Now she is claiming the partition in our family, my lords. That portion in the written statement need to be incorporated, my lords, to the amendment. That came to be rejected, my lords, because only on the ground that, my lords, we have not denied the relationship, my lords. That was the only ground which has been taken by the trial court. That is at, my lords, page number 50, my lords. Page number 47, my lords. in the bold letters, my lord, second para, that is para number 5, my lords. They say that it's not disputed that that is a written statement, incorporation of a written statement which we have filed, my lords, before the trial court. It is not disputed that the propositus and his wife had died long back by leaving the children and legal heirs like 4 sons and 1 daughter. The rest of the contents in the para number 4 of the plaint is not being disputed in respect of legal heirs of the 4 male heirs of the said propositus. The genealogy is at page number 21. We now we don't dispute with respect to the original propositus of the family having 4 sons and 1 daughter. Subsequent to that, my lords, the 4th son who is unmarried, now by claiming that the plaintiff is the wife of that 4th son, my lords, she has filed this declaration suit, my lords, for cancellation of the sale deed, which the defendant number 2 to 18 have sold those property to the defendant number 20 to 25. Now she is seeking for cancellation of those sale deed and subsequently for seeking of the partition in that the suit scheduled property, my lords. Recently, we got to know that, my lord, she's taking the widow pension of my lords, one in the name of, my lords.
Yes. Issue notice to respond number 2, returnable by 19th March. The further proceedings in OS number 262 of 2022 pending on the file of the Principal Senior Civil Judge and CJM Dharwad is stayed till the next date of hearing. Process fee and copies by end of date 29th. Acknowledgement of service in respect of respond number 2 on the acknowledgement of service of notice on the counsel appearing for the respond number 2 in the above suit to be filed on or before 4th February, failing which interim order will stand. Failing either of which interim order will stand automatically.
Please, great.
In the meanwhile, office objections to be complied.
Please, I will come.
Remaining office objection to be complied with on or before 4th, failing which the interim order will stand automatically.
Please, great.
So office objection regarding the non-compliance.
Yes.
Of serial number 3, 10, 12 and 23 and 2 of the serial number 25. But to that extent, my lord, on 29/11/2024, filed a memo at the registry stating that the petitioner are not interested to proceed with the respondent number 10 to 136.
Which memo have you filed?
On 29/11/2024, my lord, filed a memo that there is no claim against the respondent number 10 to 136. So their name may be.
Who are they?
There are 147 respondents. They are the defendants in OS number 259 of 2013.
And you are?
I'm the defendant number 1 and 2 in the trial court, suit before the trial court.
Order is passed on?
Order is passed on, Lord, 6/11/2024.
What application?
Application was filed under section 151 CPC to strike out the cross-examination conducted by the defendant number 3 to 8 and 11 to the defendant number 1. The specific case, my lord, the respondent number 1 and 2 are the plaintiffs before the trial court.
Can you ask for striking out the cross-examination?
What has happened? Yes, my lord. There is no conflict of interest between the defendants. There is no adverse interest between the defendants.
How can defendant number 1 and 2 ask for striking out of the cross-examination?
Because they have stepped into the shoes of the plaintiffs. My lord, page 180, my lord, the cross-examination conducted by the defendant number 3 to 8 and 11. They have filed the written statement denying the claim of the plaintiffs. Lord, internal page number 23 of the deposition.
Now the cross-examination of PW1.
DW1
was conducted by?
Defendant number 3 to 8 and 11.
3 to 8. Who is DW1?
DW1 is the elder brother of?
Defendant number?
Defendant number 1.
Defendant number 1.
DW2, my lord. Sorry, my lord, I may stand corrected.
Defendant number 1 was examined as DW2.
And he was
examined by defendant number
3 to 8 and 11. So there is
11.
no conflict of interest and adverse interest against the defendant. My lord.
They are cross-examined.
Yes, my lord.
You should have objected then.
We have objected, my lord, that has not been taken on record.
To challenge, you can't ask for striking out.
My lord, what has happened? They have adopted the written statement. They have adopted the written statement filed by the defendant number 1. And subsequently, they themselves have filed written statement denying the claim of the plaintiffs. And subsequently, they stepping into the shoes of the plaintiff, they have cross-examined. My lord, for a moment, my lord, page 180, my lord. The cross-examination of the defendant number 3 to 8 and 11.
Yes.
My lord, first para, last but second line. ವಾದಿಯರಿಗೆ ದಾವಾ ಆಸ್ತಿಗಳಲ್ಲಿ ಹಕ್ಕಿದ್ದರೂ ಕೂಡ ಇಲ್ಲ ಎಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. If at all, if they are having any rights or share in respect of social property, they could have asked for their own self. Now they have stepped into the shoes of the plaintiffs.
This is a
suit for declaration, partition, and separate possession. Declaration so as to declare that the sale.
Each one is a plaintiff, Mr. Counsel.
Yes, my lord. I do admit, my lord. My lord, one more submission, my lord. One more
Just
submission.
because it's contrary to what you want to say.
My lord, what has happened in this case? The sale deeds were challenged by the plaintiffs. Is these 3 to 8 are the executant of the sale deed?
That is on merits will be dealt. You can't ask for striking out. Petitioners are before this court seeking for the following reliefs. Respondent number 1 and 2 had filed a suit in OS number 259 of 2013 seeking for declaration, partition, and separate possession, wherein the petitioner was arrayed as defendant number 1 and 2. Defendant number 1 was examined as DW2 and cross-examined by defendant number 3 to 8, cross-examined by counsel for defendant number 3 to 8 and 11, who are also the other family members.
No, 11 is the purchaser, my lord.
3 to 8 are
3
family
to 8
members.
are the family members.
3 to 8 are the family members and 11 is a purchaser. An application under section 151, IA number 79.
Yes, my lord. Now it has reached 85.
That shows your
No, my lord, it was. They
IA
have
number under section 151 of the Code of Civil Procedure came to be filed, which came to numbered as IA number 79 for cross-examination, to strike out the cross-examination dated 25/10/2024 of the aforesaid DW2 by the counsel for D3 to 8 and 11. The said application came to be dismissed, while the impugned order dated 6/11/2024 challenging the said order that the petitioner is before this court. The contention of the counsel for the petitioner is that there is no adverse interest between defendant number 1 and D3 to 8 and 11. And as such, firstly, they could not have cross-examined DW2. And having cross-examined, the trial court ought to have allowed the application in IA number 79 and struck off the cross-examination. Having heard the learned counsel for the petitioner, the suit being one for declaration, partition, and separate possession, it is tried law that all the family members would be plaintiffs in the suit, and all of them would have their interest, which needs to be determined in the said suit. Defendant number 1 and defendant number 3 to 8 being the family members not being in dispute, all of them are plaintiffs in the said suit. And as such, the question of whether there's a conflict of interest or not, when each of them being the plaintiff, would not arise. Any of the family members can always cross-examine the other family member in the said suit, since each of the almele plaintiff and defendant in a suit for partition. Since in a suit for partition, a member of the family occupies both the position of the plaintiff and defendant, and if any particular party any particular family members wishes to cross-examine the other family member, he would be required to be permitted to do so, and the cross-examination would have to be considered on merits and cannot be struck off on the ground that there is no conflict of interest. No grounds being made out, the petition stands dismissed.
My lord, more submission, my lord. Trial court be directed not to be influenced by the order of the Honorable Court.
Why?
Because they have filed a memo. They
The
have
trial
filed a
court
memo.
will have to be influenced by this order, so that you don't file another application.
I appear for petitioner.
Pending IA stands dismissed. 21. What is your number? Court fee kottidira?
Yes, my lord, I paid it.
DCF.
400 I paid. They are demanding 500
Huh.
because 4 petitioners is there. Why they are demanding 500?
Five properties idava?
No, my lord. Only one property,
ಮತ್ತೆ ಯಾಕೆ?
10 acres, my lord, among the 53 acres.
100 acres with one property ಇದ್ರೇನು ಒಂದೇ ಕೊಡ್ತೀವಿ.
10 acres, 10 acres.
ಎಷ್ಟು ಎಕರೆ ಇದ್ರೇನು ಅಷ್ಟು ಒಂದು ಬ್ಲಾಕ್ ನಂಬರ್. There being only 4 petitioners, petitioner has made payment of court fee of 400 rupees. Registry has raised an objection that there is a deficit court fee of rupees 100. Registry is direct put up a note as to on what basis the same has been calculated by the registry. Until then, the office objection at CL number 3 is kept pending. Heli.
Please, my lord. The petitioner is filed an for number 7 to grant occupancy right in respect of 10 acres out of 53 acres 32 guntas in block number 32, my lord. Subsequently, this is the third round litigation before this honorable court, my lord. And some of the other applicants in block number 32, my lord, they have filed an affidavit before this honorable courts, affidavit before the tribunal stating that they are not cultivating the land. And their for number 7 is rejected and enter the name of the owner instead of the government, my lord. And at the time of deleting their name, my lord, in the year 2006, my name is also deleted in the record of right, my lord. That is annexure H1, my lord. Page number 115.
Yes.
In respect of 53 acres 32 guntas, entire the name of owners is shown, my lord. Thereafter, my lord, the notice is issued to me as per annexure J, page number 122, regarding 10 acres of land. That is page number 122. I have participated in the proceedings, my lord. Then, my lord, without giving opportunity of hearing, passed an order, rejected my occupancy right. Page number annexure L, page number 193. That is before questioned in this petition.
Page number
193, annexure L.
Annexure L is a very long order.
The reason is given in the order is, my lord, ಅರ್ಜಿದಾರರು ಗೇಣಿದಾರರೆಂಬುದು ಅರ್ಜಿದಾರರು ಸ್ವಾಧೀನ ಹೊಂದಿದ್ದಾರೆ ಎಂಬುದು ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಮತ್ತು ವಿಚಾರಣೆಯಿಂದ ಸಾಬೀತು ಆಗಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಲು ಬರುವುದಿಲ್ಲ. This is the only reason given in the order, my lord. Though I have filed a for number 7 in the year 1973-74, my name is continued till 2006.
But your lordship, they have to show that your lordship, they are the tenants of the land in question. Unless they, your lordship, they produce the document, relevant document regarding, even though your lordship, they might have filed form number 7, but your lordship, they have to show their possession as on 1/3/1974.
Yes, my lord. I am in possession of the land. Annexure B.
RTC ಎಲ್ಲಿದೆ?
RTC, yes, my lord. Annexure C, my lord.
Page?
Page number 32. Typed copy, my lord. Page number 48. Page number 48. Page number 48. Serial number 3. Shambulingappa Shivarudrappa Kulkarni. Extent is 10 acres. Total extent is 53 acres, 32 guntas.
40?
47, I'm sorry. 47, annexure, typed copy.
Is on 67, 68.
Yes, ma'am.
ಇದೆಲ್ಲ mistake ಅನ್ನು?
No, 60. I'm sorry.
74 ಎಲ್ಲಿ?
74, yes, ma'am. '74, your lordship kindly come to page number 34.
49, yes. ಇದೆಲ್ಲ.
But your lordship may kindly see in the next, that is page number 34, 74, 75. That your lordship column 12, Sher Khan Mohammad Sahab Nadaf.
ಅವ್ರ ಹೆಸರು ಇದೆ.
Totally 5 applicants are there.
There are different tenants.
Different tenants
But
on the entire extent.
Rudrappa
Air can
Kulkarni,
withdraw ಮಾಡಿದ್ರು ಅಂತ ಎಲ್ಲಾರ್ದು withdraw ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Rudrappa Kulkarni name is cultivated Sagol Padati 1 though. It is not 3. If it is,
ಶಂಭುಲಿಂಗಪ್ಪ ಶಿವರುದ್ರಪ್ಪ ಕುಲಕರ್ಣಿ.
it is shown as 3, Your Lordship.
3.
1.
Applicant number 3.
ಇದೆ ಅಲ್ಲ.
ಶಂಭುಲಿಂಗಪ್ಪ ಶಿವರುದ್ರಪ್ಪ ಕುಲಕರ್ಣಿ.
Air can withdraw ಮಾಡಿದ್ರು, affidavit ಹಾಕಿದ್ರು.
ಶೇರ್ ಖಾನ್ ವಿಡ್ರಾ ಮಾಡಿದ್ರು, ಕರೆಪ್ಪ ಭೀಮಪ್ಪ ವಿಗ್ದಾನ್ ಮಾಡಿದ್ರು, ವಿಡ್ರಾ ಮಾಡಿದ್ರು.
ಇವ್ರದ್ದು
But
withdraw ಬಗ್ಗೆ ಏನು ಹೇಳಿ.
ಮೊಹಮ್ಮದ್ ಗೋಸ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು.
ಯಾಕೆ ಎಲ್ಲಾರ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಸರಿಯಾಗಿ ನೋಡದೆ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಇದೊಂದು 5 ವರ್ಷ ಅನ್ನೆಸರಿ ಟೈಮ್ ವೇಸ್ಟ್ ಇದೆಲ್ಲ. legal heirs of legal heirs of legal heirs, legal heirs of counsel also.
So many coming, Your Lordship.
ಎಷ್ಟು 74 in the
In land farms matter, it is going
50
like that.
matters of 50 years of litigation is already.
Especially in land farms matter, Your Lordship.
Because of your officers not conducting it properly. Correct ಆಗಿ ಒಂದು ರೀಸನ್ ನೋಡಿ ಒಂದು ರೀಸನ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ರಿಸಾಲ್ವ್ಡ್. ಒಂದೊಂದು ರಿಮಾಂಡ್ ಒಂದೊಂದು ಪಾಯಿಂಟ್, ಅದೇ ಪಾಯಿಂಟ್ ಮಾತ್ರ ನೋಡೋದು, ಇನ್ನೇನು ನೋಡಲ್ಲ. ರಿಮಾಂಡ್ ಆಗೋವರೆಗೂ ಇವಾಗ ಸ್ಟೇ ಮಾಡಬೇಕು. ವಿ ಕಾಂಟ್ ಇವನ್ ರಿಮಾಂಡ್ ವಿತೌಟ್ ನೋಟಿಸ್.
And also they have to follow the rule 17 of the land farms rules. Spot inspection ಮಾಡೋಕಂತೆಲ್ಲ ಇರ್ತದೆ ಅಲ್ಲಿ.
But nothing has been considered. And AGA accepts notice for respond number 1 to 3. Issue notice to respond number 4 to 12. Emergent notice written on by 6th March. So and so is at annexure L is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29th, failing which the interim order will stand automatically vacated.
Please.
For the petition, there are total 6 IAs. Petition number 15 and petition number 1 were died.
Sole petitioner?
No, my lords, petition 15 and petition number 1.
IA 1, 2 and 3 yargappa.
Petition number 15. Please.
4, 5 and 6 petition number 1.
Please.
During the pendency of the above matter, petition number 15 expired on
10/7/2019.
10/7/2019. Hence IA 1, 2 and 3 of 2020 have been filed on
My lords, 5th February 2020.
5th February 2020, accepting the reasons stated in support of IA 1 of 2020, the delay of 120 days is condoned. Accepting the reasons stated in support of IA 2 of 2020, abatement in respect of petition number 15 is set aside by allowing IA 3 of 2020, the person named therein are brought on record as 15A to 15D. Counsel for 15D. During the pendency of the above matter, petition number 1 also expired on.
Please, your lords. Lords, on 6/8/2017.
6/8/2017.
8/2017.
8/2017. Hence IA 5, 6. Bari 5 and 6.
ಇಲ್ಲ 3 IAs ಇದೆ, my lord. 6 IAs ಇದೆ.
7 ಅಲ್ಲಿ.
ಪುಟ್ಟಪ್ಪ ಇರ್ಲಿಕ್ಕಿಲ್ಲ, my lords.
IA 4, 5 and 6 have been filed on.
On my lords, same day, 5th February 2020.
Accepting the reasons stated in support of IA 4 of 2020, delay of 822 days is condoned, subject to payment of cost of rupees 2,000 to the advocates, 1,000 to the advocates clerks, so and so. Accepting this IA 5 abatement set aside, 6 P1A to P1E, counsel for the petition to carry out necessary amendment and file amended cost title. Mr. Angdi, you are appearing for R1. Sri R.H. Angdi has entered appearance for respond number 1. Registry is direct delete the name of Ms. Aruna Deshpande and AP Kamoji as that appearing for respond number 1.
Please, your lords. God bless.
Connected matter.
22.1 ಯಾರು appear ಆಗ್ತಾರೆ ಇವಾಗ? R2 ಗೆ?
In that matter, my lordship, I have not received wakalat, my lord. In first matter only, I have filed wakalat.
So you will file wakalat?
I'll undertake, my lord. I'll undertake.
22.1 Sri R.H. Angdi submit that you will be appearing for respond number 2 by filing wakalatnama within a week from now.
Please.
If needful is done, registry direct print his name as that appearing for respond number 2 and delete the name of Ms. Sharmila M. Patil and AP Kamoji as that appearing for respond number 2. Objections ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? Proceedings complete?
Complete ಆಗಿ.
2008.
Short point for consideration.
Objections in bedwa?
Bad, bad.
The RH Angdi submit that he does not wish to file any objections in writing. His submission is taken on record. Relist on 6th February, by which time the amendment is to be carried out and amended cost title to be filed.
Please, Your Lordship, oblige.
Who is appearing for respond number 5 now? You are appearing. Yeah, Avinash Vankar has entered appearance for respond number 5. Registry is direct delete name of Sri Shivkumar as Badwadgi as that appearing for respond number 5. Yes, Mr. Kannur.
Establishing the year 92
Hmm.
and continuing. Now there was certain objections which they said that they are not fulfilled. That was for the year 21-22.
Hmm.
And subsequently, 23, 24, 24, 25, we are functioning, there are no issues.
Hmm.
Now, in respect of this, with regard to certain faculty members, they said it's not there. So, there are two submissions before your lordship.
Hmm.
One on the merits, if your lordship were to see page 28, of annexure into the issued orders at 2012-2021.
Hmm.
The order starts on at page 26.
Hmm.
Come to page 28.
Hmm.
And in that, in the just above the table, where they say college is not paragraph 2,
Yes.
College is not fulfilling the criteria of minimum 12 of higher faculty in 11 departments as per RMS so and so.
Hmm.
College submitted. Now, if your lordship sees these 6 people,
Hmm.
in respect of 6, 3, they say the teacher has neither updated his OTMS profile nor having the new teacher's code.
Hmm.
So 3 of them are that, my lord. So this is not, my lord, straight away illegality, my lord. Some irregularity may be there. But in respect of 3, that is serial number 2, 3 and 6, my lord, they say that PG qualification. My lord, but
They require only 12. You have submitted list of 35.
Yes.
Out of 35, 6 are disqualified.
Yes.
That means there are 29.
Yes, so everything is there.
More than 12.
Now, this honorable court had granted an interim order, my lord, and one more technical thing is hearing committee hears, one hears and the other passes the order. So, my lord, which could not have been done based on that, that has been recorded by the learned single judge and an interim order of stay was granted
Hmm.
on 23/12/2021, if your lordship sees that order. 23/12/2021.
Mr. Kanvi, you appear for NCM. Yes.
Lord, and then he was permitted to take up the students were permitted to take up the examination on 13/7/23 and results were to be declared. Lord, that was done. Then on 28/11/2023, my lord, supplementary exams, my lord, this honorable court permitted them to take. Results were also declared. Now, my lord, we are filing application. My lord, to take up the second year.
We'll dispose of your petition via you.
My lord, I am appearing for 1 month, 2 to 4,
I
my
appear
lord.
for, my lord, my name has not been shown, my lord.
You appear for whom?
NCISM, my lord.
You have not filed your wakalat.
No, my lord, in this case, my lord, I haven't filed.
Why you haven't filed your wakalat?
Lord, I was not aware of this. In another case, my lord, I have filed. The next case, my lord, I have filed it. My lord, my shin.
Order sheet ಕೊಡಿ. Notice ಆಗಿದೆ ಏನಾಗಿದೆ? ಇದೆ
In serial number 25, my lord, I have filed it. There is another case, my lord.
Shri MB Kanvi accepts notice for respond number 1 to 4 ಅಂತಿದೆ.
Earlier it was there, my lord. Now the separate penal counsel has been made. Now
You are not concerned.
Yes.
You are not retired.
He has also not filed.
Have you retired? We don't see you, we only see Mr. Karnataka.
Yes.
If you wanted to file wakalat, you should have filed.
Because I was unaware of this particular case, my lord.
Your client is aware.
Not one submission, my lord. Lord, insofar as the admission of students to the
Admission Namelban, you first only say in this, when they gave a list of 35 teachers, you require only 12. You found fault with 6, leaving a balance of 29. 29 is greater than 12, 2.5 times. Indian problem in the.
Nodilla sir, at least by tomorrow, my lord, I will.
Pass over, note. We'll be passing orders against this person, the president, for having done this.
He passes the hearing committee hears and the president passes.
That's why the president will pass orders against. If he doesn't know even simple mathematics, how is he the president of the Medical Assessment and Rating Board of Indian System of Medicine? This is all extortion. One or two of these people, if they go in, then it will be clear. All unnecessary litigation coming up before this court where we have to intervene. Permission kodi first, ಆಮೇಲೆ declare ಮಾಡಿ, supplementary ಮಾಡಿ, ಅದೆಲ್ಲ ಕಣ್ಣೂರು ಹೇಳ್ದಂಗೆ ಮಾಡಬೇಕು. Because this person does not know simple mathematics. So and so submit that you would be appearing for respond number 2 and 3. He seeks for 2 days time. Relist on 29th. He is directed to obtain instruction, make his submission as regards para 7 of the impugned order dated 2012-2021, where it is categorically stated that the criteria for grant of recognition is 12 higher faculty. The college having submitted a list of 35 teachers in an Excel format, fault has been found only with 6 teachers, leaving a balance of 29 eligible teachers, eligible faculty, 6 faculty members, leaving a balance of 29 eligible faculty members. If that be so, the impugned order could not have been passed. Released on 29th. You don't need to come. Physically, you can come if you want to.
25.
24. Then we'll come to 24.
But may I appear on behalf of the petitioners.
Yes.
But IA is filed seeking for direction as against the respondents.
They have to
Pay.
ಯಾವ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
But IA is filed during pendency of the about it petition, but the endorsement came to be issued by the respondent. So therefore IA is filed on 31st July 2023.
What is this application for?
But application is seeking direction as against the respondents to pay rupees 40,15,184. For the reason that in the year 2000.
You argue the matter on merits, Mr. Yaji. We'll consider that along with it. Ready for merits?
Day of tomorrow.
Yes, I'm ready, madam.
Tomorrow.
And AGA seeks for and is granted 2 days time to get ready and address his arguments on merits. Released on 29th. IA 1 of 23 will be considered along with merits.
Please, madam.
For the petitioner college.
Yes.
Same college. Just for one more year, certain other
Allegations are there, which are not that easily satisfied. 25, connect with 23 and relist on 29th.
Please.
Bangi, you are appearing for 9 to 11. So
Please. Tenants.
Deepa P. Dodatti for R2. S.H. Yadwad for 3 to 7.
Yes.
Deepa P. Dodatti.
Lord, she sails with me.
She sails with you. Yes.
Here the issue is that the tenancy has been surrendered in the year 1955.
This is not for vacating, this is for merits.
Yes.
Yes.
Here the surrender of the tenancy in the year 1955 under the Bombay Agriculture and Tenancy. The land tribunal passing in order from Lord Tenancy, page 37.
Yes.
On the bottom line.
ಸರಿಯಾ ಕಾಣಿಸಲ್ವಲ್ಲ ಇದು ಟೈಪ್ ಇದೆಯಾ?
Typed it.
ಹಾ ಅದೇ ಹೇಳಿ. Page?
Is that number 47. Page 47.
Yes.
Page 47 after this English second paragraph. ತಾವೇ ಒಂದು 1956 ಮಂಜೂರಾದ ಹಕ್ಕು ದಾಖಲೆ ನಂಬರ್ 707 ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಜಮೀನುಗಳ ಆರ್ಟಿಸಿಯಲ್ಲಿ ರೈತ ಅಂತ ಇದ್ದ ಅರ್ಜಿದಾರ ಸವಣಪ್ಪ ಬಸಪ್ಪ ಪದ್ಮಣ್ಣ ಇವರ ಹೆಸರನ್ನು ಕಡಿಮೆ ಮಾಡಿ ಮಧುಕರ್ ಒಮ್ಮಣ್ಣ ಮುಚ್ಚಂಡಿ ಇವರ ಹೆಸರನ್ನು ದಾಖಲಿಸಲು ಸಲ್ಲಿಸಿದ ವರದಿ ಅರ್ಜಿಯ ಮೇಲಿಂದ ಅವರ ಹೆಸರನ್ನು ಕಡಿಮೆ ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ರೆ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 1961-74 ಕಲಂ 25 ಅನ್ವಯ ಅರ್ಜಿದಾರರು ಗೇಣಿ ಹಕ್ಕನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರ ಪರವಾಗಿ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳು ಹಾಗೂ ಅವರ ಪರ ನೀಡಿದ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಗಮನಿಸಲಾಗಿ ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 1/3/74 ಮತ್ತು ಅದಕ್ಕೂ ಮುಂಚೆಯಿಂದಲೇ ದಾವೆಯ ಜಮೀನುಗಳನ್ನು ಗೇಣಿನಾದ್ಯಂತ ಸಾಗುವಳಿ ಮಾಡಿದ್ದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತದೆ. ಅದರಂತೆ ಎದುರುದಾರರು ಸಹ ಅರ್ಜಿದಾರರ ದಾವೆ ಜಮೀನುಗಳನ್ನು ಗೇಣಿನಾದ್ಯಂತ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಅಲ್ಲಗಳೆದಿಲ್ಲ. ಈ ಎಲ್ಲ ವಿವರಗಳನ್ನು ಪರಿಗಣಿಸಿ ಮಾಡುತ್ತಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತಿರುವುದರಿಂದ ಸದರಿ ಜಮೀನುಗಳಿಗೆ ಎಲ್ಲ ಅರ್ಜಿದಾರರನ್ನು ಸಾಮೂಹಿಕವಾಗಿ ಮತ್ತು ಜಂಟಿಯಾಗಿ ಅಧಿಭೋಗದಾರರನ್ನು ಸಂದಾಯಿಸಲು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಆದೇಶ 194 ಸ್ಥಿರೀಕರಿಸಲು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಎಲ್ಲ ಸದಸ್ಯರು ಸರ್ವಾನುಮತ ತೀರ್ಮಾನಿಸಿ ಕೆಳಗಿಂದ ಆದೇಶಿಸಿದರು. Now here they admit that there is a surrender of tenancy in the year 1956. And where is the question of applying the section 25 Karnataka Land Reforms Act after 1974 and 93 the surrender of lease is annexure 3 at page 131 section 5(3) of the Bombay.
Page?
Page 137.
137. Under section 5?
3 of the Bombay Agriculture and Tenancy.
Bombay.
There is the original I have turned out in my citation, some citations I have given.
Act ilva?
Because there is an amendment.
Rules ಸಿಗ್ತಾ ಇಲ್ಲ.
But that has been colored in some judgments of honorable.
Lord, if you click on the Google, my Lord, search for rules, Lord, the act is available.
But that is subsequent to 1956. That is aforesaid.
We'll have to see the act and the rules.
It is reflected in the judgment.
ಇದೇನಿದು?
One of the judgment.
Act ಇದೆ ಅಲ್ಲ, ಇದೇನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
There is an amended version. This amendment, there is a section 5(1) has been replaced by section 11. That is again mentioned in the one of the judgments, some series of judgments of the honorable Apex Court.
Earlier it was, my Lord, the Bombay Tenancy Act, 1939. Thereafter, my Lord, this 1948.
After state reorganization, there is an amendment in 1966. Now I try to draw that solution at page 90.
These sections were substituted for section 5, 6, 7, 8, and 9 by Bombay Act 13 of 1956, section 4. That is section 5 you are speaking of.
Yes, that is reflected in page 91, 92 of the same comparison. Yes. While dealing with the similar issue,
Section 5 is the sealing.
ಇದರಲ್ಲಿ section 5 ಬರ್ತಾ ಇರೋದು ಬೇರೆ. That is actually the section 5 is replaced by section 7.
Your new act ಕೊಟ್ಟಿರೋದು 5 is sealing.
5, this is amended act. In fact, that is reflected in this judgment at page 90.
What was 5 earlier?
5 earlier was surrender. Earlier 5 was surrender, which
Yes,
has been replaced by section 11 of
Page 90.
91 and 90. This is the judgment of Honorable Apex Court.
Lordship, kindly see page 84, my lord, in his compilations. 84, my lord.
80, ಯಾವ್ದು 84 ನೋಡ್ಬೇಕಾ?
84 ಅಲ್ಲಿ 1939 Act, my lord, has been repealed. I'm not saying, disputing anything.
You are referring now to 91, page 91.
91. So it starts from 90.
Yes.
Then the surrender of tenancy was that was here the issue was also the similar. Then there page 92 will para 3.
ಅದು full section produce ಮಾಡಿಲ್ಲ.
That is the at the relevant point of time, Bombay Tenancy and Agriculture Lands Act, which was Bombay Tenancy, was in operation in the state of Karnataka. Section 5(3)(b) of the state act is as follows. Notwithstanding anything contained in the subsection 1, a tenant may terminate the tenancy.
We need the entire section. We can't go by this.
That is again.
Notwithstanding anything contained in subsection 1, subsection 1 ಓದ್ಲೇಬೇಕು. A is not being reproduced. B may terminate the tenancy by surrendering his interest as tenant, provides that it shall be in writing and shall be verified before the Mamlatdar. In subsection 1 ಏನದು? See, it may be only that which was under consideration before that court. We'll have to read the entire provision. ಯಾರ ಹತ್ರನೂ ಇಲ್ವಾ ಇಲ್ಲಿ?
ಸಿಗ್ತಾನೆ ಇಲ್ಲ. Lord, even I am trying to search from Maharashtra. Lord.
AG's library ಅಲ್ಲೂ ಇಲ್ಲ.
ಅದೇ book ಇದೆ. That is the book available in the judge's library.
Full section ಇದೆಯಲ್ಲ ಅದ್ರು?
In fact, my lord, if
ಯಾವ publication ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ವಾ?
ಅದು that is repealed in 1939.
ಅವಾಗ ಯಾವ್ದು publication ಇಲ್ವಾ?
Page 84 ಅಲ್ಲೇ that is been repealed ಅಂತ ತೋರಿಸ್ತಾರೆ.
In 97 ಅಲ್ಲಿ ಏನಿದೆ?
97 section 15(1) was inserted in that act, and there was even before 1966 they say that there was in the act section 5(3) the proviso which required the surrender of tenancy by tenant to be in writing and verified by the Mamlatdar. So that should be in writing and it should be verified by the Mamlatdar. Section 15(1) was inserted in 1956.
Kannur, you will have to give us the act. You are the state. You should be having this. The state is a party here. ನಮ್ಮ ಲೈಬ್ರರಿಯಲ್ಲಿ ಇಲ್ವಾ? ಬೆಂಗಳೂರು ಲೈಬ್ರರಿ, ಹೈಕೋರ್ಟ್ ಲೈಬ್ರರಿಲೂ ಇಲ್ವಾ? You will have to furnish us.
Next week,
Reference is made by the counsel for the petitioner to section 5(3) of the Bombay Tenancy and Agricultural Lands Act 1958 in its unamended form. When the council was asked to furnish the bare act relating thereto, he submits that the same is not available. Similarly, the submission made by counsel for respond number 9 to 11, 13 to 16, and 17 to 19. This court also does not have a copy of the said act in its unamended form. Learned AGA is directed to secure the same and furnish it for consideration. Released on 6th February. Fourth February.
Fourth one.
Alerts.
Yes. ಮೂರು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಒಂದು ಎಜುಕೇಶನ್ ಮ್ಯಾಟರ್ ಇದೆ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದೆ. ಎಸ್. ಹಾ. ರೆಡಿನಾ?
Alert seeking for short adjournment.
You are appearing for whom?
R1, my lords. In list.
R1 in the
connected. Connected.
R1
Fourth
is the
matter.
state.
Connected.
Connected matter.
You are appearing for Mr. KL Patil.
Yes. No. Irin Gowda K. Kapoor.
ಯಾರು?
Irin Gowda Kapoor.
Lord, in 27.3.
27.3.
27.3.
Yes. R1. R1.
What about Mr. KL Patil? Is he ready?
Yes.
Ready na? And we have Shri KL Patil and Shri Iranagowda K. Kapoor. A short accommodation is sought for. Released on 6th February 2019. Released on 6th February. Not earlier granted is extended.
Please.
Gurraj R. Turmari, Deepak S. Kulkarni. Vacating stay. Where is Mr. Turumari and Deepak Kulkarni? You ready na? You are ready. ನೀವು ರೆಡಿನಾ ಅಂದ್ರೆ ಆ ಕಡೆ ನೋಡ್ಬೇಡಿ, ನೀವು ಹೇಳಿ ಎಸ್ ಆರ್ ನೋ ಅಂತ. ಪಾಸ್ ಓವರ್. Who do you want to implead, madam?
Impleading application, last occasion I filed.
Regulation
committee.
Hello,
Form,
Aditya.
if allowed, I will file the amended.
Accepting the submission of counsel for the petitioner and the amendments made in support of IA1 of 25. Said application is allowed. The regularization committee is brought on record as respond number 6. Learned AGA accepts notice for respond number 6. Counsel for the petitioner to file to carry out amendment to the cost title and file amended cost title in 1 week's time from now. Same matter either.
2 days I'll file.
In 2 days time. Same matter.
Can it be
ಮೊನ್ನೆ
disposed of?
ಯಾವ್ದು dispose ಆಗಿದ್ದು?
One.
WP number?
I'm kindly pass on. I'll sub.
Same order as WP number. And AGA accepts notice for respond number 1 to 5.
Taken up tomorrow, 28.
ಯಾಕೆ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು?
Personal
28, though counsel for the petitioner is present and ready to address arguments. None appears for the response. Released on 31st
Please.
January.
Please.
If none were to appear for the respondent on that date, matter would be taken off consideration on the basis of submission of the counsel for the petitioner.
Good.
Please, Milan.
appearing for the respondents.
In this case, if my lord may kindly take up the memo along with hand sketch which I have produced
ಯಾವ್ದ್ರಲ್ಲಿ?
in WP 108065, Milan.
Memo.
Memo
Yes.
that is filed on 29 Feb 2024.
Hmm.
I have produced the sketch of the.
ಏನಿದು? What is this petition about?
My lord, first suit is filed by the respondents claiming injunction against the present petitioner's hearing. The injunction order was granted. Pursuant to that injunction order, they started to disturb our peaceful possession over our properties. Thereafter, we filed the injunction suit. Our injunctions was rejected on the count that he has obtained the injunction. Same was concurred by the.
So both of you are claiming to be in possession.
My lord, if my lord may peruse the map which I have.
Both of you are claiming to be in possession.
Yes, my lord.
Are you claiming it on base of title or only possession?
Only possession, my lord.
Possession.
On the basis of, my lord, the compromise deed executed by my vendor. On the basis of compromise decree, I am in possession of the 2 acres of land out of, my lord, 6 acre 2 guntas. And also, my lord, the writ petitions number 108065 of 23 and 108001 of 23. Those properties are far away from this property. That is observed by the
compromise. Nim claim in.
My lord, pursuant to the sale deed, my lord, we are claiming.
Then both of you cannot maintain a injunction suit simpliciter.
My lord, in my plaint, this is the cause of action wherein after obtaining the injunction, they started disturbing our possession. Therefore, we filed the suit. Our survey numbers are different. Please, my lord.
Now, Bucci Reddy Prakara, you'll have to file a suit for.
My lord, my properties are
prima
different.
facie, my lord, I proved before the trial court that, my lord, I am in possession of the 2 acres out of 6 acres 2 guntas. Both courts have concurrently held that, my lord.
There is a rival claim of title. Can a bear suit for injunction be maintainable? Ibbur suit hogutte. Very permanent injunction itkondu ಏನು ಮಾಡ್ತಾರೆ?
My lord, we have not disputed their title in respect of their property. In respect of survey number.
You are disputing.
No, my lord. They, my lord, main, my lord, cause for the, my lord, all these, my lord.
They are not disputing your title and the Mr. Raoul's statement. So no problem. Are you disputing their title?
No, my lord. Their property is far away from their plaint itself says that, my lord, their property is far away from the
identity and location is in
house. And also, my lord, there is no identity of the properties. As both the courts have held that, my lord, there is no identity. It, my lord, takes, my lord, full-fledged trial. Then only, my lord, identity of property will come into force.
Really, Mr. So both of you are not disputing each other's title.
And only, my lord, disputing is, my lord, the title in respect of, my lord, writ petition number 102671 of 2023. My lord, I have filed the suit for permanent injunction in respect of my reverend friend Pawan Dodati. My lord, wherein, my lord, the court has granted, my lord, injunction based on the, my lord, documents produced by me. My lord, those documents, my lord, they have, my lord, and even not, my lord, in spite of the order passed by the trial court, they are disturbing my possession. Thereafter, my lord, I have filed the police.
Adu will hear you. Are you disputing each other's title?
I am disputing his title, my lord, because there are no title deeds, and he is claiming title over the property based on a compromise decree which is not registered. And, my lord, under the agreement of sale, my lord, possession was not handed over, and their pleading say that possession was handed over. And under the compromise decree, they say
We'll
that
take it up
possession is
one by
already
one. Yes, for 8065, Mr. Raut.
My grievance is this much, my lord. In respect of my description of property pursuant to the injunction granted in connected writ petition, they are trying to disturb my possession. Therefore,
So,
I filed the injunction.
Concurrent finding in the suit and the first appeal.
Yes, my lord.
In all the, my lord, 3 writ petitions.
Suit status,
It is for evidence, my lord.
Yaar evidence.
I have to file, my lord, written statement in the first 2, my lord, writ petitions.
OS number 433 in status.
433, my lord,
They have to file
WP
a
number 108001 of 2023.
10?
108-001 of 23, OS number 433 of 23.
108065 ಇದೆ ನಮ್ಮ ಹತ್ರ ಫೈಲು, ಅದರಲ್ಲೂ 433 ಇದೆ.
ಅದು 434, my lord. That is 434.
By confirming the order dated by annexity by allowing IA1 and 433 ಅಂತಿದೆ. Prayer ನೋಡಿ.
ಇಲ್ಲ sir. First, my lord, writ petition, my lord.
MA 3 of 23.
MA 3 of 23, my lord.
OS 434 ಇದೆ, ಅಲ್ಲಿ ಮತ್ತೆ 433 ಇದೆ.
433 correct sir. 434 correct sir.
434 ಕರೆಕ್ಟಾ? ಏನಪ್ಪ ಶುರು ಮಾಡೋ ಒಳಗೆ 5.
434 correct.
434 ಇದು?
Yes, ma'am.
Yes. What is status of 434?
I have to file, my lord, return statement.
ಇನ್ನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ವಾ?
ಇನ್ನು ಇದು ಆ ಸ್ಟೇಜ್ ಬಂದಿಲ್ಲ ಸರ್.
ಯಾಕೆ ಬಂದಿಲ್ಲ? 22 ಸೂಟು.
22 suit, my lord.
90 days ಎಕ್ಸ್ಪೈರ್ ಆಗಿಲ್ವಾ?
Evidence ಕೈತ್ರಿ.
From date of service.
Evidence.
But as per records, my lord, return statement not at, my lord.
From date of service, then return statement not filed and matter go ahead.
It is now for evidence. Recording of evidence of PW.
Evidence.
How?
In the connected matter, it is still posted for WS.
ಯಾವುದು?
Connected matter.
433 of 23.
30.1.
ಅದರಲ್ಲಿ ಯಾವ ಸೂಟ್ ನಂಬರ್?
Suit number
108 of 22, my lord.
108 of 22.
22 ಇನ್ನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
Earlier, only one.
ಸರ್ವಿಸ್ ಯಾವಾಗ ಅಫೆಕ್ಟ್ ಆಯ್ತು?
Only one LR had filed a suit for injunction lots. Subsequently, other LRs of the original vendor has filed a lots applications, which is pending. So after that lots, now it is again posted for WS.
Other LRs are coming on record as plaintiff.
These plaintiffs LRs.
How does that impact your filing return statement?
We have filed lots. So again lots in order to give benefit to lot for us, and then again lots matter is listed for WS. Since they have come on record later on lots.
First get to know what the status is. All the counsels are directed to obtain instruction, make the submission as regard the status of the suits before the trial court. Relist on 31st.
But in my matter, there is interim order.
Interim order earlier granted is extended.
My lord, taken third, my lord.
Third.
Please.
Third or fourth.
Please.
Yes, your lordship. Yes, I am ready for arguments.
Number 4.
Yes, sir.
Bentur.
Yes. He is here.
I'm just one.
Rakesh is also here. My lord, come, my lords. We three are standing together. Three municipalities, my lord, who have been allotted 5 acres land each for solid municipalities.
Yes, Mr. Virashaki.
Yes, your lordship. Your lordship, I challenge the order of the second respondent.
Michael Matadi, Mike Dura.
Your lordship, I have challenged the order of the Deputy Commissioner Belagavi. That is second respondent. The second respondent is not following the order of this honorable court, nor the trial court, nor the Deputy Commissioner has not given single opportunity to the petitioner for submitting his grievances. Passed the order against the petitioner's property, sir. Your lordship, the petitioners and his family members are cultivating the agricultural land, and they are growing crops since 60 to 70 years, since forefathers. Till today, single person have not entered. But now, even though this honorable court passed the order without you have given the sufficient opportunity to the petitioner, and after hearing the matter, they can pass the order. But
what is your title to the property?
Title to property only cultivating the lands, unauthorized cultivating the land. Unauthorized cultivating the agricultural land and
in regularization application ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೇವೆ ಸರ್, ಹಾಕಿದ್ದೇವೆ. ಅದರಲ್ಲಿ ಅದು ಏನು ಮಾಡಲಿಲ್ಲ, ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಆದರೆ ಅವರು ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಪ್ರೀವಿಯಸ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ ಆರ್ಡರ್ ವಿತ್ ಡ್ಯೂ ಪ್ರೊಸೆಸ್ ಆಫ್ ಲಾ ಅಂತ ಅದೇನು ಫಾಲೋ ಮಾಡಲಿಲ್ಲ ಸರ್. ಅಂಡ್ ವಿತೌಟ್
ನಿಮ್ಮ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಟೇಟಸ್ ಏನು
ಕೇಳಿದೆ ಸರ್. ಇದು ನಮ್ಮ ರೆಗ್ಯುಲೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ನಮ್ದು ಇದೆ ಸರ್. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ
ಪೇಜ್.
ಯೆಸ್ ಸರ್. Even my application is also pending before the second respondent office.
Where's the application? Page number?
Yes, yes. Yes, I will see.
He has produced documents along with an application, my lords.
Yes, yes.
Yes, where is that application?
Application is here, and I have, what is annexure, sir? In page number 92, your lordship.
92.
IA number 1 ದಲ್ಲಿ, page number 92, your lordship, the petitioner filed the application before the
57.
deputy commissioner ಅನಧಿಕೃತವಾಗಿ ಅತಿಕ್ರಮಿಸಿದ ಜಮೀನಿನ ಮಂಜೂರಾತಿಗಾಗಿ ಅರ್ಜಿ.
ಏನಾಗಿದೆ ಮಿಸ್ಟರ್ ಕನ್ನೂರ್? There's annexure V, page 92.
Annexure V, sir. This application, my application is pending before the honorable court, sir.
ಇಲ್ಲ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇಲ್ಲ ಇದರಲ್ಲಿ. Where the seal? ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಮಿಸ್ಟರ್ ರೊಡ್ಡ ಶೆಟ್ಟಿ?
ಸರ್,
ಯಾವತ್ತು ಸಬ್ಮಿಟ್ ಮಾಡಿದೆ? ಡೇಟ್ ಏನು?
ಡೇಟ್ ಇದೆ, ಡೇಟ್
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
19/12/2018 ದಲ್ಲಿ ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೆ.
ಯಾರು ಕೊಟ್ರಿ?
ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
ಅವ್ರ ಸೀಲ್ ಎಲ್ಲಿದೆ?
ಎಸ್ ಸರ್, ಇದು ಪ್ರಿಸ್ಕ್ರೈಬ್ ಪರ್ಫಾರ್ಮಾ ಇದೆ ಸರ್. ಟಿಪ್ಪಣಿ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಫಾರ್ಮ್ಯಾಟ್ ಇನ್ ನಮನ
ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ
57ರಲ್ಲಿ.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿ?
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ ಸರ್. ಟೈಪ್ ಕಾಪಿ. ಎಸ್ ಸರ್, ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇನ್ ಸ್ವೀಕೃತಿ ಇನ್ annexure W ಸರ್, ಪೇಜ್ ನಂಬರ್ 95 ದಲ್ಲಿ.
W.
ಬೆಳಗಾವಿ ಜಿಲ್ಲೆಯ ರಾಯಬಾಗ್ ತಾಲೂಕಿನ ಕುಡಚಿ ಹೋಬಳಿ ಮುಗುಳ್ಕೋಡ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 738, ಕ್ಷೇತ್ರ 27 ಎಕರೆ 35 ಗುಂಟೆ
ಏನಾಯ್ತು? annexure W
ಕ್ಷೇತ್ರದಲ್ಲಿ ಅನಧಿಕೃತ ಸಾಗುವಳಿ ಸಕ್ರಮಣಕ್ಕಾಗಿ ರಾಮಪ್ಪ ಯಮಣಪ್ಪ ಪಿಟಿಷನರ್ ತುಗುದಲ್ಲಿ ಅವರಿಂದ ಅರ್ಜಿ ಸ್ವೀಕರಿಸಲಾಗಿದೆ. This is the, yes sir.
If this is still pending, you could not allot to anybody.
Yes sir, yes sir.
If it is post, then only. So next week you let us know whether.
Yes sir.
Learned AGA seeks.
Just one submission. My lords may pass that order itself, but place my submission on record. Previously, he instituted a suit also, and also a writ petition before this honorable court not to dispossess him. Suit has been dismissed, which has now reached this honorable court in an RSA pending. Thereafter, my lord, the deputy commissioner has allotted 5 acres each out of the entire extent of 27 acres.
How can he allot without passing orders?
That my lord, they have to answer. But my only grievance is now, because of the orders passed by NGT and so many my lord, communications being passed, because there was an immediate necessity for solid waste management. But lands which are totally open have been once.
Have immediate necessity doesn't mean you'll override.
No, not in that. My submission, I'm distinguishing it on this ground that which was uncultivated, which was barren, that has been allotted to us. In that regard, this honorable court previously in this writ petition had passed an order to hold a survey and submit a report before this honorable court. That is also submitted. Now what happened?
What has happened to annexure V?
That our here, but he claims to have been cultivation of entire 27. That is not the case, is what I am submitting.
He may claim rightly or wrongly.
Please.
Order has to be passed.
Yes.
Without order being passed, it cannot be given.
That proposition I cannot because his rights have to be first determined.
AGA,
if any,
seeks for and is granted a week's time to obtain instruction, make a submission
no.
to the status of the application submitted by the petitioner under Form 57 in Annexure V at page 92 to IA 1 of 24, which has been acknowledged to have been received on 19/12/2018 in terms of Annexure W at page 95 thereof. Relist on
one submission, my lord.
Fourth.
One submission, my lord. The application filed by the petitioner only to the extent of 4 acres 10 guntas that was clearly mentioned. Now he is contending that entire survey number, the other petitioner already they have vacated the suit premises, and the deputy commissioner pleased to grant the for dumping the garbage of the society. Now he is obstructing our position. The report
interim order, my lord, he is this 4 acres ಅಲ್ಲಿ ನಿಮಗೆ ಏನಾದರೂ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ, ನಮ್ 4 acres ಕೊಟ್ಟಿಲ್ಲ.
You are not.
We are.
So that report may be perused. It may clarify something.
The report
is on the file of this.
You are not questioning his 4 acres.
We are not disturbing his position. My lord, the report submitted by the survey department, wherein that was specifically contended that ABCD that was clearly mentioned in the rough.
one submission, Your Lordship. They are entering it
Commissioner report.
in the land of the petitioner, sir. They are destroying the standing crops of the petitioner.
4 acres 10 ಗುಂಟಸ್ ಅಷ್ಟೇ ನೀವು ಕ್ಲೇಮ್ ಮಾಡಿರೋದು.
ಅದರಲ್ಲಿನೇ ಬರ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ ಅವರು. Even though this honorable court already granted the interim order, sir, not to dump the garbages, but they are dumping the garbages and they are forcibly, sir.
Where is the survey report?
Sir, report ಯಾವತ್ತು?
ಯಾವ ಕೋರ್ಟ್?
File ಮಾಡಿಲ್ಲ. Last time ಮಾಡಿಲ್ಲ. It is read, but file is not.
Already.
Last hour ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
Serial number 33. HDMC, Lord, they have already argued, I have completed the argument, your lordships have already expressed. Only we may probably seek for some liberty, my lord, in that matter. Otherwise, everything is over.
We'll come and take.
Lord, only thing is, Lord, 2:30, I have a partner, man.
Mr. Adjournment will be there.
Please, that's all.
Serial number 32, I seek a week's accommodation due to my personal inconvenience.
Inform ಮಾಡಿದ್ದೀರಾ ಎಲ್ಲರೂ?
Inform ಮಾಡಿದ್ದೀನಿ.
For respondent. Can be taken on Thursday.
Next week, any date, my lord.
For R5 minutes. This is a tangent, there is an urgency in the matter.
Monday or Tuesday, any date, my lord.
32 at the request of counsel for the petitioner released on 4th.
Please.
It is made clear that
Please.
there will be no further adjournment which would be granted if arguments are not advanced by the petitioner. Petition would be liable to be dismissed for non-prosecution.
Please.
Interim order earlier granted is
ಇಲ್ಲ
extended.
ಅದು absolute ಇದೆ. Absolute.
ಮತ್ತೆ vacating.
But serial number 95, my lord directed the deputy commissioner to submit a report in that it is regarding, my lord, PDO endorsement, my lord.
ಅದರದ್ದು
Government check.
receive. We'll take it up.
List number 2, my lord. Serial number 4, day after tomorrow.
List number 2, CL number 4.
Day after tomorrow.
Inform ಮಾಡಿದ್ದೀರಾ?
Please, tell him correct.
At the request of counsel for the petitioner released on 29th.
Serial number
Interim order earlier granted is extended.
serial number 65, my lords. I'm on behalf of RR Mani, my lords, appearing for respondent number 1, my lords. Recently undergone surgery, my lords. Kindly
Petitioner inform ಮಾಡಿದ್ದೀರಾ?
I will inform, my lord.
Will ಬೇಡ. Inform ಮಾಡಿ.
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ಇನ್ನು.
Inform ಮಾಡ್ಬಿಟ್ಟು 2:30 ಮೆನ್ಷನ್ ಮಾಡಿ.
Obliged.
List number 2, 4. ಸರಿ.
Dharwad bench matter, 230 matter. Serial number 96.
Sir, I have filed an application for Impleading 7 to 29, my lord. These are the parties to the OS number 58/2007. I have filed the document, certified copy of the judgment passed in OS number 58/2007.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ತಗೊಂಡಿದ್ದೆ
ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತದೆ
ಆಗಿದೆಯಾ
ಪಾರ್ಟಿ ಇಂಪ್ಲೀಡ್ ಆಗ್ಬೇಕಾಗ್ತದೆ ಅದ್ರಾಗ ಯಾಕಂದ್ರೆ ಆ ಒರಿಜಿನಲ್
ಸೊ ಅದೇ ಆಲ್ ದಿ ಕ್ಲೀನ್ ಅಪ್ ಸೊ ಇವಾಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ನೀವೇ ಅಪಿಯರ್ ಆಗ್ತೀರಾ
ನಾನು ಅಪ್ರಿ ಆಗ್ತೇನೆ ವಕಾಲತ್ತು ಹಾಕಿದ್ದೀನಿ ಸರ್ 7 to
as respondent you have filed it as any objections
since last 3 to 4 days it has been going on for compliment. There are 30%.
hopefully let us finish it now IA number 1 of 25 has been filed for impleading respond number 7 to 29 in the present proceedings on the ground that they are
parties in OS number 58 for
there were parties in OS number 58 of 2007 and FDP number 12 of 2015. Bari OS, sir. OS number 58 of 2007 and have not been arrayed as respondent by the petitioners herein. The submission of Shri S.L. Matti, learned counsel for the impleading applicants, is that those persons also have an interest in the subject matter of the above petition, and as such, they are both proper and necessary parties. There is no particular objection on part of the petitioners to the said application and contention. As such, amendment and file amended cost title. Registry is direct print the name of Shri S.L. Matti as that appearing for respond number 2, 7 to 29.
And also I have filed the wakalat on behalf of dependent respond number 1A, 1B.
Then memo for treating R2 to R5 as legal heirs. During the pendency of the above matter, respond number 6 expired.
ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ
ಸರ್ ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆ
ನಿಂತಿದ್ದು
ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಅಬೌವ್ ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಸರ್ ಬರ್ಕೊಂಡಿರೋದು ಅದು
ಅಲ್ಲ IA 1 of 25 ಕ್ಲೋಸ್ ಆಯ್ತಾ
ಅದು ಕ್ಲೋಸ್ ಆಯ್ತು ಸರ್
Okay. During pendency of the above matter, respond number 6 is expired. Hence, a memo dated so blank has been filed by counsel for respond number 3 to 5, stating that respond number 2 to 5 are the only legal representatives of deceased respond number 6. Accepting the said memo, respond number 2 to 5 are treated as the legal representative of deceased respond number 6. Counsel for the petitioner to make a necessary endorsement in the cost title. Then documents ಏನಕ್ಕೆ ಇದು
The OS certified copy of the OS
memo
It is a suit for partition and separate possession. Ours is some of the
we'll take it on record. There's a memo filed to place on record certain orders passed by the trial court. The said memo is taken, said memo along with document is taken on record.
I have filed the power on behalf of the respond number 1A and 2.
Respond number 1A na. Respond number 1 served ಆಗಿತ್ತು ಅವ್ರ legal heirs ಬಂದ್ರ ರೆಕಾರ್ಡ್ಗೆ
1A and 1.
one neighbor currency, I will make them application.
ನೀವು ಬದಲು let Mr. Matti file.
They all
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅಲೋ ಮಾಡ್ಬೋದು It can be immediately allowed so that ಯಾವ file ಮಾಡ್ತೀರಾ? R1 now. R6 deleted. 3 to 5 ಆಯ್ತು. R2 ಇದ್ದಾರೆ. ಅಷ್ಟೇ ಅಲ್ವಾ? R1 ಗೆ you will file an application.
I have filed ವಕಾಲತ್ on behalf of respondent 2 also.
Application ಇಲ್ಲದೆ ಹೆಂಗೆ?
2 only.
2 already ಇದೆ. 1 ಮಾಡಬೇಕು. It is submitted that respondent number 1 is expired. Both the counsel seek for and are granted a week's time to file necessary application, bring the legal revenue of deceased respondent number 1 on record. Relist on 5th February. ಇಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮಾಡ್ತೀರಾ? 5th February. ಅದಾಗಿ ಮತ್ತೆ ಇನ್ನೊಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿ ಆಮೇಲೆ ಕರಿಬೇಕು ನೀವು. 5th ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಡೇಟ್ ಆಗಿ.
Pass over matters. Serial number 4, R.K. Sundarraj.
Office has raised, my lord, further office objection, my lord. Annexure E is the, my lord, mutation, my lord.
Vishwanath Hegde and Tanuja Hegde have entered appearance for the petition. Registry that lead name Shri R.K. Sundarraj and S.S. Shettamnavar as that appearing for the petitioner. Shri Hegde seeks for and is granted a week's time to comply with the office objection.
My lord, no, compliance, my lord. Annexure E is the mutation entry, my lord. It is legible and readable, my lord. It is used for reference only, my lord. My lord, annexure E, my lord, page number.
Copy of annexure E. Page.
My lord, page number 24.
Not legible.
ನಾನು ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕ್ತೇನೆ ಸರ್.
ನೀವು ನಿಮ್ಮ ಕೈಲೇ ಓದಿಸ್ಬೇಕು ಇದನ್ನ.
ಅಲ್ಲ ಅದು ಓನ್ಲಿ ಫಾರ್ ರೆಫರೆನ್ಸ್, ಮೈ ಲಾರ್ಡ್. ಮೈ ಲಾರ್ಡ್, ದಿಸ್ ಇಸ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅಂಡರ್ ದಿ ULC Act is challenged, my lord. That mutation, my lord.
Counsel for the petition seeks for and is granted a week's time to comply with the office objection at CL number 33/11. Released on 7th February.
Please.
7, A.S. Patil.
Filed.
Respondent number 4, my lords.
During the pendency of the above matter, respondent number 4 expired on
4/5/2021.
4/5/2021. As such, IA 1 of 25 has been filed. Issue notice on IA 1 of 25, returnable by 26th March. Amendment ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಮಿಲ್ಟ್ಸ್ ಮಾಡಬೇಕು.
In the meanwhile, amendment to be carried out and amended cause title to be filed.
Please, your lordship, please.
Records ಏನಾಗಿದೆ? And AGA seeks for and is granted 4 weeks time to secure the records.
Please.
ಇದರಲ್ಲಿ 7.1
ಅದರ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಬೇಕು.
Same
ಸೇಮ್ ಆರ್ಡರ್, ಸೇಮ್ ಪಾರ್ಟಿ, ಸೇಮ್ ಡೆತ್. ಅಪ್ಲಿಕೇಶನ್ ಹ್ಯಾಸ್ ಟು ಫೈಲ್, my lords.
Has to file.
ಹ್ಯಾಸ್ ಟು ಫೈಲ್, my lords.
ಯಾಕ್ರಿ ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡಿ?
ಇಲ್ಲ my lords, ಅದು ನಾವು ಓವರ್ ಸೈಟ್ ಆಗಿ ಮಾಡಲಿಲ್ಲ, ಒಂದರಲ್ಲೇ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಓಕೆ, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡೋಣ.
Please, your lordship. Please, your lordship.
31, Doddavir Shetty.
Extent of his
Been
point.
conducted.
That has been conducted. Map is also prepared. In between, yes, or the product. This is the my lords, may kindly observe this.
ಫೈಲ್ ಆಗಿದ್ಯಾ
Our file ಮಾಡಿ.
ನೀವು ಪಕ್ಕದಲ್ಲಿ ನಿಮ್ಮ ಜೇಬಲ್ಲಿ ಇಟ್ಕೊಂಡು ಏನ್ ಪ್ರಯೋಜನ ಫೈಲ್ ಆಗ್ಬೇಕು.
ಫೈಲ್ನು ಆಗಿಲ್ಲ ಮತ್ತು ಸರ್ವೇನೂ ಆಗಿಲ್ಲ ಸರ್, ಅದು ಪ್ರೈವೇಟ್ ದೊರದು ಮಾಡ್ತಾ ಇದಾರೆ, ನಮಗೂ ಇನ್ನೂ ಕಾಪಿ ಕೊಡ್ಲಿ. ಅವ್ರು ಪ್ರೈವೇಟ್ ಮನುಷ್ಯರಿಗೆ ತಂದು ಸರ್ವೆ ಮಾಡ್ಕೊತಾ ಇದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಸರ್ವೆ ಗವರ್ಮೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸರ್ವೇನೇ.
This is a government survey done under the auspices of.
ಸರ್ವೆ ಆಯ್ತು
ಲ್ಯಾಂಡ್ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಆಗ್ಬೇಕು ಸರ್.
ಇನ್ ದ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದ ಪೆಟಿಷನರ್.
ಮತ್ತೆ ನಮಗೆ ನೋಟಿಸ್ನು ಇಲ್ಲ ರೀ ಅದರಲ್ಲಿ. ವಿಥೌಟ್ ನೋಟಿಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ವಿಥೌಟ್ ನೋಟಿಸ್ ಟು ಸರೌಂಡಿಂಗ್ ಪ್ಲೇಸಸ್.
ಇಲ್ಲಿ ಸ್ಕ್ರೀಚ್ ಆಗಿದೆ.
ಅವ್ರು ಹೇಳಿದ್ರೆ ನೀವು ಸಿದ್ಧಿಗೆ
ನಿಮ್ಗೆ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
It's audible, sir.
ಪೂರ್ಣಿಮಾ?
Yes.
Learned AG seeks for and is granted a week's time to obtain instruction, make his submission as to whether the application form number 57 filed by the petitioner has been considered in necessary orders passed. If so, to produce the said order, as also to place on record the joint survey carried out of the subject property, released on 6th February.
Interim order make.
Interim order earlier granted is extended.
My lords, may say survey in terms of the order dated 30/10/2024 passed in this writ petition.
Survey in terms. Can be taken on 4th. Survey in terms of the order dated 30/10/24.
Yes.
Released on 4th.
Yes.
Please.
33 G.A. Gachinmat.
ಏನು?
Matter, my lords, senior advocate Kannur has already made his submission.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? What is the liberty that you want?
My lords, liberty, my lords, to file such other applications, my lords, as permissible and law. Liberty, my lords, to file interim application, my lords, as is permissible.
In both the above matters,
Lords, in one case, my lords, there is a direction has been sought to deposit the rent, my lords, in favor of the corporation. One writ petition, my lords, is to stay. Of course, my lords, that has ended up, my lords, still RSA, and therefore that could not be entertained. But the other writ petition, my lords, is for depositing the rent, my lords, to the corporation, not the person, my lords, who has.
by whom? Rent by whom?
My lords,
By your lessee?
Yes.
Original lessee?
Original lessee.
Party ಇದರ ಇದರಲ್ಲಿ?
Idhar.
I'm appearing, my lord. My lord, I move.
He has sold that property in favor of him,
My lord.
being a lessee. And my lords, he wants to evict the person, my lords, in whose favor the subless has taken place by the original lessee. So, my lords, they are not entitled to take any rent, my lords, is the second petition.
I'm not taking any rent, my lords. Till sell, my lords.
I'm entitled.
Have you paid HDMC the rents
I have paid the entire rents till date, my lords.
till date?
Till date illa. Andre what he contends is that
Till I have sold the property.
till he
to-
sells.
After that what?
After that, my lords, he being the lessee, he is supposed to.
And in RSA, my lords, there is a direction.
You have to pay.
Then, my lords, it may be taken tomorrow. I will take instruction with regard to payment of rents.
If he has paid, my lords, it is for him to pay, my lords. Now he has to say.
My lord, I am.
Why do you want to recognize him? ಮತ್ತೆ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ?
Damages at least, my lords, if not in the form of rent for occupying the premises.
Please apply your mind properly and see what is to be done. Don't create further complications. Only Mr. Betterment will have to pay everything. If you accept your submission, then some collusion between your officers and them and Bharat.
Please.
If they have instructed to you to make that submission, then it can only indicate collusion between your officers and the purchaser.
Not like that.
That is what will give.
I will leave it to you,
By
lords.
that you are accepting is right.
Then I will leave it to you, lords. I will not press it.
The original lessee has to do it.
Yes.
33. Petitioner HDMC is before this court seeking for the following reliefs. The HDMC claims to be the owner of the land in CTS number 442 stroke B stroke 1 MF, CTS number 442 stroke B2 stroke MF, CTS number 443 stroke 1 MF, all of which are adjoining each other and situated at Subhash Road, Vivekanand Circle, Market Fort area, Dharwad. The said properties were leased by the HDMC to one Shri Kalandar Walad Mahbub Sahib, Dasan Koppa, by the municipal borough under a registered lease deed dated 24/9/1954 for a period of 99 years on certain conditions. It is contended that the lease was personal in nature and could not be assigned in any manner whatsoever. After the death of the original lessee, aforesaid original lessee, the names of his legal representatives who are defendants 1 to 6 in OS number
119 was 2.
OS number
119
119 of 2020, pending on the file of the third additional civil judge, bracket junior division Dharwad, were entered into in the CTS extract as lessees on account of devolution of the lease on an hereditary basis. It's alleged that the said defendant number 126 have illegally and unlawfully without any right sold stroke assigned their leasehold rights under a sale deed dated 19/6/2010 to defendant number 7 therein, who is respondent number 7 herein. The same being styled as a sale deed. Contending that the defendant number 1 to 6, who are respondent number 1 to 6 herein, could not execute such sale deed, and that the same has no legal sanctity which would amount to a breach of the lease condition of the lease deed dated 24/9/1954. The corporation has a right to forfeit the lease. The HDMC issued a notice to defendant number 1 to 7 terminating the lease and calling upon them to hand over the possession of the suit properties. Defendant number 1 to 7 are alleged to have given false and evasive replies and did not hand over the possession. In view thereof, the petitioner, the HDMC, filed two suits in OS number 118 of 2020 and another in OS number 119 of 2020 before the third additional civil judge junior division Dharwad, seeking for vacant possession of the suit property. The corporation also sought, HDMC also sought for declaration that the alleged sale deed executed by defendant number 1 to 6 in favor of defendant number 7 is illegal, null and void, and not binding on the plaintiff. Service having been effected, the defendants have entered appearance, filed their written statement. In the meanwhile, defendant number 7, it is then that the SDMC came to know of defendant number 7 having filed a suit in OS number 78 of 2013 against the husband of defendant number 8 therein, who is a subtenant of the original tenant. Mehboob Saab, Kalandar Walad Mehboob Saab Dasan Kopa, which has been decreed and confirmed in RA number 10 of 2019. The tenant, subtenant having filed a second appeal in RS number 100-711 of 2019, the same was withdrawn. It is in that background that the SDMC filed an application IA number 6 under section 151 of the Code of Civil Procedure seeking for deposit of rent by defendant number 7 before the trial court.
Defendant number 8 to 13. Defendant number 8 to 13. They have filed
8 to 13.
application.
8 to 13 who are the subtenants before the trial court. The said application came to be rejected by the impugned order dated
1/6/2024.
1/6/2024.
1/6/2024.
On the ground that there is no pleading, no court fee is paid, no relief is sought.
On the ground
Page 180, paragraph 11.
that the plaintiff SDMC has neither averred in the plaint nor prayed for any amount in the plaint. There being no pleading regarding any amount, such an order could not be granted. It is the trial court further observed taking note of the decree in OS number 78 of 2013, that defendant number 8 to 13 would have to pay the arrears of rent and future rent to defendant number 7, which has been confirmed, and as such no direction could be issued to defendant number 8 to 13 to make payment of any rentals to the petitioner SDMC. It is challenging said order that the petitioner SDMC is before this court seeking for the aforesaid relief. Shri Gurudas Kannur, senior counsel, would submit that the rentals which are being paid by respond number 8 to 13 to respond number 7 is to the debt.
To the corporation.
In the court.
Court.
It is deposited in the court.
ಅಲ್ಲ ಇಲ್ಲಿ ಅವ್ರು ಕೇಳಿದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ.
In RSA, it has been deposited, my lords, at page number 163.
That amount is deposited in education 25/19.
Page number 163.
ಅದು ಇಲ್ಲಿ ಡೀಲ್ ಮಾಡಿಲ್ಲ.
Deal ಮಾಡಿಲ್ಲ.
That's not been referred to here.
It is there in the order, my lords.
Arrears of rent and rent of rupees 50 per month to the present defendant number 7 till handing over vacant position to the plaintiff ಅಂತಿದೆ.
Said order.
Gets finality after disposal whether the present is neither averred and not provisional to when the. So you are depositing it in execution.
Education 25 or
filed by so. Defendant number 7 could not be paid to defendant number 7.
Earlier, this amount was deposited before this put in RSA.
Hmm.
Immediately after the disposal, the amount is sent back to the executing court. In
Number 163 may kindly be sent.
And as such, no direction could be issued to defendant number 7. The defendant number 7 does not have any right, title, or interest, inasmuch as the sale deed executed by defendant number 1 to 6 in favor of defendant number 7 is non-est. There being no right on part of defendant number 7 to collect any rentals, the rentals would have to be paid only to HDMC, and as such he submits that the order passed by the trial court is not proper and is required to be set aside. Shri S.S. Beturmat, learned counsel, appearing for respondent number 1 to 6, submit that the respondent number 1 to 6 have not received any rentals.
We have not received, it is deposited.
Shri
It is deposited in exhibition.
MP Kulkarni
Yes.
also submit that respondent number 7 has not received any rentals. In pursuance of the judgment in RSA number 100711 of 2019, execution proceedings have been filed
Yes.
by respondent number 7 against respondent number 8 to 13. Respondent number 8 to 13 are depositing the rentals in the execution proceeding in execution number 25
21/19.
of 25/19.
25/19.
And as such, he submit that the deposit having been made in the execution court, there could not be any further direction to deposit the rentals in OS number 119 of 2020. Shri S.S. Beturmat, appearing for respondent number 1 to 6, submits that until the assignment was made by respondent number 1 to 6 to respondent number 7,
Till assignment, my lords, the respondent number 8 to 13, we are depositing rent.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
Navenal, we are initially we are given lease to the respondent number 8 to 13, my lords.
Shri S.S. Beturmat, learned counsel for respondent number 1 to 6, submit that the payment of rentals is the responsibility of respondent number 8 to 13, who are the sublessees, and they had been making payment of those rentals to the HDMC until the assignment made by respondent number 1 to 6 in favor of respondent number 7. And thereafter, in the execution proceedings, the deposit has been made in the execution proceedings. Similarly, the submission made by Shri
Vinay Kaujali.
For 8 to 13.
ಶೀಲ್ವಂತ ಹೆಸರು ಮಾತ್ರ ಇದೆ, ವಕಾಲತ್ ಇದೆಯಾ?
I have filed, madam.
ಇದೆಯಾ? ಶ್ರೀ ವಿನಯ್ ಕೌಜಲ್ಗಿ ಅಪೇರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9. ಇಲ್ಲಾರೆ ಎಲ್ಲ ಹೆಸರು ಬರುತ್ತಲ್ಲ.
8 to 13.
Respondent number 8 to 13. Shri MP Kulkarni, learned counsel for respondent number 7, would submit that respondent number 7 having filed eviction proceedings against respondent number 8 to 13, respondent number, until the suit is decided, otherwise and against respondent number 7, the decree passed in favor of respondent number 7 can be enforced by respondent number 7 against respondent number 8 to 13. And as such, he submits that the above petition may be dismissed. Heard so and so perused document. Admittedly, HDMC is the owner of the property. Admittedly, HDMC had only leased the property for a period of 99 years to
The father of respondent number 1 to.
father of respondent number 1 to 6. Thus, the father of respondent number 1 to 6 only had leasehold right, which is succeeded to by respondent number 1 to 6. The sale, as contended by the petitioner and the respondents, could only be the sale of the leasehold rights and not sale of the property, the title of the property continuing with HDMC. Insofar as the leasehold rights are concerned, respondent number 7, now stepping into the shoes of the original lessee, has now sought to evict respondent number 8 to 13, who were the sublessees of the original lessee. Any such eviction of the sublessees would anyhow to benefit of the HDMC. It therefore cannot be said that respondent number 7 cannot seek for eviction of the sublessees. Insofar as the rental is concerned, it is for the HDMC to establish the rentals, mean profits or damages in pursuance or in furtherance of establishing a valid termination of the lease and or forfeiture of the lease. Until the same is done, HDMC would be only entitled to the rentals under the original lease of the year 1954, which would be required to be paid by defendant number 7. Respondent number 7 who seeks to evict respondent number 8 to 13. Needless to say, in the event of the HDMC succeeding in the proceeding for damages stroke mean profits, respondent number 7 would also be liable to make payment of the same. Thus, at this stage, as rightly held by the trial court, there could be no direction to the sublessee to deposit the rentals with the HDMC. The deposit being made in the execution proceedings will inure to the benefit of HDMC also, which shall be subject to the result of the suit in OS number 119 of 2020. Hence, 118 and 119 of 2020.
If at all the prisoner has got any right and etc., let him file contest the matter and get to that.
Yeah, the 118, 119 is filed already.
They have to establish.
Once that is done, any decree or judgment passed in OS number, any judgment and decree passed in OS number 118 and 119 of 2020 would be binding on respondent number 7. In that view of the matter, reserving liberty to the petitioner HDMC to take up all such contention against respondent number 7 as is available under law, the petition stands dismissed.
Allah sir,
ಇನ್ನ ಸ್ವಲ್ಪ ಒಂದು 5 ವರ್ಷ ಮಲಗಿ ಎದ್ದಿ.
The documents in that expeditious
33.1 ಏನು?
Day of execution. Execution. Order 21, Rule 29.
Your Lordship's my lord had Order 21, Rule 29.
Stay of the proceedings.
Yes.
33.1, petitioner HDMC is before this court seeking for the following reliefs. The facts in the present matter are identical to that in WP number 104649 of 2024. In the present writ petition arises out of the impugned order dated 1/6/2024, passed in OS number 119 of 2020 and 118 of 2020 on IA number 5, wherein the third additional civil judge in JMFC Dharwad rejected the application of the petitioner under Order 21, Rule 29. In IA number 5, seeking for stay of the execution of the judgment decree in OS number 78 of 2013, filed by respondent number 7 herein against respondent number 8 to 13. The contention of Shri Gurudas Kanur and senior counsel appearing for the petitioner is that the ownership being vested with HDMC, the so-called assignee of a lease, which is illegal and honest, could not maintain a execution proceedings for eviction against respondent number 8 to 13 when HDMC itself is seeking for eviction of respondent number 7. And as such, he submits that if the respondent number 7 were to receive the possession from respondent number 8 to 13, grave loss, hardship and injury would be caused to HDMC, which has not been considered by the trial court. Shri MP Kulkarni appearing for respondent number 7, the decree holder, in OS number 78 so and so, arising out of which execution petition number 25
or 19.
of 19 have been filed, submit that so long as the lease, the assignment of lease in favor of respondent number 7 is not set aside, respondent number 7 is entitled to exercise all its right over the leasehold property, including the eviction of the lessees, sublessees, respondent number 8 to 13 in terms of decree in OS number 78 of so and so. Shri Vinay Kaujalgi, appearing for the sublessees, would submit that the sublessee would be bound by any order passed in the execution proceedings.
Sir, two submissions, sir. Order 21 Order 21 Rule 29 applies only when judgment debtor files a suit against the decree holder. Then only Order 21 Rule. Then one other point, sir.
The other submission of Shri MP
application-
Kulkarni is that that an application under Order 21 Rule 29 can only be filed by a judgment debtor against a decree holder and not by a third party to the proceedings. Heard so and so peruse papers. As held in OS, as held in today's order passed in WP number 10649 of 2024, the facts of ownership of HDMC and the lease are not in dispute. OS number 118 and 119 have been filed for the reliefs as sought for therein. Until those reliefs are granted against respondent number 7, the HDMC cannot exercise any rights against respondent number 7. Insofar as eviction of respondent number 8 to 13 are concerned, even if respondent number 7 were to evict respondent number 8 to 13, such eviction and possession being vested with respondent number 7 shall inure to the benefit of the landowner, HDMC, since respondent number 7, as admitted, is only a lessee. As admitted, can only claim the right of a lessee and not as owner of the property. Ownership continuing to always vest with HDMC. In that background, until necessary judgment is passed in favor of the HDMC in OS number 118 and 119, the question of the HDMC restraining respondent number 7 from evicting respondent number 8 to 13 would not arise. The respondent number 7 would be entitled to evict respondent number 8 to 13 and take on the possession in itself. Insofar as the apprehension on part of Sri Gurudas Kannur Learned Senior Counsel that respondent number 7 may further deal with the property by further leasing, subleasing, or the like of the property is concerned, it is for the HDMC to file necessary application in relation thereto to maintain the property in status quo pending the resolution of OS number 118 and 119, which will have to be considered by the court seized of the matter in accordance with law. In that view of the matter, no grounds being made out, reserving liberty to HDMC as aforesaid, the petition stands disposed.
Expeditious disposal. And one more subject.
The suit of 2020, there are suits of earlier vintage, pending IA stand disposed.
Any observation made should not prejudice.
We have not made any observation against you. In fact, observation all against defendant number 7.
34, Sadiq Kanvi.
My lord, this petition, it has to be classified as JMRES since it is the proceedings arising out of the Maintenance and Senior Welfare Citizen Act 2007. Assistant Commissioner.
Filed by?
Filed by petitioner. It has been classified as JMCPC.
Filed by the daughter?
Yes, my lord.
Maintainable,
Yeah.
glad to be.
Maintainability, my lord, so this section 16(1) prakaram.
And
DC
writ petition is also is not
DC
maintained.
appeal to the section 61.
Well, it is
Division bench has held
Coordinate
against.
judgment.
Division bench has held against.
Well, following the Supreme Court judgment, this court has passed an order.
Yeah.
Reported judgment. Sunita.
Yes, yes, ma'am.
Sunita ji.
Following the Supreme Court judgment.
Idella old story.
The assistant commissioner has passed the impugned order without jurisdiction, my lords. Petition
That
of
we'll consider. First, we'll have to reclassify it.
Yes.
like
What is under challenge in the present proceedings is the order passed by respondent number 2, Assistant Commissioner, under the maintenance and welfare of senior citizens so and so act. The same cannot be classified as GM CPC, but would have to be classified as GM res registry as indicated by the petitioner in the petition. However, it is the registry who has classified it as GM CPC. Registry is directed to rectify the same. Shri Venkatesh Karvi appearing for respondent number 3. Mother,
Yes,
mother senior citizen.
Yes,
mother-in-law, my lords.
Mother-in-law senior citizen.
Yes.
Mother-in-law na mother?
Mother-in-law. She is
ಎಲ್ಲದಕ್ಕೂ
the daughter-in-law, my lords.
ಎಲ್ಲದಕ್ಕೂ ಅಂತೀರ. Mother-in-law senior citizen submit that since the order has been passed by the assistant commissioner, the petitioner has an alternative efficacious remedy in terms of subsection 1 of section 16 before the deputy commissioner. The division bench of this court recently in Lokesh versus so-and-so has held that the right to appeal under subsection 1 of section 16 is only available to a senior citizen or a parent and not to anyone else. In that view of the matter, the petitioner would not have any remedy of appeal before the deputy commissioner. No appeal having been provided under the Senior Citizens Act for a person otherwise than a senior citizen or a parent. The only remedy that would be available is a writ petition. As such, the above writ petition being maintainable, the contention of Shri Venkatesh M. Karvi, Learned Counsel for respondent number 3 is rejected. Relist on, registry is directed to reclassify and relist on, relist before the concerned roster court at the earliest.
Please.
Oblige.
Yes, early over.
35, Vital Teli.
Interim order में कैली
34, interim order earlier granted is extended.
Writ petition challenging the order passed by the State Minority Commission.
Yes.
Notes the petitioners herein father ancestors were tenants of RS number 757. And my lords, in view of the Karnataka Land Reforms Act coming into force, my lords, filed a form, the land stood vested with the government. Thereafter, my lords, form number 7 came to be filed by the father of the present petitioners. My lords, land tribunal by its order dated 28/12/1981, my lords, granted occupancy rights. And in the year 1982, form number 10 came to be issued, my lords. Thereafter, my lords, around 5 to 6 survey numbers were, my lords, in the form number 7 it was. Not so far as 3 survey numbers, one of the owner preferred a writ petition before this honorable court, matter remitted. However, my lords, the contesting respondents further herein did not challenge the order of a land tribunal. My lords, in the year, my lords, very recently, my lords, that is in the year 2019, he, my lords, filed appeal before the State Minority Commission, that is the, my lords, at page number 80, that is page number.
Who filed it? This is as regards survey number
757.
757.
Please.
A number hangge continue agide.
Hangge continue. That remained intact. In so far as, my lords, I have filed, my lords, the present petitioner's father has filed for number 7 in respect of, my lords, almost around 10 properties. That is at page number 31. That is the form, my lords, the land tribunal order. So far as, my lords, 757 remained intact. Notice the owner of 32, 32A and 33 preferred a writ petition before this honorable court. This honorable court allowed the writ petition and remanded back. But however, my lords, the contesting respondents further herein, my lords, he did not challenge that order. Thereafter, my lords, appeals were filed before the assistant commissioner, deputy commissioners. All appeals he failed. Thereafter, my lords, moved an application before the Karnataka State, my lords, Minority Commission My lords, I was not made, petitioners were not made as a party. My lords, the minority commission, my lords, at page number 69 is the impugned order.
Yes.
My lords, 69, my lords. My lords, I was not made a party, my lords. Thereafter, my lords, operative portion, my lords,
What is the order?
my lords,
recommendation
ಈ ಆಯೋಗ ಸಲ್ಲಿಸಿದ ದಾಖಲೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಕೊನಗೋಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ರಿಸಾ ನಂಬರ್ 757ರಲ್ಲಿ ಶ್ರೀ ಬಾಬು ಪೀರು ಮಗ್ದುಮ್ 5 ಎಕರೆ 22 ಗುಂಟೆ ಮತ್ತು ಅನುಗೊಂಡ 3 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಅಧಿಕೃತ ಕಬ್ಜಾದಾರರೆಂದು ನಿಂದಾಯಿಸಿದಾಗಿ ಸಾಬೀತುಪಡಿಸಿರುವುದಿಲ್ಲ ಪಡಿಸಲಾಗುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಬಾಬು
How can the minority commission pass this order, madam?
it is not an order, my lord, it is only recommendation to the deputy commissioner,
Can
that
they
is the
even
respondent.
recommend that
Pardon, my lord.
without you having challenged 757?
I will submit that here, that your lordship.
Yes.
My lords, this is the order, my lords. My respectful submission for my lords is, my lords, I will take my lords to the, my lords, page number 39 for a moment, annexure E. My lords, where the contesting respondents further, my lords, has collected a premium of 2,000 rupees. My lords, typed copies.
Yes.
By this order, my lords, the special Tahsildar has passed, and my lords, he has collected 2,000 rupees at page number 48, 4 comes, typed copies at next page, my lords. Lords, once he has collected this premium, lords, his right stands extinguished. Lords, my one more contention for my lords is the order is without jurisdiction. Secondly, my lords, I was not made up.
757,
No appeal.
no appeal.
No writ petition.
Form 7 is not challenged.
Not challenged.
In further Form 7, Form 10 issued.
Issue.
In further Form 10, the compensation received. Thereafter,
Thereafter, preferred appeal before assistant commissioner. He dismissed it. Deputy commissioner, he also dismissed it. Thereafter, my lords, they went to the state. My lords, the respondent has filed a statement of objection contending this land was granted under the Karnataka Village Officers Abolition Act. And they contend under section 5, it amounts to their self-accountability. But however, section 8 provides, lords, I will take my lords to the section 8 of the Karnataka Village Officers Abolition Act, where my friend has taken a contention. Section 8 of the Karnataka Village Officers Abolition Act 1961, my lords.
yes.
My lords, section 8, application of tenancy laws. If any land granted or continued in respect of or annexed to a village office by the state has been lawfully leased and such lease is subsisting on the appointed date, the provisions of tenancy law for time being in force in the area in which land is situated shall apply to the said lease, and rights and liabilities of the person to whom such land is granted under section 5, 6 or 7 and his tenant or tenants shall, subject to the provisions of this act, be governed by the provisions of any said tenancy law. Notes, here in my case, my lords, according to the respondents herein, my lords, originally, my lords, this property was granted in favor of Abdul, my lords, that is the father of the contesting respondents, on 25/1/1967. And subsequently, my lords, on 31/7/1978, it was re-granted to him. My lords, land for number 7 came to be allowed, my lords, in the year 1981. Lords, my respectful submission before my lords, even if the provisions of this Karnataka Village Officer Abolition Act are considered, lords, tenants can maintain their form number 7. Lords, that is what my submission. Even my lords, this court has taken a view. Application is very well maintainable.
Has been lawfully leased and such lease is subsisting on the appointed date.
Please.
So appointed date 1961.
74, my lords, as on that.
Allah.
Please.
This was in this section A. This is the act of 1961.
Please.
So appointed date is as per this act.
That is 63 problem. This act is.
Israel appointed date in other new course.
That is. 68.
Section 1.
68. The Office Abolition Act is 1968.
1 to 1963. Mysore Village Office Abolition.
1968.
1 to 1963, Your Lordship.
No, issued a precedent assent on 1/7/1961. Madam.
But it is.
1/2/1963.
Please, ma'am.
Please.
So you are a tenant as on 1/2/19.
That is, my lords, that has been observed by the land.
What is the finding on that?
My lords, land tribunal order is very silent. That has been not silent.
What is your claim? You are a tenant from when, Anta?
My lords, that mutation entry I have not produced. That mutation entries I have not produced.
You'll have to produce that.
My lords, even if that is considered, my lords, for number 7 order is not challenged. That is what my contention, my lords. Even if
That doesn't answer everything, Mr. Tilly. You should produce that.
That, my lords, now the counter has been raised, then I realized this facts. That is,
Because
please,
even if it is not been challenged,
please.
their contention would be that it is non-extant, contrary to law.
My lords, here in the year 1961, my lords, my name is forthcoming in the mutation entry records, which my friend has.
Of course, yes.
Lords, that is at annexure R11. Typed copy, my lords, Babu Piru Magdum.
R11.
Page number 36, my lords.
Puru Magdum. Yeah, we are in the 6061.
60.
Yes.
Please.
Astana?
This is if my lord friend forgive me.
Yes, ma'am.
Please, my lord. Your lordship may kindly see that it is in Inam land, my lord. And the propositors, the predecessor of the respondent 6 and 7 was owning that property as he was serving as a sanadi under the state government, your lordship. And this petition property as well as other 3 properties, your lordship, 787/3, 788 and 787/1 was granted to the predecessor of the respondent 6 and 7, my lord. And he died on 8/10/1949, your lordship. And after his death, his son, Abdul Rahman Bala Sheikh, was entered in the record of rights pertaining to this property as well as other properties, your lordship. I have produced that document at exhibit annexure R1, your lordship. That is R1, annexure R1, your lordship.
Yes.
That is 4/11/1949, your lordship. Bala Abbas Sheikh ಇವರು ದಿನಾಂಕ 8/10/49 ಮೈತಾಗಿದ್ದು ಏಕತ್ರ ಕುಟುಂಬ ಮ್ಯಾನೇಜರ್ ಅಂತ ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಬಾಳಾ ಶೇಖ್ ಇವರ ಈ ಪ್ರಕಾರ ಹೆಸರು ದಾಖಲು ಮಾಡಲು ವರದಿ ಕೊಟ್ಟ ಪ್ರಕಾರ ದಿನಾಂಕ ಇತರೆ. So his name was entered in the year 1949, your lordship. Thereafter, this in view of the abolition of the Inam's lands, as dated 1/2/1963, in the petition property was vested with the government, your lordship. And the government has directed the landholders, that is authorized landholders, to get it regranted on or before 20th/1/1968 by paying the assessment amounts to the parties 6 times assessment and the other people 3 times assessment, your lordship.
Yes.
And I have produced that ME number 5631 of Kognoli village at annexure R2, your lordship, the vested of the government land.
Yes.
And thereafter, the predecessor of the respondent 6 and 7 regrant has applied for the regrant of the said land, and the respondent number 4 by his order dated 16/3/1971 has regranted that land and other lands to the predecessor of the respondent 6 and 7, my lord. And to that effect, the mutation entry was effected, your lordship. And I have produced that document at annexure R3, that is ME number 6466, my lord. Annexure R3, your lordship.
Yes.
And thereafter, this the predecessor of the respondent number 6 and 7 filed an application to the respondent number 4 for conversion of his land, that is the petition property, into ordinary tenure, my lord. And he has paid the chalan of rupees 579.15 paise to the respondent number 4, my lord. I have produced the application filed by the predecessor of the respondent number 6 and 7, as well as the chalan copy at annexure R4 and R5, your lordship. Thereafter, the Shildar Chikkodi submitted information to the respondent number 4 on 31/7/1978, stating that Abdul Rahman Balashek of Kognadi has applied for conversion of his land bearing RS number 757/19 Kognoli village into ordinary tenure, and it was resumed to the government under the Karnataka Village Offices Abolition Act 1961, and it has been regranted under the respondent number 4's order dated 16/3/1971, and the now applicant has deposited an amount of rupees 579 through Challan on 29/7/1978, being the sum equal to the 15 times of the assessment, Your Lordship. And there is no any objection for convert the said land into Raitava, that is ordinary tenure, Your Lordship. And I have produced that letter at annexure R6, Your Lordship. And thereafter, the respondent number 4 by his order dated 10/8/1978, the converted the petition property into ordinary tenure, Your Lordship. And thereafter, this the Shildar Chikkodi has given an order to the village accountant to enter the by deleting the entry as new and impartial tenure into ordinary tenure, Your Lordship. And have produced that order annexure R8, Your Lordship.
Yes.
And thereafter, there was a mutation entry to that effect, Your also, Your Lordship, that is ME number 7997. And that copy is furnished at annexure R9, Your Lordship. And thereafter, the name of the predecessor of the respondent 6 and 7 by name Abdul Rahman Balashek was appearing in the revenue records of the petition property as owner, Your Lordship. And have produced the documents, that is the record of rights at annexure R10 to R11, R10 to R15, Your Lordship, from 1946 to 2001, Your Lordship.
Yes.
And in two landed properties, two RTCs, Your Lordship, for the year 1946-47 and to 1955-56 and 1960-61 to 1965-66. It is mentioned that he has got a right to serve to the government, Your Lordship. It is mentioned in the said record of rights, Your Lordship. And
yes.
The predecessor of the petitioner number 1 to 5, Your Lordship, by name Babu Piru Magdum, and the predecessor of the petitioners number 6 to 9 by name Baburao Adagoda Kagude, they are no way concerned to the petition property, Your Lordship. And this, this without the name of the Babu Piru Magdum is a hello entry, Your Honor, Your Lordship, and there is no any mutation entry to that effect, Your Lordship. It is an hello entry. And Your Lordship may kindly be say that this they have filed a form number 7, Your Lordship. Form number 7, form number 7, that is annexure A, Your Lordship. In annexure A, they have claimed 1 acre 20 guntas out of RS number 757. And annexure B, that person has also claimed 1 acre 20 guntas out of RS number 757/7, my lord.
Yes.
And annexure C is the order passed by the land tribunal Chikkodi, Your Lordship. Your Lordship may kindly be see the annexure C. That is both have claimed 1 acre 20 guntas each. The total extent of area is 8 acre 39 guntas, Your Lordship. Annexure C, that is page number 26, Your Lordship. Page number 26, Your Lordship.
Yes.
Your Lordship may kindly be see the number of the said petition, Your Lord, order, Your Lordship. KLR SR Cognoli 18, 23, 24 and 26/74. That order is passed on 28/12/1981, Your Lordship. And in the said order, it is The name of the owner, that is Abdul Rahman Bala Sheikh, the predecessor of the respondent 6 and 7, as well as survey number 757 was deleted. That is bracketed, Your Lordship. But they have granted occupancy rights. Both these persons have claimed 1 acre 20 guntas each in the 757, but they have granted 5 acres 19 guntas and 3 acre 10 guntas. That is 8 acre 29 guntas. But remaining 10 guntas, there is no any mention.
So you are concerned only for 10 guntas?
No, I am not saying that, Your Lordship. I will come to that also, Your Lordship. And regarding Your Lordship may kindly see Annexure F. Annexure F, that is the order passed by this Honorable Court in WP 5493/1982, Your Lordship. Even though the one Ganapati Balamant Jirge has filed a writ petition, this Honorable Court held that the notice was not issued to the original owner, and hence entire order is set aside. That is, Your Lordship may kindly see the order. Writ petition is filed under Article 226 and 227 of the Constitution of India with an affidavit praying that in the circumstances stated therein in this court may be pleased to quash the order dated 28/12/1981 passed by the first respondent in KLR SR Kogonoldi 18 plus 23 plus 24 and 26/1974.
Yes.
Total order is quashed, Your Lordship, as per the order passed by this Honorable Court in WP 5943/1982, Your Lordship.
So impugned order is dated 28/12/1981.
81, Your Lordship. And KLR number is the same, Your Lordship. 18, 23, 24, 26 and 74.
Land annexure C, madam.
Annexure C, page number 26.
That has been cost.
The entire order is quashed, Your Lordship.
So the Form 7 has been quashed.
Quashed. And Your Lordship may kindly say what happened afterwards. The predecessors of the petitioners 1 to 5 by name Piru Babaji Magdum got
This
entered.
was challenged by
Ganapati
Palwant Jirge.
Please, Your Lordship. Because the no notice was issued to the predecessor of the respondents 6 and 7 prior to passing of this land tribunal order, they were not available.
This order benefit you. This is, you are not
But
claiming under
it is
Jirge.
not, the order is not in respect of part of the order. Only entire proceedings were quashed, Your Lordship. As per Annexure F, Your Lordship may kindly see that no notice was issued to the original owner. That's why entire it is vitiated and quashed, Your Lordship. There is no mention that the part of the order, only in respect of these properties, it is quashed.
Yes.
And thereafter, what happened, Your Lordship? The predecessors of the petitioners have submitted a application to the Your Lordship may kindly see, that is Annexure R18, Your Lordship. R18 is on page number 59, Your Lordship, and the translation is 60. 60 translation is 62, Your Lordship.
62. Yes.
Please, Your Lordship. ME number 8841 is important, Your Lordship. Hukum may land tribunal Chikkodi hukum number Kogonoli, they have got entered their names. ಕೆಳಗೆ ತಹಶೀಲ್ದಾರ್ ಚಿಕ್ಕೋಡಿ ಇವರು ಖಾಲಿ ಅಪ್ಪ ಭಾವ ಮಹಾದಗೌಡ no my lord, sorry, I will submit that one more that
757 is item number 4.
please Your Lordship.
See, in form number 10 is also mentioned, my lords, on the right side.
Yes. Sorry, my lord.
Column
That
number
is
4, my lord.
Form number, as per the form number 10, it was 8841, your lordship. I want to rely on page number 63, ME number 10301, your lordship. 301, your lordship. 10301.
Yes.
वरदी बाजू के पर रिविजन सर्वे नंबर गड़ा कब्जेदार मियाल रहमान शेख मगदूम बाबूराव पीरगौಡ ಕಗ್ಗೋಡೆ ಬಾಬುರಾವ್ ಅದಗೌಡ ಇದರಲ್ಲಿ ಕರಾರ್ ಪತ್ರ 21/1/80ನೇ ಪ್ರಕಾರ ಪ್ರತ್ಯಕ್ಷ ಕಬ್ಜಾ ವಹಿವಾಟುಯಲ್ಲಿ ಮಾಡುತ್ತಿದ್ದು ಅದರ ವಿವರ so and so they have given you lordship ಈ ಪ್ರಕಾರ ಕಬ್ಜೆದಾರರು ವಹಿವಾಟು ಕ್ಷೇತ್ರಕ್ಕೆ ಗ್ರಾಮ ದಫರಕ್ಕೆ ದುರಸ್ತಿ ಮಾಡಲು ವರದಿ ದಿನಾಂಕ 10/2/88 ಬಂದ ಪ್ರಕಾರ ದಾಖಲು. So the predecessors of the petitioners have filed and submitted an application to the village accountant as per the agreement given by the son of the Abdul Rahman Sheikh to agreement, and hence they are in the possession of the petition property to the extent of 5 acre 29 guntas and 3 acre 10 guntas, your lordship, as per ME number 10301, your lordship. They are not claiming that they are the tenants, they are the land.
5 acres ಎಲ್ಲಿ ಬರುತ್ತೆ 3 acres 10 ಗುಂಟೆ ಬಾಬುರಾವ್ 8 acres
3 acre 29 guntas and 3 acres 10 guntas, your lordship.
29 guntas.
Please, your lordship.
Baburaj so and so 3 acre 29 and 3 acres 10.
Please, your lordship.
So 6 acres 39 ಆಯ್ತು.
Please, your lordship. And the Varadi which was filed by these persons, that is the predecessors of the petitioners, your lordship, I have produced that document at annexure R20, page number 68, your lordship. And 69 is the Kannada translation.
ಎಲ್ಲ ಪೇಪರ್ ಎಲ್ಲ ಬಂದ್ಬಿಡ್ತಾ ಇದೆ ಸರಿಯಾಗಿ ಸ್ಟಿಚ್ ಮಾಡಿಲ್ಲ.
Sorry, ma'am. Page number 69, your lordship. ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿ ಕುಗನೋಳಿ ವರದಿ ಅರ್ಜಿದಾರ ಬಾಬುರಾವ್ ಪೀರ್ಗೌಡ ಮಗ್ದೂಮ್ ಬಾಬು ಆದಗೌಡ ಕಗ್ಗೋಡೆ ಸಾಕಿನ್ ಕೊಗನೋಳಿ ಇವರು ವಿನಂತಿ ಅರ್ಜಿ ಏನೆಂದ್ರೆ ಮೋಜೆ ಕೊಗನೋಳಿ ರಿವಿಷನ್ ಸರ್ವೆ ನಂಬರ್ 757 ಈ ಜಮೀನಿನಲ್ಲಿ ಪ್ರತ್ಯಕ್ಷ ಕಬ್ಜಾ ವಹಿವಾಟು ಮಾಡುತ್ತಿರುವ ವಿವರ ಈ ಕೆಳಗಿನಂತೆ ಅದೇ. ಸರ್ವೆ ನಂಬರ್ 757 8 ಎಕರೆ 39 ಗುಂಟೆ 31/61 ಬಾಬುರಾವ್ ಪೀರ್ಗೌಡ ಮಗ್ದೂಮ್ ಎಕರೆ 5 ಎಕರೆ 29 ಗುಂಟೆ ಅಂಡ್ ಕಗ್ಗೋಡೆ ಬಾಬುರಾವ್ ಆದಗೌಡ 3 ಎಕರೆ 10 ಗುಂಟೆ. ಈ ಪ್ರಕಾರ ಕಬ್ಜೆದಾರರ ಹೆಸರು ವಹಿವಾಟು ಪ್ರಕಾರ ಕ್ಷೇತ್ರ ದುರಸ್ತಿ ಗ್ರಾಮ ದಫ್ತರಕ್ಕೆ ಮಾಡಬೇಕು ಅಂತ ವರದಿ ಬಂದ ಪ್ರಕಾರ ಸಹಿ ದಿನಾಂಕ 10/2/88 ಲಗತ್ ಮೂಲ ಮಾಲೀಕ ಮಿಯಾಲಾಲ್ ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಶೇಖ್ ಇವರ ವಹಿವಾಟಿಯ ಕರಾರ್ ಪತ್ರ ಹಾಜರುಪಡಿಸಿದೆ. So they are claiming, they are not claiming as a tenants, they are not claiming as a the land tribunal Chikode has granted an occupancy rights in their favor, but they are saying that one Mialal Abdul Rahman Sheikh has given an agreement, and on that strength, on the strength of that document, they are claiming the right over the petition properties, your lordship, as per the Vardi, as per the ME number.
This is in 1988.
Please, your lordship.
But 1981 order has been set aside.
81, it is set aside on, your lordship. That order is set aside on
19 July 84.
19 July 1984, it said. And your lordship may kindly be see that after remand, your lordship, by this this honorable court, the land tribunal Chikode has passed only in respect of 3 landed properties. Other properties they have not taken anything, and nothing is whispered in the said order, your lordship. 86 that order was passed, but nothing is whispered regarding this property as well as other properties. They have claimed more than 10 properties, your lordship.
Yes.
And this your lordship may kindly be see that after the death, this the petitioners are claiming that the Abdul Rahman Bala Sheikh has received rupees 2,000 from the petitioners as it is an occupancy price paid by them, your lordship. Your lordship may kindly be see that according to them, they have produced one document that is the affidavit of Mialal Abdul Rahman Sheikh, your lordship. Your Lordship may kindly see that the order of land tribunal was quashed by this honorable court on 19/7/1984. And they have contended that the Abdul Rahman Bala Sheikh has received rupees 2,000 on 7/9/1984, Your Lordship. After quashing that order, he has received 7/9/1984, Your Lordship. It was quashed in the month of July 1984, and according to them, he has received the amount on 7/9/1984, Your Lordship.
Yes.
Not only that, Your Lordship, this Abdul Rahman Sheikh died in the year 1987, Your Lordship. That is on 25/1/1987. If really Abdul Rahman Sheikh was taken that 2,000 amount from the petitioner's predecessors, then he could have filed affidavit before the land tribunal, Your Lordship. But he has not filed any affidavit till his death. He died in the on 25/1/1987. According to the petitioners, he received the amount on 7/9/1984, Your Lordship. But the said order was quashed by this honorable court on 19/7/1984, Your Lordship.
Now, what is the recommendation made?
Pardon me?
Recommendation by the commission?
Recommendation is only to verify the records and pass orders, Your Lordship. And the other side is making much about the appeal as well as the revision petitions filed before the respond number 3 and 4, my lord. They are dismissed only on the ground of delay. And they have the respond number 7 had challenged the ME number 7158 and 7159. That is a vesting of the land to the government, Your Lordship. And nothing more that they have not, the respondents 6 and 7 not challenged the land tribunal order or anything, Your Lordship. It was already quashed by this honorable court. Only recommendation is to respond number 3 to pass necessary orders by seeing the documents, Your Lordship.
Saying kadme madi.
Please, Your Lordship. Recommendation. As per the records, it is found that the predecessors of respondent 6 and 7 are the owners. They have, the land was regranted to them, and they have converted the same into Raitava tenure, and their names are appearing in the year of the names of, Your Lordship may kindly see the respond number 7 has given application in Janta Darshan also. I have produced the documents, that is the annexure R25, Your Lordship, page number 78. The letter issued to the revenue inspector by the Tahsildar Chikkodi, Your Lordship. Dated 30/11/2018. ಚಿಕ್ಕೋಡಿ ತಾಲೂಕಿನ ಕೊಗನೋಳಿ ಗ್ರಾಮದ ರಿವಿಷನ್ ಸರ್ವೆ ನಂಬರ್ 757 ಭೂಮಿಯು ಸನದಿ ನೌಕರಿ ಮಾಡುವ ಶ್ರೀ ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಬಾಳಾಶೇಖ್ ಇವರ ಹೆಸರಿಗೆ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಚಿಕ್ಕೋಡಿ ಇವರು ಭೂಮಿಯನ್ನು ರಿಗ್ರಾಂಟ್ ಮಾಡಿದ್ದು, ಸದರಿ ಭೂಮಿಯು ರಿಗ್ರಾಂಟ್ ಆದ ನಂತರ 15 ವರ್ಷಗಳಿಗೆ ಹಸ್ತಾಂತರವಾಗಬಾರದು ಅಂತ ಷರತ್ತು ದಾಖಲಿದ್ದು, ಮಾನ್ಯ ವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶದ ಮೇರೆಗೆ ತಹಶೀಲ್ದಾರ್ ಸಾಹೇಬರು ಅಥವಾ ಗ್ರೇಡ್ 2 ತಹಶೀಲ್ದಾರ್ ಇವರ ಯಾವುದೇ ಆದೇಶವು ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ರಿಗ್ರಾಂಟ್ ಆದೇಶ ಸದರಿ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಇದ್ದ ಸ್ಟೇ ಪ್ರಕಾರ ಶ್ರೀ ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಬಾಳಾಶೇಖ್ ಇವರ ಹೆಸರಿಗೆ ರಿಗ್ರಾಂಟ್ ಆದ ಆದೇಶ ಇದ್ದು, ಈ ಭೂಮಿಯ ಮಾಲ್ಕಿ ಹಕ್ಕು ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಬಾಳಾಶೇಖ್ ಇವರ ವಾರಸುದಾರದು ಸಹಿತ ಕಬ್ಜಾ ವಹಿವಾಟು ಹಕ್ಕು ಇರುತ್ತದೆ ಮತ್ತು ಡೈರಿ ನಂಬರ್ 102/44 ಇವತ್ತಿನ ಉತ್ತಾರೆ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಭೂಮಿಯಲ್ಲಿ ಶ್ರೀ ಬಾಬುರಾವ್ ಕಗ್ಗುಡೆ ಮತ್ತು ಅವರ ವಾರಸುದಾರು ಶ್ರೀ ಬಾಬುರಾವ್ ಮಗ್ದುಮ್ ಮತ್ತು ಅವರ ವಾರಸುದಾರು ಇವರ ಯಾವುದೇ ಪ್ರಕಾರದ ಹಕ್ಕು ಅಧಿಕಾರ ಇರುವುದಿಲ್ಲ. ಶ್ರೀ ಕಗ್ಗುಡೆ ಮತ್ತು ಮಗ್ದುಮ್ ಇವರಿಗೆ ಈ ಪೂರ್ವದಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರವು ದೇವಸ್ಥಾನದ ಭೂಮಿಯನ್ನು ಇವರಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ನಮ್ಮ ಭೂಮಿ ಸನದಿ ಇನಾಮ್ ಭೂಮಿ ಇರುತ್ತದೆ. ಸದರಿ ಭೂಮಿಯ ಡೈರಿ ನಂಬರ್ 10301 ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಬಾಳಾಶೇಖ್ ಇವರ ವಾರಸುದಾರ ಶ್ರೀ ಮಿಯಾಲಾಲ್ ಅಬ್ದುಲ್ ರೆಹಮಾನ್ ಶೇಖ್ ಇವರ ಕೊಟ್ಟಿ ಸಹಿ ಇದ್ದ ಬಗ್ಗೆ ಕಂಡು ಬರುತ್ತದೆ.
Once you have that order of the risk court in 1984, setting aside the Form 7 in WP 5943 of 1982, everything comes to a standstill.
Notes, I will take my notes to that effect. Notes, that is only in respect of my notes, the owner, who was the owner of an notes RS numbers.
Only in respect of owner, it's respect of the property.
Notes, but that is true, my lords. That
order is set as a quashed and the matter remitted. After the remittal,
My
In
lords,
1984, is there a fresh order passed
my lords,
after
one
19 July
submission. My lords,
1984?
there, my lords, my lords, I will take my lords. The grievance of the petitioner is that the tribunal, without notifying him of the inquiry, granted occupancy right in favor of 3 and 4. An order without notice to the real owner cannot be. My lords, here, real owner who is contending, that is Ganpati.
But what is the operative portion, Mr. Lee? In the
Please.
result, the writ petition is allowed. Impugned order is hereby
Quashed.
quashed.
Please, my lords.
The matter is remitted to the land tribunal for fresh
My
disposal.
lords,
in accordance
one
with law.
submission before I am not making. I have verified this entire code, I could not get. Why the owner has produced only 3 this, which he was a owner, to that extent he has approached the court.
This document new produce ಮಾಡಿರೋದು.
Lords, that is true.
Petition.
That is, my lords, I have not suppressed this, only the purpose of.
This order, impugned order is dated 28/12/1981, under which Form 7 was granted to you.
Please, please.
If that 28/12/1981 is quashed,
My lords, my submission for my lords, in the earlier order, my lords, at page number 26, there are 4 owners.
ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ.
Please,
The 28/12/81, there's one order
please,
under which it is for 18, 23, 24, 26.
please,
Now that is what you are claiming under.
please, my lords, that is something.
If that order is being quashed and the matter remitted,
My lords, one submission, that is
what
true, my lords.
happened after remittal?
My lords, after remand, only to the extent of who was the owner, my lords, to that extent inquiry was conducted. My friend has produced that.
ಆಮೇಲೆ
order.
ಏನಾಯ್ತು?
To that application, so far as those 3 lands that came to be rejected on the ground that it is a Village Officers Abolition Act.
ಇಲ್ಲಿ entire land has been entire
Inquiry, my lords, page number 65 of the,
ಆಗಿದೆ. The entire order has been quashed.
my lords, one submission.
After that, what have you done on this?
My lords, may I request, page number 65 of the statement of objection, annexure R19.
ಅಲ್ಲ ಅಂಬರೇ 3 ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಅಷ್ಟೇ ಮಾಡ್ಯಾರ ಅವ್ರು. ತಪ್ಪು ಮಾಡ್ಯಾರ.
Lords, after remand, my lords, only 3 properties inquiry was conducted, that is the owner was Ganpati.
How can that be?
See, page number 65. Page number 65.
This is the last order.
This is the last order, my lords. Only the owner is, my lords, Ganapati. He is the who has filed a writ petition before this honorable court. Only 2.
ಏನಪ್ಪ ಇದು? Once the entire order is quashed, how can you deal with only 3? What happens to 757?
Lords, may I request, my lords, instead of that, my lords, let this writ, if the writ petition order, entire papers I could have got submitted, but I am unable to get the entire papers. They can get it.
State is there, it get
State is there.
everything. How can you deal with only 3? This is what is causing all the confusion.
Secure the record.
And AGA is direct to secure the records. ಯಾವಾಗ ಬರುತ್ತೆ?
Land. Proceedings from the land as per annexure.
In ಇದು.
ಅದೇ same.
Annexure C, page number 65, it could get, why the only this inquiry was conducted to this extent.
And make a submission as to what action has been taken post the order dated 19 July 1984 in WP number 5943 of 1982.
Please.
At annexure F. ಯಾವಾಗ ಬರುತ್ತೆ?
Lord by Friday.
ಈ ಫ್ರೈಡೆ ಬರುತ್ತಾ?
Thursday.
Monday.
ಸುಮ್ಮನೆ adjournment ಮಾಡೋದು. Released on 5th February.
Yes.
Unless there is an endorsement saying that 757, the earlier order stands, there's a problem. And if you don't deal with 757, then you will have to be now directed to deal with 757.
And we have to secure within insofar as that writ petition. ಅಲ್ಲ ಯಾಕಂದ್ರೆ writ petition if he is claiming only to that particular extent and
The entire order is set aside. That's the problem.
Only my submission for my lords is, only the petitioner is the Ganapati, and my lords, the contestant.
Can't read like that, Mr. Teli. When the entire order is set aside.
Lords, only my lords, even if that is true, in the entire writ petition, only to the 3 lands, the writ relief was sought, means that can be. That I tried, my party has went to the Bangalore, he could not get any papers.
Check ಮಾಡಿ ಅದು.
Please. 36, Vital Teli.
Serial number 36, my lords, so this is order 39 rule 1 and 2. There was a direction, get the matter settled, whether they are ready to sell that take.
My party is not ready, my lord, for sale of the, my lord, portion of the land. He is not ready, my lord.
Not ready.
Not ready. Because there is a boundary dispute is there, or relations not strained, not ready.
Injunction grant ಮಾಡ್ತೀವಿ ಆರಾಮಾಗಿರ್ರಿ.
Please,
We'll grant injunction, then you stay.
No, they claim, my lord, there is absolute road, my lord, but the hand sketch map may
May I
kindly be
pass for a
seen.
moment this photo?
They already, my lord, two alternatives road, my lord, commissioner has shown, my lord. Our separate road is there.
Page number 82 is a commission report. I'm seeking only here, my lord, at a C point, my lord, I'm only required
You are the owner in 160/3 and 160/4.
only 160/3. Only
60/4 was also, my lord, he has sold.
I
my
have
lord.
sold it, my lord,
Sold,
to third party.
So you 160/3, ಯಾವ್ದಿದೆ access?
My lord, this, I am not having any access. Earlier, my
ಅವ್ರ
lord,
ಪ್ರಕಾರ access, ಎರಡು
But
access ಇದೆ ಅಂತ.
This not the OP road, my lord. OP road in commission report.
OP road ಎಲ್ಲಿದೆ?
Top because the entire 167 number is belongs to, my lord, the petitioner herein. He sold the portion of the land to three different persons, my lord. 1, 2, and 4. Now he claiming road through ours, my lord.
may I?
He sold to you also.
No, my lord, it is our land, my lord.
Lords, may I pass?
160 entire stretch is one, my lord, initially.
160/1, 160/2 was belonging to you, Mr. Teli?
Please, my lord, petitioner, he sold him, my lord.
No, my lord, I was only 160/4 and 160/3.
160/1 and 160/2?
They are not the, it does not my mind.
ಎಲ್ಲಿ ಸೇಲ್ ಮಾಡಿದ್ ಸೇಲ್ ಇಟ್ ತೋರಿಸಿ.
Sell it, my lord, say, not produce, my lord, but as per instruction, my lord.
If you produce the sale deed, we won't it.
One submission.
If there is no sale deed by the petitioner,
Please, my lord.
then we'll grant an injunction order.
So for the amendment, my lord, in the commissioner report, page number 79, my lord. 79, in the first paragraph from bottom, 6th line, my lord. ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹಾಗೂ ಕಮಿಷನರ್ ವರದಿ ಜೊತೆಗೆ ಹಾಜರುಪಡಿಸಿ OP ಅಂತ ತೋರಿಸಿದಲ್ಲಿ ಮಾತ್ರ ಅಷ್ಟೇ ಇರುತ್ತದೆ, ಆದ್ರೆ ಅದನ್ನು ವಹಿವಾಟು ಮಾಡಲು ಯೋಗ್ಯ ಇರುವುದಿಲ್ಲ.
OP 160/3 ಬರಲ್ಲಪ್ಪ.
That's
ends with 160/1.
ಫರ್ದರ್ ಕೈ ನಕಾಶೆಯಲ್ಲಿ QR ಅಂತ ಗುರುತಿಸಿದ ರಸ್ತೆಯ ಸದರಿ ಜಮೀನಿನ ಮಾಲೀಕರು ವಹಿವಾಟು ಮಾಡುವ ರಸ್ತೆ ಆಗಿರುತ್ತದೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ಕಮಿಷನ್ ನೋಡಿ ಸಬ್ಮಿಟೆಡ್ ಕೈ ನಕಾಶೆಯಲ್ಲಿ
submitted, but
QR ಅಂತ ತೋರಿಸಿದ that entire survey, my lord, it is not the road. That entire survey number 160, my lord, these two roads are, my lord.
The QR leads to OP.
Please, my lord.
OP leads to 160/1.
Please, my lord.
Unless you are able to show that 160/1 belongs to the petitioner.
Please, my lord.
Or he has sold it, then petitioner will not have the benefit of QR or OP.
Please, my lord. And WX road, my lord, WX road, my lord, it is directly connected to the, my lord, canal road. Commissioner, my lord, not shown further, my lord.
ಇಲ್ಲಲ್ಲ.
ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ, ಆದ್ರೆ this connects, my lord, it connects to the canal road, this JIJ road, my lord, that connects to the, my lord, canal road. Through that road also, my lord, he is access, my lord.
Google map of photographs ಇದಾವ?
Photographs, my lord.
So guys, sale deed produce ಮಾಡಿ.
Please, my lord.
160/1, 160/2 ಎರಡೂನು.
Please, my lord.
That they are belong to them and produce this.
And 160/3 the owner, my lord, I have produced the photographs, and
160/3 there is no issue.
He is transporting, my lord, through this WX road, my lord. I have produced along with my vacating stay application.
WX doesn't go anywhere. It doesn't connect to any road.
ಇಲ್ಲ, ಅದು ಕಮಿಷನರ್ ತೋರಿಸಿಲ್ಲ, ಆದ್ರೆ that is the road, my lord. I have also produced photographs and the cane weapon slip, my lord, transporting sugar cane, my lord.
Photographs showing that it connects to a canal road.
No, my lord, harvesting, my lord, connecting the 160/3 harvest ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಆ ತರದ photographs produce.
ನೀವು ಬಿಟ್ಟಿಲ್ಲ ಅವತ್ತು ಹೋಗಿದ್ದಾರೆ, ನೀವು ನಿಂತಾವಾಗ ಕಷ್ಟ ಆಗುತ್ತೆ.
Lord, still I have not sent 6 acres of sugarcane is standing of this 160/3 and.
Now your contention is 160/1 is his and he sold.
I will
cannot claim.
I will, my lord.
So you'll have to show that.
I will produce.
Counsel
Lord,
for
one
the
submission.
respond number 1 to 3. Submit that the petitioner was earlier the owner of the land in survey number 160/1 and 160/2 and he has sold the same. There was a access to the said 160/1 in terms of the commissioner's report at page 82 labeled as OP. The petitioner having sold 160/1 and having lost the access cannot now seek for access from the land of the respondents. An inquiry as regards whether sale deed has been produced, counsel for the petitioner seeks for a day's time to produce the sale deed to evidence if the petitioner has sold, was the owner of and has subsequently sold RS number 160/1 and 160/2. Relist day after tomorrow, 29th.
One submission, may I request? Earlier, this court directed me to transport a sugarcane, but they are not allowing me. Only I request this time, my lords, at least But any writ petition that could be. They are not allowing me. I tried police complaint, everything.
If they produce the sale deed, we'll be dismissing yours. If they don't produce it, we'll be allowing your
So
petition.
now the sugarcane,
wait
one
for 2
sugarcane
days.
factory has stopped
2
it.
days yen agalla.
37, Santosh Raut.
Yes.
Please, madam. This review petition arising out of order passed by this honorable court in RS number 1042424, madam. Wherein
Hmm.
in the second appeal, present petitioner who was the appellant has filed the application to produce the document that is earlier partition, memorandum of partition,
Hmm.
that has been declined by this honorable court. Against that, he prepared the SLP for the honorable appeals court, wherein with liberty to file review petition, it has been
How are you filing this review petition? Earlier it was Mr. Somapur.
Somapur,
appeared.
madam.
How can you appear?
Lord,
Change of counsel is not permitted in review petition.
no,
ಮೇಲೆ ಹೋಗ್ಬಿಡತ್ತೆ.
ಇಲ್ಲ, no objection ತಗೊಂಡು
No objection ಬರಲ್ಲ. Supreme Court, Tamil Nadu Electricity Board.
with that context only we prepared, madam.
ಸೋಮಪುರ್ ಅವ್ರು ಕರ್ಕೊಂಡು ಬಂದು ಅವ್ರ ಕೈಯಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇಲ್ಲಾದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ.
I will seek instructions of the parties, madam.
The above review petition has been filed by a counsel different from one who had argued RSA 100424 of 2019. Faced with the above situation, counsel for the petitioner seeks bond is granted
To 1 week, madam.
a week's time to make his submission, released on 7th February.
38, BS Sankti.
Respond number 1, my lords, Ram Kulkarni, he requested short accommodation and intimated Sankti.
ನೋಡ
2019 ಇನ್ನ preliminary
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಸರ್. ಅದೇ
Notice
3
order
and 4
ಆಗಿದೆ.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. 3 and 4.
ಇಲ್ಲ ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ.
ಹೌದು. 3 and 4.
ಏನ್ ಮಿಸ್ ಸಂಗತಿ?
ನೋಡು for 3 and 4 I accept notice.
And AGA accepts notice for respond number 3 and 4.
Yes.
Issue notice to respond number 2. Emergent notice to respond number 2 returnable by 6th March. Process fee and copies to be furnished by end of day 29th January.
39, Anil Kale.
In this, my lord, week's time, my lord, some particulars, my lord, this is regarding allotment of site.
This honorable court had directed.
And counsel for the petition seeks bond is granted a week's time to make his submission. Released on 6th
Please.
February.
40, MM Swami.
This matter, my lord, the petitioner is a purchaser, my lord, and he purchased the land from the vendor, respond number 4, my lord. The sale deed was executed on 25th 4th 2023, my lord. The sub-registrar office has directed to call for the report from the Tahsildar office for approval and permission to register the sale deed. The land is in question, my lord, actually. And he granted, my lord. That is, I have mentioned page number 16, my lord. The sale deed. Tahsildar Karyalay, Hospet, Ivar, Patra number. That is, I mentioned approval letter, my lord. After that, my lord, I went for the, I filed the application for the mutation, entities mutation, my lord. That is what rejected, my lord. And issued the endorsement, annexure D, my lord.
Sale deed ಆದ್ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Only that without obtaining permission and reject ಆಗಿದೆ. Without obtaining permission from the government, it was rejected. Annexure D, lordship. In the last.
Where is the impugned order?
Annexure D, my lord, page number 32. They themselves approved, my lord, first for permission. In between that, my lord,
ಇದೆ ಅಲ್ಲ ಅಪ್ರೂವಲ್.
In ink page 16,
necessary entries were made in the RTCs and necessary mutation entries were made, and so also entries in the RTCs. At that stage, the Tahsildar, after calling for a report from the revenue inspector, issued a notice on 25/2023 to the petitioner and also to the vendor respondent number 4, alleging that there was no prior approval obtained from the Tahsildar, as the land in question is a government land and the same could not be sold without such permission. It is challenging the same that the petitioner is before this court. The Tahsildar once earlier, while order dated 23/5/23,
18/3.
endorsement dated
18/3.
18/3.
2023.
2023.
Yes, madam.
Having categorically stated that there was no necessity for granting of any approval or permission to sell the land. This said order having passed in the administrative capacity of the Tahsildar, and the considered opinion that the Tahsildar could not review his own order and issue a notice to the petitioner seeking for calling upon the petitioner to show cause as to why the sale deed could not be cancelled. Once the endorsement had been issued on 18/3/2023, the Tahsildar was rendered functus officio and could not review his own order by issuing a notice to the petitioner. In that view of the matter, I pass the following order.
it is not the notice, your lordship, is rejected. It is not the notice.
Notice,
Notice, madam.
25/3.
In next said, your lordship, it is the order antide. Only that, your lordship, he has not obtained the
It is rejected, my lord.
rejected.
Could not have issued a notice come order. ಏನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು? ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಲ್ಲ.
Yes, madam.
Only on the ground that your lordship without obtaining permission, but it in the said your lordship it is
But he
mentioned.
himself he given, madam.
Mention only.
What is he rejecting?
Yes,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
Notice show order.
To retain in the name of the seller ಅಂತ ಮಾಡ್ತಾರ ಅವರು.
ಅದನ್ನು ಇಲ್ಲ ಇದು.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಎಂತ ಆರ್ಡರ್ ಇದು ಅಂತ.
Because he has sold the property and with the permission of the
Tahsildar.
Tahsildar.
He rejects the request for change in mutation. Mutation is already carried out. Sale deed is already registered.
Registered ಆಗಿದೆ. Only your lordship as
Petition
per
ಇಲ್ಲ.
Yes, sir.
only as per the sale deed he has to enter ಅಷ್ಟೇ.
Order rejecting the request. Rejecting the change in the mutation in the name of the petitioner. Once rejecting the change, order notice stroke order rejecting the change in the mutation in the name of the petitioner on the ground that prior approval has not been obtained. A sale deed having been already executed, mutation entries having been already made in the name of the petitioner, the question of subsequently rejecting the change would not arise if at all the same had to be cancelled by following the due process. Be that as it may, as aforesaid observed, the Tahsildar having been rendered functus officio after having categorically indicated that there was no requirement of any prior permission for sale of the concerned land, the question of issuance of any notice and/or order rejecting the mutation entry would not arise. In that view of the matter, I pass the following order. Writ petitions allowed. Certiorari is issued, order dated so on to 23/5/23. Should I respond number 2 at annexure D is quashed. ಆಮೇಲೆ change ಮಾಡಿದಾರಾ?
Not yet changed, man. Not yet changed.
It is, the respondents are restrained from causing any change in the mutation entries standing in the name of the petitioner. The one does not survive for considerations.
He's
51, Girish Bhatt.
So mandamus, I am the owner of land survey number 81/E1, which I purchased my loss, which is 12 cents.
Rectification, what are
Subsequently, I relinquished my loss 2 cents, 2.80 cents to the in the governor name for public road. After that, I requested the Tahsildar to correct my RTC entry to reduce it from 12.90 cents to 10.10 cents. E my loss by the registered deed, I have relinquished it in the name of the governor for public road. So my loss, section 140.
So you want your area to be reduced?
Oh, my loss. Section 141A mandates on the Tahsildar.
Why should not that happen?
We need to consider the lordship.
Land AG accepts notice for respond number 1. Petitioner is before this court seeking for the following reliefs. Petitioner claims to the owner of the land in survey number 81/5, measuring 0.12.90 cents, out of which 2.80 cents were relinquished in favor of the government for the purpose of widening of a road. In furtherance thereof, the petitioner had approached the respondent to rectify the entries in relation thereto by reducing the extent of 0.80. Wide. Application dated 19/8/2024. Despite this said application having been submitted, no action having been taken by the respondent, the petitioner is before this court seeking for the following aforesaid relief. It is not in dispute. What the petitioner is seeking for is rectification of the entries in the revenue records pertaining to the property of the petitioner in survey number 81/5, bracket P of B Gonal village, Bellary Taluk, to reduce the extent in terms of relinquishment deed executed by the petitioner in favor of the state. When such an application is submitted, it was required for the respondent authority to consider the same and pass necessary orders within a reasonable period of time, or reject the same. Needless to say, if a rejection order were to be passed, same would have had to be accompanied by reasons. Neither having been done, I ask the following order. Writ petition is allowed. A mandamus is issued directing the respondent to consider the application of the petitioner dated 19/8/2024 at annexure F within 30 days from the date of receipt of a copy of this order.
To my direction to reduce my loss. Because one or the other reason.
Consider it. What is the implication? They will cause an inquiry.
42, Gayatri, yes, sir.
Bari 2 cents ತೆಗೆದ್ಬಿಟ್ರೆ ಬಾಕಿ ಅವ್ರದ್ದು ಕೊಡ್ಬೇಕಲ್ಲ. Yes.
Appear for the petitioner, milords, seeking mandamus to issue hakkupatra in terms of the intimation, milords. We had already deposited the money, milords, to allot D category site, milords. Till date, there is no response from the respondent side, my lords. Your lordship, few-
ಮ್ಯಾಂಡಮಸ್
This-
ಇದು ಲೋಕ ಅದಾಲತ್
same order.
ಯಾಕ್ರಿ
ಮಾಡ್ತೇವೆ
ಲೋಕ ಅದಾಲತ್ ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ.
ಅಲ್ಲ ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಅದಕ್ಕೆ ಒಲ್ಲಿ ಕನ್ಸಿಡರ್ ಅಂತ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ.
ಅದಾದ್ಮೇಲೆ
ಅದಾದ್ಮೇಲೆ they issued an intimation.
ಇಶ್ಯೂಡ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ದೇರ್ ಆಫ್ಟರ್ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೇವೆ.
ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ 19(1)
ಇಲ್ಲ ಇಲ್ಲ
ಅದಾದ್ಮೇಲೆ 4(2) ಇಂಟಿಮೇಷನ್ ದುಡ್ಡು ಕೊಟ್ರು 4(9) ಅದಾದ್ಮೇಲೆ ಇನ್ನ ಮಾಡಿಲ್ಲ 5(9)
ಬರೀ ಅದು ಆಫೀಸರ್ಸ್ ಮಿಲೋಡ್
ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ರು.
ಇನ್ನು ಯಾರು ಇಲ್ಲ ಇಲ್ಲ ಈಗ ಮಾಡುತ್ತೆ ತಾವು ನಿನ್ನೆ ಆರ್ಡರ್ ಮಾಡಿಂದ ಎಲ್ಲಾನು ಮಾಡಿದ್ವಿ. ತಾವು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಇದೆ, ಇಟ್ಸ್ ಟ್ರೂ ದಟ್ ಇಟ್ಸ್ ಕವರ್ಡ್.
ಶ್ರೀ ಜಿ.ಕೆ. ಹಿರೇಗೌಡರ್ accepts notice for respond number 1 and 2.
ಅದರ ಒಂದು ಸಬ್ಮಿಷನ್
ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಬೇಡ ಅಂತೀರ. ಸೇಮ್ ಇದೇ ಮಾಡಿ ಡೇಟ್ ಚೆಕ್ ಮಾಡಿ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಚೆಕ್ ಮಾಡಿ ಅಷ್ಟೇ. ಕಾಸ್ಟ್ ಬೇಡ ಇದ್ರಲ್ಲಿ.
Actually, pursuant to my lord's order, that order, already all the matter, including this matter also not.
ಇನ್ಯಾವುದು ಬರ್
43 KL Patil.
Your lordship, I am appearing for respondent number 3, City Municipal Corporation.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಈ ಕಡೆ ಬನ್ನಿ.
Sorry,
ಪೆಟಿಷನರ್ ಈ ಕಡೆ.
sorry, pardon.
ಎಸ್
Appearing for respondent.
ಎಸ್
File my objections. I have to file my objections.
ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟು ಸೀರಿಯಸ್
Disqualification under anti-defection.
counsel for respond number 3 seeks submit that
It can be,
draft of the
if
objection
your lordships are inclined to hear it, my lords, because I am a formal party, ಅದಕ್ಕೆ authority ಇರೋದ್ರಿಂದ
objections ಬೇಕು ನಿಮ್ಗೆ. ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಟೈಮ್
I am an authority, my lord, so
who is the authority?
I am
is
for
the contesting.
Complainant.
Yes, complainant.
Authority ಯಾರು?
I am the municipal corporation, city municipal council, my lords, to elections to the post of, my lords,
President and Vice President.
he was
Whip
disqualified.
issued.
Whip was issued and the petitioner,
Remained
the
absent.
councillor, my lords, is disqualified. Order is passed by deputy commissioner, so, my lords.
Deputy Commissioner State. Annexure F is by Deputy Commissioner. 43. Ready?
Not in fact, not on the last occasion, my lord, before the other bench, my lord, I have submitted, my lord, the judgments of my lords, my lord, wherein, my lords have held that, my lord, the deputy commissioner, my lord, the complaint, my lord, was directly submitted to the deputy commissioner. And the contention of the petitioner is that, my lord, the
Rule 4 is not followed.
complaint. My lords have held that, my lord, after referring all the judgments, my lord, that, my lord, deputy commissioner, even if a complaint is directly lodged to the deputy commissioner, still the proceedings holds good, as my lords have observed. I have submitted that judgment also, my lord.
Only ಅದೇ ಗ್ರೌಂಡ್ ಇರೋದಾ?
Yes.
Other grounds also there. Other grounds, also, since I am suffering from
ರೆಡಿನಾ? ಯಾರು ರೆಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ಅರ್ಧಂಬರ್ಧ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಹೇಳ್ತಾ ಇದ್ರು. ರೆಡಿ ಅಂದ್ರೆ ಎಲ್ಲರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
next week.
At the request of counsel for the petitioner, released on 5th February.
Obliged.
Is made clear no further adjournment would be granted.
44 Prithvi KS.
My lords, before regular appeal, my lords, the appeal was dismissed for non-prosecution. Against that, my lords, miscellaneous has been filed, my lords, the same was confirmed. In spite of, my lords, the objection have not filed by the respondents. The same has been confirmed before the appellate court.
ಏನಕ್ಕೆ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ?
My lords, for 2 hearings, the counsel has not appeared, only
2 hearings. Issue notice to respondents.
My lords, before the miscellaneous appeal, my lords, for respond number 2, 15, 12 and 13, they have appeared. I will seek dispensation, my lords, for remaining respondents, my lords. And also serve the counsels, my lords, appeared before the.
Lord counsel for the petitioner submits that in
Respond number
RA
two,
number 25 of 2018, only respond number
2, 14, 15 and 17
2, 14, 15 and 17
have appeared.
had entered appearance and the rest were placed ex parte.
Please.
In that view of the matter, accepting the memo filed by the counsel for the petitioner, notice to respond number 1 to 3, 1, 3 to 13 and 16 is dispensed with the sole risk, cost and peril of the petitioner. Counsel for the petitioner is also permitted to take out hand summons.
Please.
To respond number 2, 14, 15 and 17.
Please.
Returnable by 19th February.
Please.
45, Sharanappa Kolibad.
Yes.
My lord, petitioner is the bona fide purchaser of the suit property in respect of the dependent number 2 husband, my lord. Now, my lord, the plaintiff is seeking that he is a declaration of the 1/3 shares, my lord.
Suit for?
Suit for declaration of 1/3 share, my lord.
Declaration and partition.
Declaration partition, my lord. As per the plaintiff, my lord, the trial court has decreed 1/3 shares, my lord, and stated that, my lord, the sale deed executed by the deceased Mehboob, who is the husband of the dependent number 2, the dependent number 1, 3 and 4 in respect of the portion of the suit scheduled property not binding on the plaintiff 1/3 share, my lord. My lord, in respect of the plaintiff shares ಬಿಟ್ಟು ಉಳ್ಕದ್ ಯಾವುದು not binding ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, my lord. Then, my lord, the dependent number 1 filed an RA, my lord. But RA is confirmed, my lord. Now, my lord, I am the dependent number 4 is there, my lord. I am the purchaser of the from the dependent number 2 husband, my lord. On that property, my lord.
Yes.
Now, my lord, the
Final decree was directed.
final decree is there, my lord. FDP is filed by the plaintiff, my lord. FDP is, my lord, in that property, my lord, that in FDP, my lord, the bona fide purchase is the ex parte, is the formal party ಅಂತ ನಮ್ ನೋಟಿಸ್ ಕಳಿಸ್ಲಿಲ್ಲ, my lord. Please, man.
Where is that entry?
And annexures, my lord,
FDP order.
page number 65, man. 65, man. Page number 65. Last, man, respond number 3 to 5 are formal party because they are the purchasers. Their sale deeds are not binding upon the petitioner's suit, such scheduled property ಅಂತ. ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಿಂದ FD ಒಳಗೆ ನಮ್ಗೆ ನೋಟಿಸ್ ಕಳಿಸ್ಲಿಲ್ಲ. Then, my lord, respond dependent number 5, my lord, one Nasima filed an execution petition, my lord. But dependent number 5, my lord, in before OS, my lord, she is ex parte, my lord. And also, my lord, she is not declared the shares, my lord. Only for my lord, plaintiff, in respect of the plaintiff shares is declared, my lord. The dependent number 5 shares, my lord, when she arises in FDP, my lord, 1/3 shares is there, my lord. But I am the bona fide purchaser of that property, my lord. One dependent number 2 husband, my lord. That property, my lord, the sale deed, my lord. Dependent number 5 is also one of the witness, my lord, because that property is not standing in the name of the dependent number 5, my lord. While at that the sale deed, my lord, partition ಆದ್ಮೇಲೆ ಈಕಿನ ಹೆಸರಲ್ಲೇ ಬಂತು, ನಸೀಮನ ಹೆಸರಲ್ಲೇ.
But you contested the suit, your contention was rejected. Appeal came to be rejected.
But that decree, my lord, not binding, my lord. Only for plaintiff shares 1/3 shares ಕೇಳಿದ್ರು, 1/3 declare ಆಯ್ತು, my lord. Even, my lord, ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಹಾಕಿದವರು ಅವ್ರು ಎಕ್ಸ್ ಪಾರ್ಟಿನೇ ಇದ್ರು, my lord, ಬಿಫೋರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ದಲ್ಲಿ. Nasima is the execution petition filed by the. That is
their contention. 1/3 is plaintiff ಆಯ್ತು, 1/3 defendant number 5 ಆಯ್ತು. ನಿಮ್ಮ sale deed has been held to be not binding on the plaintiff's 1/3 share. Plaintiff is the decree holder.
My lord, plaintiff shares na ಕೇಳ್ತಾ ಇಲ್ಲ my lord. But ಇಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಡಿಪೆಂಡೆಂಟ್ 5 ಈಗ ನಮ್ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿರೋದು ಡಿಪೆಂಡೆಂಟ್ 5 ಅಲ್ಲಿ ಇದೆ my lord. But as on the date of sale deed my lord, the standing in the name of the dependent number 2 husband my lord, that property. And also that property sale deed ಗೆ ಡಿಪೆಂಡೆಂಟ್ 5 ಕೂಡ ವಿಟ್ನೆಸ್ ಇದ್ದಾರೆ. Annexure H ದಲ್ಲಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. She know that my lord. Therefore my lord, she is not participate in OS and RA ಇದೆ. RA ದಲ್ಲಿ ಬಂದು ವಕಾಲತ್ ಆಗ್ತಾರೆ my lord. ಯಾವಾಗ ಆಕಿಗೆ ಡಿಕ್ಲೇರ್ 1/3 ಅಂತ ಸೇರ್ಸ್ ಒಂದು FDP ಬಂತು, ಆಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಹಾಕ್ತಾರೆ ನನ್ ಸೇರ್ಸ್ಬೇಕು ಅಂತ. ದಟ್ ಈಸ್ ಫ್ರಾಡ್ my lord. ಇವನ್ FDP ಯಲ್ಲಿ ಕೂಡ ಪಾರ್ಟಿ ನಮಗೆ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿ ನೋಟಿಸ್ನು ಕೂಡಲ್ಲ ಪಾರ್ಟಿಸಿಪೇಟ್
CPL ಆದ್ರೂ ಹೇಳಿದ್ರೆ ಆಗಿರೋದು. And there is a compromise there.
Please.
Issue notice to the respondents written by 11th March. The further proceedings in execution petition number 3 of 22 pending on the file of the additional civil judge in JMFC was pete is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29 January. Acknowledgement for having served notice on the respective counsels for the respective respondents before the before the execution court to be filed on or before 4th February. Failing either of which, the interim order will stand automatically vacated.
Please, man.
46 Vijay Malali.
Please, ma'am. Application under order 18 rule 17 came to be rejected.
18 rule 17?
Yes.
Yaವಾಗ file ಆಗಿದ್ದು?
Please, ma'am.
What stage did you file it?
At the stage of defendant evidence. I filed application to recall the evidence of cross-examine the evidence of PW1. But on the ground.
ಶುರು ಆಗಿತ್ತಾ?
No, my lords.
ಇನ್ನ ಶುರು ಆಗಿದೆ.
Defendant evidence start ಆಗಿರಲಿಲ್ಲ. But the court has taken view that, my lords, I have taken 19 adjournment and I have twice, my lords, the recalled. The plaintiff, my lords, is the husband. The defendant number 1, 2, 3, my lords, is a wife and children's. Husband claims against the, my lords, the wife, my lords, partition.
But why are you taking so much time?
She is residing at Delhi, my lords.
ನಿಮ್ ಕೌನ್ಸಿಲ್ ಡೆಲ್ಲಿಯಲ್ಲಿ ಇದಾರಾ?
ಇಲ್ಲ, ಕೌನ್ಸಿಲ್ ಅದಾರೆ.
ಮತ್ತೆ ಇಷ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡು ಎಷ್ಟು ಸತಿ ಕಾಸ್ಟ್ ನೋಡಿ?
Twice, my lords, same was recalled.
Recalled, costs have been imposed some 5 times. No.
The one opportunity, my lords, very same day, my lords.
Opportunity, the court has given you so many opportunities.
Wife is, defendant number 1 is residing at, my lords, Delhi.
So let her reside in Delhi. If she can't instruct her
And many
lawyers,
times, my lords, the matter was sent for settlement. Settlement ಅಂತಾನೆ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಬರೀ.
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಅದನ್ನು ಎಕ್ಸಾಸ್ಟ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ, ಪ್ಲೇಂಟಿಫ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ತಗೊಂಡಿದ್ದು ನಾವು.
ನೀವು ಕೇಳಿರೋದು. From 14/6/22.
Yes.
Petitioner is before this court seeking for the following relief. Notice to respondents is dispensed with in view of the proposed order to be passed. What is under challenge is the order dated 11/12/2024, passed by the trial court on IA number 11 filed under order 18/17 for recall of the stage and reopening of the matter for cross-examination of PW1. The submission of learned counsel for the petitioner is that if one more opportunity is granted, the petitioner would cross-examine PW1 and proceed with the matter. A perusal of the detailed order dated 11/12 detailed impugned order would indicate that the matter was first posted for cross-examination of PW1 on 1/12/2021. And when the cross-examination was not conducted, the evidence of PW1 was closed. When a recall application was filed, the recall application having been allowed on cost, subsequent thereto 19 adjournments were sought for by the petitioner. And again, the side of the petitioner, plaintiff was closed. Thereafter, once again, a recall application was filed, which came to be allowed. Again, the petitioner sought for and obtained several adjournments, but did not cross-examine PW1. Once again, the side of the plaintiff was closed. And it is in that background that the application IR number 11 was filed, which came to be rejected by the trial court. A perusal of the order sheet would indicate that on several occasions, costs have been imposed on the petitioner. Despite the costs having been imposed, despite on 2 earlier occasions, the matter, the side of petitioner, plaintiff's evidence being closed and recall application having been allowed, the petitioner has chosen not to cross-examine PW1. And counsel for the petitioner submit that the petitioner is a resident of Delhi, and as such there has been a delay. Even if the petitioner were to be a resident of Delhi, the matter having been posted for cross-examination on 1/12/2021, no cross-examination has been conducted till date, except for filing application for recall and seeking for adjournment. Even costs not having been paid, I have the considered opinion that there is no diligence on part of the petitioner requiring this court to exercise its equitable jurisdiction to permit the petitioner to once again cross-examine PW1. 4 years have been wasted by the petitioner in seeking for adjournments. No grounds being made out, the petition stands dismissed at the stage of admission itself.
47 RHND.
Suit for specific performance was filed.
Suit for?
Specific performance was filed. Kindly turn to Annexure B, my lordship. This is the document on which the plaintiff is claiming the right over the property. And in the said document, there is a recital stating that, my lordship, kabja kottiruttare. So when the document was tendered in evidence. Yes, that is on page number 18, my lordship.
Yes, where?
In fourth paragraph from the top. ಇವತ್ತಿನ ದಿವಸ ಕಬ್ಜಾ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಸದರ ಆಸ್ತಿಯ ಕುರಿತು ಬಾಕಿ ರಕಮ್ 5 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಖರೀದಿ ಕಾಲಕ್ಕೆ ಕೊಟ್ಟು ಖರೀದಿ ಮಾಡಿಕೊಳ್ಳಬೇಕು. ಖರೀದಿ ಕಾಲಕ್ಕೆ ಯಾವಾಗ ಕರೆದರೂ ಬಂದು ಖರೀದಿ ಮಾಡಿಸಿಕೊಡುತ್ತೇನೆ. ಇವತ್ತಿನ ದಿವಸ ಕಬ್ಜಾ ಕೊಟ್ಟಿರುತ್ತೇನೆ. This is the recital forthcoming in the document. When this document was tendered in evidence, the trial court has impounded the document.
By we?
No, in my humble submission, my lordship, nowhere in the pleadings, my lordship, and in the notice which was issued prior to filing of the suit, the plaintiff has claimed possession over the property on the strength of this document, my lordship. And even in the pleadings also there are.
You are stuck by it.
No, even
the document, we are not looking at your pleadings to stamp it.
No, I'm not claiming any possession over the property, my lordship.
The impounding is of the agreement of sale, not of your pleading.
No, if I am claiming a right under the said document, my lordship, then the document has to be impounded, my lordship.
Mr. Angadi, ನೀವೇ draft ಮಾಡಿಸಿರೋದು as the purchaser.
This document has come into existence. No, this document has come into existence in the year 2018, my lordship.
So ನಿಮ್ಮ client ಮಾಡಿಸಿರೋದು.
ಅಲ್ಲ ಮಾಡಿಸಿದ್ದಾರೆ. They are illiterate, my lord.
To take advantage of it.
They are illiterate. And I'm not claiming right under the said document that his position is claimed, my lord.
They cannot be said to be illiterate. They have signed very well. Style like signature ಇದೆ.
ಇಲ್ಲ.
The 5E will get attracted, whether you claim or not. That's the finding of the coordinate bench. Finding of the coordinate bench, you are aware of it. No, 5E will get attracted if under that document, possession is given.
No, that,
In fact, another coordinate bench has gone ahead and said even subsequently possession ಅಂತ ಹೇಳಿದ್ರೇನು cover ಆಗುತ್ತೆ ಅಂತ.
no, if I am claiming any right under the, and if I have pleaded to that extent, my lordship, then I am bound to, that is pay the deficit stamp duty, and it has to be registered, my lordship. Anyway, nowhere in the pleadings, my lordship, nowhere in the notice also, my lordship, I am claiming right. And position is not delivered as on that date also, my lordship.
But the stamping is of the agreement, not of your pleading.
No, if I am claiming right under the document, and if I am claiming position, my lordship,
if we accept, then the agreement will given a go by various
no,
pleadings.
even assuming, my lordship, the fact is that, my lordship, the position is not delivered as on that date by virtue of this document. The defendants are in possession of the property. They are cultivating the land in question, my lordship.
We won't stay the proceeding, we'll issue notice if settlement agatta anta.
Please, please.
Issue notice to respond number 1 and 2, returnable by, emergent notice returnable by 20th, in order to ascertain if there's a settlement which is possible. Counsel for the petitioner to cause notice of the above petition on the counsel appearing for respond number 1 and 2 before the trial court, and file the same before this court on or before 4th February 2024.
My request in the first week, my lordship, since the document is already sent to district register for ascertaining the valuation.
The emergent notice at least 3 weeks.
I'll take your hands on the advocate.
13th February.
Please, please.
48 CR payment.
ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಡಕ್ ಬದಲು ಅವ್ರಿಗೆ ಎಕ್ಸ್ಟ್ರಾ ದುಡ್ಡು ಕೊಡ್ಬೋದು.
Matter. The respond number 6 is the contesting party. His claim before the the deputy commissioner and the assistant commissioner regarding one of the property which is measuring 1 acre 35 guntas purchased by the petitioner and another Parvatama. That property virtually it is belongs to the father husband, who is having the 2 wives, that is petitioner and one deceased Parvatama. His claim is in the year 2010 he got purchased the property, and thereafter he kept quiet, and after the death of one of the vendor, that is Parvatama, when the records are enter, revenue records are entered, the name of the the present petitioner, now he has challenged the entries before the assistant commissioner. Even assistant commissioner, page number annexure D. The assistant commissioner stated and the findings that there is a dispute with regards to the sale deed itself. That dispute has to be raised before the civil court. That liberty has been given.
The dispute as regard to sale deed.
Please, annexure D, the finding 41, page number 41. And even the sale deed itself is in the suspicious. The registered number, very when the appeal was filed, he has shown different register number. Thereafter, he sought for amendment.
Where is the sale deed? Annexure C.
That's annexure C. Initially, this sale deed has produced before the assistant court, respondent number assistant commissioner. Thereafter, annexure C1 is he has taken there is a placed the register number instead of year 2009. 2013 and 14 was mentioned. That while looking to the that sale deed, the itself is suspicious.
How can we rectify?
Because your lordship, when a registered deed, your lordship, the revenue authority cannot go into the merits of the case, because your lordship, in para number 13 of this petition, the petitioner himself has stated, your lordship, regarding the sale deed, he has to approach the civil court, but the revenue, your lordship, authorities have to exercise their rights, your lordship, under the Registration Act. They are done. It is also finding given by the deputy in page number 17.
Here they have the sale deed on the face of it is dated 14/6, presented for registration on 17/6.
Yes. But your lordship, when your lordship is
the endorsement,
when the petition is disputing regarding sale deed, he has to approach the civil court and get it set aside the sale deed.
On the face of it, when the sale deed was presented for registration on 17/6/2013,
But your lordship, revenue
your officer accepted to be 9/10.
but the revenue authority, your lordship, have to accept the, your lordship, by the register sale date.
Yes,
So your
if
lordship,
it is
exercise,
rightly done.
yes.
Here, the amendment to a date of the sale deed is allowed.
Amendment of sale date cannot be made, your lordship.
13/2/09, nodi.
In page 70 make annexure, that is A. ಒಂದನೇ ಅಂಶದಲ್ಲಿ ವಿವರಿಸಿದ ಕಾರಣ ಮೇಲಿಂದ ಪರಿಷ್ಕರಣ ಅರ್ಜಿದಾರ ಸಲ್ಲಿಸಿದ ಪರಿಷ್ಕರಣ ಅರ್ಜಿ ಪುರಸ್ಕರಿಸಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಕೊಪ್ಪಳ ಇವರು ದಿನಾಂಕ 25/1/2024 ಹೊರಡಿಸಿದ ಆದೇಶಗಳನ್ನು ಮತ್ತು ಕಂದಾಯ ನಿರೀಕ್ಷಕ ಕಾರಟಗಿ ಇವರು ದಿನಾಂಕ 28/8/2001 ಹೊರಡಿಸಿದ ಆದೇಶ ರದ್ದುಪಡಿಸಿ ವಿವಾದಿತ ಜಮೀನಿನ ಪಹಣಿಯಲ್ಲಿ ನೋಂದಾಯಿತ ಖರೀದಿ ಪತ್ರ ಪ್ರಕಾರ ಪರಿಷ್ಕರಣ ಅರ್ಜಿದಾರರಿಗೆ ಹೆಸರಿಗೆ ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಲು ತಹಸೀಲ್ದಾರ್ ಕಾರಟಗಿ ಅವರಿಗೆ ಆದೇಶ ಸೂಕ್ತವೆಂದು ಕಂಡುಬಂದ ಈ ಕೈಯಿಂದ ಆದೇಶಿಸಿದೆ.
ರದ್ದುಪಡಿಸೋದು ಹೆಂಗೆ?
Yes.
On that basis. We had rejected his contention and ಅದು ಬೇರೆ.
Yes.
Sale deed date change ಮಾಡಿ, number change ಮಾಡಿ.
Sale deed change ಮಾಡಕ್ಕೆ he has no right.
Other basis ಮೇಲೆ
ಅದು ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ.
DG accepts notice for respond number 1 to 5, issue notice to respond number 6, returnable by 12th March. The operation of the order bearing number so and so dated 26/12/24 passed by respond number 1 at annexure A. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29, failing which the interim order will stand automatically vacated.
49, Santosh Raut.
Please, my lord. Respondent number 1 filed suit for partition, which was came to be decreed. Which was came to be decreed, my lord. Wherein mother has been also allotted with particular share. And mother relinquished they get relinquishment deed from the mother on 39/2022. And thereafter on 15/12/2022, mother died, my lord. And FDP was came to be filed on 30/1/23. That time I came to know about the relinquishment of my mother when she was under in the hospital. At that time she was unable to understand what is what. I filed the private complaint and accordingly matter was referred and FIR was filed. Thereafter I filed the suit for declaration to declare that the relinquishment is not binding on us. And they accordingly I filed the application in FDP. Until disposal of the suit, the FDP proceedings may kindly be stayed, wherein the FDP court declined to grant the relief. I approached this honorable court, and wherein I got the liberty to file application in a suit. In the suit also, the trial court rejects the application on the count that the
You contested the first appeal, you contested second appeal, you contested the.
I am not on that, my lord. I am not on that.
And now you have come up with a new contention.
My lord, my mother, they got executed the relinquishment deed on 39/22. My mother has died on 15/12/22.
13?
39/22, and mother has died on 15/12/2022.
2 months later.
My lord, when she was in hospital, my lord.
What have you produced to show that she was in hospital?
My lord, I have filed the private complaint.
Private complaint ನೀವೇನಾದ್ರು ಬರಿಬಹುದು. What have you shown? What document have you produced to show that she was in hospital?
My lord, regarding documents are not produced, but I have the documents, my lord.
ಕೊಡಿ.
These are the discharge summary and clinical.
She was in hospital for 1 day.
My lord, other documents I have, my lord, it is not that.
This is
Even,
only,
even in the earlier occasion, I filed the application before the FDP court wherein,
body and joint pain for last 8 days. ಅದು how
my lord,
is it?
it has paper news ಆಗಿದೆ ಅದು.
You have had your extension of time for a long time.
My lord, ಅವ್ರಿಗೆ ಶೇರ್ ಕೊಡಕ್ ನಂದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ನಮ್ಮ ಮದರ್ ಶೇರ್ ನನಗ್ ಬರೋ ಶೇರ್ನ ದೇ ಹ್ಯಾವ್,
ನಿಮ್ಮ mother ನಿಮ್ ಜೊತೆ ಇದ್ರಾ?
my lord, earlier she was with me only.
That time was she residing with you?
As on the date of death, she was.
So you are not even taking care of your mother and you want her share.
My lord, I am not.
Sorry, Mr. Raut. Petitioner is before this court seeking for the following relief. Notice to respondents.
Kevat, respondent number 1 kevat.
Respond number 1 KVT ಅಲ್ಲಿ ಇದ್ದೀರಾ?
Please.
Respond number 2 accept ಮಾಡ್ತೀರಾ? Different 1 and 2.
1 and 2, my lord. We are not any instructions with regard to respond number.
Notice to respond number 1 is on KVA. Notice to respond number 2 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The petitioner had filed an application under section 151 of CPC in OS number 301 of 2024 filed by the petitioner seeking for declaration, consequent relief of permanent injunction for stay of the FDP proceedings number 6 of 2023, which came to be dismissed by the impugned order dated 22/1/2025,
17/12.
which is challenged.
17/12/24, my lord.
22/1/25.
Call on.
Then date is
17/12/24.
17 already, 7/12.
Next date of
17/12/24.
Yes.
next date of hearing 17. The application came to dismiss on the ground that, my lords, there was an inquiry was going to be conducted on relinquishment deed.
The suit in OS number 182 of 2018 had been filed. 182, 1080.
My lord, which was, came to be returned. Munchip court ಅಲ್ಲಿ ಇತ್ತು.
2018 filed by the defendant number 1.
Earlier suit
182.
number ಏನು?
Earlier suit number, my lord, OS 182/2018
182.
of annexure A, my lord. Annexure A, page number 13.
182 of 2018 had been filed on the file of the 4th Additional Senior Civil Judge JMFC by
The present respond number 1, my lord.
respond number 1 herein for partition and separate position which came to be decreed. Challenging same, the petitioner herein had filed RFA number 100275 of 2020, where it was declared that the plaintiff and the first and second defendants are having 1/3 undivided share in the total extent of the properties, and a preliminary decree was directed to be drawn up. The same came to be challenged in a SLP number
SLP ಇಲ್ಲ.
SLP file, my lord.
Madam,
6587 of 2023, na? Number ಏನು?
6587 of 23 came to be dismissed.
6587 of 2023 which came to be dismissed.
On 25,
Subsequently, FDP 6 of 2023 had been filed. During the pendency of the said FDP, the mother of the petitioner, namely Mahadevi Gurrappa Agasimani, had executed a relinquishment deed in favor of respondent number
1 and 2 herein,
1,
and 2 herein.
who was the respondent number 2 in the FDP proceedings. The petitioner therefore filed alleging that the relinquishment deed was obtained by fraud, had filed a private complaint and also a suit in OS number 301 of 2024 seeking for a declaration that the relinquishment deed was not binding on the petitioner. In the said suit, the aforesaid application had been filed seeking a stay of FDP number 6 of 2023, which came to be rejected by the court seized of OS number 301 of 2024. The submission of Shri Santosh B. Raut, learned counsel for the petitioner, is that the relinquishment deed was executed on
3922 mal.
39
309
2020.
before filing FDP mal.
relinquishment deed ಯಾವುದು?
That is on 3922.
39/2022. When he claims that his mother was unwell, and as such, this execution of relinquishment deed is fraudulent to deprive the petitioner of his right over the share of the mother. And in that background, we submit that until OS number 301 of 2024 had been decided, the further proceedings in FDP number 6 of 2023 ought to have been stayed by the trial court. Having gone through the documents and having perused the impugned order, it is clearly seen that the suit in OS number 182 of 2018 had been contested by the petitioner all the way up to the Supreme Court, up to the Honorable Apex Court, wherein the petitioner had failed. The special leave petition having been dismissed on
25/5/2023, my lords.
25/5.
2023.
The mother of the petitioner having expired subsequently in December 2023. Hereafter, the
No.
suit
She died on 15/12/2022.
15, 12.
22, my lords.
22, na?
Please.
The mother of the petitioner having expired in the meanwhile on 15/12/2022, the suit in OS number 301 of 2024 has been filed challenging the relinquishment deed executed by the mother during her lifetime on 30/9/2022. On the ground that the same came to the knowledge of the petitioner post the disposal of the special leave petition. Having perused the documents, it is seen that the petitioner, having failed in the SLP, has subsequently filed the suit in OS number 301 of 2024. The relinquishment deed having been executed during the pendency of OS number 301 of 2024 is a registered document. executed by his mother. Now, the FDP proceedings are sought to be stayed by the petitioner till the disposal of OS number 301 of 2024, which, to my considered opinion, is only to protract the proceedings and delay the implementation of the final decree. The trial court, the FDP court, the trial court has also seized of OS number 301 of 2024. After considering the papers in OS number 301 of 2024, has also categorically come to a conclusion that there are no grounds made out by the petitioner for stay of the proceeding in FDP number 6 of 2023. I do not find any infirmity in the said order for the reasons attributed by the trial court as also the reasons given here and above. The FDP court would have to go ahead with FDP number 6 of 2023 and conclude the proceedings at the earliest. The petition stands dismissed.
Yes.
Dinesh Kulkarni.
Petitioner Marod purchased 2 acres of agriculture land in 2010. At the time of purchasing, my lord, he has taken a necessary certificate from the Tahsildar to show that he belongs to the agriculture family. In 2000, and his name was entered in record of rights. Land was bifurcated. Thereafter, he obtained loan from the bank also. In 2013, my lord, Tahsildar referred the matter to Assistant Commissioner to hold inquiry. There is a violation of section 79A and B of Karnataka Land Reforms Act. Thereafter, the Assistant Commissioner has now passed the order, holding that there is a violation of 79A of the Land Reforms Act and order for vesting the land into the government.
Yes.
Lord,
without issuance of notice.
Lord, notice were issued, but
you are
not
not
served.
residing there.
He was out of station.
But next year you will have 2014 order. There is a delay. And you will worship in under section 118, appeal provision you will worship to the tribunal. If the order is passed under section 83.
Their order, second respondent.
Yes, Assistant Commissioner. Tribunal.
Commissioner order challenge ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Lord, grievance is now, the said provision is repealed from the date of inception.
Only for pending proceedings.
Allah, from date of inception it is deleted.
Only for pending proceedings. You have to file you can't come to this court.
Not the, here, Lord, on prima facie, your lordship, kindly see page number 13. Page number 13, sale deed. Para 3.
Yes.
ನೀವು ಕೃಷಿ ಕುಟುಂಬದ ಸದಸ್ಯರು ಇರುತ್ತೀರಿ. ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಹಾನಗಲ್ ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೊ ದಿನಾಂಕ 14/7/10 ಪ್ರಕಾರ ವ್ಯವಸಾಯಗಾರರ ಕುಟುಂಬದ ಸದಸ್ಯರ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು.
Order ಅಲ್ಲಿ.
Yes.
Where is that order?
Please.
Where is that?
That this order copy is not available. It is referred in sale deed.
Order copy ಬೇಕು.
ಅಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ. Even application ಕೊಟ್ಟು ಟ್ರೈ ಮಾಡಿದ್ದಾರೆ. Now
ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ.
It is referred in the.
Then that will complicate and compound the matter, Mr. Kulkarni. Before this court definitely compounded.
Registered sale deed, there is a reference. And not.
You go avail the appeal. Without this document, we won't.
One more thing. If once it is held that he belongs to agriculture family, 79A does not apply.
Order copy ತೋರಿಸಿ 14/7. Only then it can be held.
Sikila, I will try, I will try to get it one more time.
If you don't succeed, then
the finding of Assistant Commissioner is violation of 79A. It refers that he is not belonging to agriculture family.
That is only if you produce 14/7/2010.
I will try to get it.
If you don't produce it, it cannot be.
I will try to get it.
And AG accepts notice for respondent number 1, 2, 3. Counsel for the petitioner seeks for and is granted 10 days time to produce the order dated 14/7/2010 said to have been passed by the third respondent Tahsildar, holding the petitioner to belong to an agricultural family. Agriculturist family.
Agriculturist.
Released on 11th February.
One, Kishore Sutar.
It's a matter pertaining to demand of property tax from education institution, my lords. Your lordships covered by judgment, my lords. Annexure D, my lords, page number 15.
And AGA accepts notice for respond number 1. See,
Chetan Manwal. Chetan Manwal.
Monoli accepts notice for respond 2 and 3. In education, reserving liberty for non-educational purposes. Education tax, reserving liberty.
Please.
I'm seeking for interim order.
Disposal.
Your disposal.
Please.
230 mood matter. 1, Rajshekhar Halli. Rajshekhar Halli.
Yes, Mr. Lee.
Please, my lord, Annexure J is the impugned order, my lord, passed by the respondent number 3, my lord. My lord, there being without any notice to the appellants, my lord, petitioners, my lord. My lord, directed to the Tahsildar to delete my name, which was entered in the year of 1973.
And AGA accepts notice for respond number 1 to 4. Issue emergent notice to respond number 5 to
10, please.
Returnable by 19th March. The operation of the order passed by respond number 3 bearing number so and so dated 21/2025 at Annexure G is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 29th January. Failing which the interim order will stand automatically vacated.
2, Susai M. Patil.
Yes, Mr. Patil.
Commercial suit was filed by the petitioner before the principal DJ Dharwad, and the honorable court passed an order of emergent notice. My only request was that attachment of the property as per annexure C1, because there is a possibility that he may run off the Dharwad itself, and he is trying to sell the property. My suit is recovery of 21 lakhs. If the attachment is not given, if any alienation is made, I will not be left with nothing. Even the checks are given by him have been bounced.
He won't attach, we'll restrain him from alienating.
Please.
Attachment is a very high form.
KSFC, he has already there is attachment.
To emergent notice to respond number 1 and 2, written by 12th March. Respondents are restrained from any manner alienating the properties scheduled to the plaintiff.
Please.
The plaintiff. Plaintiff ಇದೆಯಾ?
ಅಯ್ಯದಲ್ಲಿ
plaintiff ಹಾಕ್ಬೇಕಾಗಿತ್ತು ನೀವು. Scheduled to I
number 1, my lord, at C1.
1 filed in commercial OS number 42 of 2024.
Page number 29.
Pending on the file of the principal district and session judge and designation commercial court at Dharwad till the next date of hearing. Process fee and copies to be furnished by end of day 29th January, failing which the interim order will stand automatically vacated.
Surati Mudhol.
Yes. Petition.
Lord, in the morning, I have received the report, but it is not so satisfactory in order to make, submit before the honorable court. Lord, as per the instructions given by the concerned officer, those statements have been recorded, but it is not forthcoming. Straight away, it has been addressed to me and reported, and along with the signature of the deputy commissioner. So that cannot be submitted before the honorable court. But on going through the report, it is noticed that at the time when they request for the certified copy of motion of no confidence resolution, in order to the note which has been put up by the assistant commissioner to close that note should not be given. For that purpose, that paper was backsided and it was.
Why did the assistant commissioner say to close?
Please.
Why did the assistant commissioner say close and not the endorsement irkudu anta yake?
ಅಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡಬೇಕಾದ್ರೆ ಅದು ಬ್ಯಾಕ್ ಸೈಡ್ ಅವ್ರು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಹಾಕಿದ್ದು ಗ್ರೀನ್ ಶೀಟ್ ನಲ್ಲಿ ಇದ್ದು ಅದನ್ನ ವೈಟ್ ಶೀಟ್ ಇಟ್ಟು ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಬರೀ ಫಸ್ಟ್ ಪೇಜ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಯಾರು ಮಾಡಿದ್ದದು?
That is issued by the concerned case worker who issues the certified copy.
Under whose instructions?
Assistant commissioner instruction only. ಅದಕ್ಕೆ for that reason only I made a submission. The satisfactory reason is not assigned. So my lord, since in view of some revenue meeting before the Bangalore, my lord, the deputy commissioner is not present today. He will come on Wednesday morning. If the lordships give up till 29th or 30th, my lord, I'll submit. Since election is on first ಇದೆ election.
ಅದು ಸ್ಟೇ ಮಾಡೋಣ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಷ್ಟರೊಳಗೆ ನಾವು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರೆ it can be allowed itself.
ಏನ್ ರಿಪೋರ್ಟ್? ಹೆಂಗೂ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ.
ಅಲ್ಲ ಈಗ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇತ್ತು ರಿಟ್ ಪಿಟಿಷನ್ has to be go.
Put on 31st.
Yes.
Without will dispose. Now that action will take some.
Yes, Lord.
The learned AGA submit that though he has received a preliminary report from the deputy commissioner, the same is not complete. He seeks for 3 days time to submit a proper report. The operation of the impugned notice dated 15/1/2015 issued by a second respondent at Annex H is stayed till the next date of hearing. Released on 31st.
Please.
At 2:30 p.m.
Please.
I'm told, my lord, the
For further
assistant
hearing.
commissioner called the PDO, my lord, and got the, my lord, acknowledgement, my lord, endorsement done by the PDO. He calls PDO who was on leave. He calls him and tell him to acknowledge on the.
Whoever is doing the hanky-panky and mischief in these kind of matters, PDO avರಂತೂ ಎಲ್ಲ ಕಡೆ mischief ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So that is why we are directing inquiry. They have no business to interfere in the democratic working.
Please.
And if the assistant commissioner is also doing that.
Yes.
PDO is not forgivable, but assistant commissioner will be even worse.
Yes.
No, he is a custodian.
No, my lord, I have strictly instructed them. But the report.
My lord, get it, my lord, endorsed. He gets the endorsement of PDO.
We are not accepting what Mr. Goodwala is saying right now.
Yes.
If we accept it, we will have to take action immediately.
Yes.
So nimge option ide. They can't be doing like the functioning of the entire panchayat will come to a standstill because of this. ಒಬ್ಬರ ಮೇಲೆ ಇನ್ನೊಬ್ಬರಿಗೆ ಹೇಳಿ ಅದ್ ಮಾಡಿ ಇದ್ ಮಾಡಿ ಏನಿದು? They are not there to do politics. Let the politicians do that. These officers cannot do that.
Please.
It's on 31st.
Please.
Serial number 84, may I make mention, my lords? Appear for the respondent in this matter, my lords, wherein this honorable court order dated 28/10/2024, my lord, was pleased to direct to maintain status quo, my lord. But learned trial court, my lord, not proceeding with the suit, my lord, and stating that, my lord, awaiting this honorable court's order, my lords.
Let it wait for some more time.
My lords, my kind submission.
Interim order may kindly be extended.
ಎಲ್ಲ interim order extension.
This matter may kindly.
68, my lord. In serial number 68, I am for respondent authorities. Lord, petitioner herein challenging the demand notice issued by the Gram Panchayat authorities. There is an alternative remedy is also available.
Yaar 68 petitioner.
But I have also filed memo in this regard.
Petitioner yaar ಇಲ್ಲ, we can't take it about 5:30 for that.
Tomorrow.
ಇಬ್ರು ಇದ್ರೆ ತಗೊಳ್ಬಹುದು. Yes, Mr.
My lords, 84, my lord. Date, my lords.
Date ಬರುತ್ತೆ.
Article number 63.
My lords. My lords, I apologize for mentioning the matter out of turn. My lords, this is with respect to a matter on Saturday wherein
We are not
your lordship
listening
had
to you.
directed-
Just Please hold your horses. Yes.
The land of the petitioners,
Sorry, my lords.
without there being a acquisition
ಜೋರಾಗಿ
process.
ಹೇಳ್ರಿ, ಅವ್ರು ಜೋರಾಗಿ
Lands
ಮಾತಾಡ್ತಾರೆ.
of the petitioners, my lord, have been taken without there being a notification. The then chief minister have inaugurated the building, my lord, without there being a final notification. The award also has been made. Till date, my lord, the award has been not seen any light. And in recent, my lord,
What are you submitting? You are arguing or you are submitting? You are
it may be,
mentioning.
it may be take it in the second week of February, my lord.
ಬರುತ್ತೆ.
Date may be, my lord.
ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Serial number 79, my lord.
ಹಾ.
My layout has been stayed, my lord, by virtue of,
ಅಷ್ಟೇ ತಾನೆ.
my lord, application, my lord, have filed application for, ಅಲ್ಲ,
ಅಷ್ಟು ಮೆಮೊ ಮೂವ್ ಮಾಡಷ್ಟು ಫೈಲಿಂಗ್ ಆದ್ರೆ ಏನ್
sorry, my lord. I have filed application for vacating stay, my lord.
ಬಹಳ ಜನ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ.
T group ಅಲ್ಲಿ ಇದೆ ಅದಕ್ಕೆ. Kindly, my lord, one chance to.
Yes. ಹೇಳಿ.
My lord.
ಹಾ. ಕೊಡ್ತಾರೆ. Yes, who was this on the?
My lords, I apologize, my lords.
Yes,
my lords. My lords, with respect to the GM police matter on Saturday, wherein your lordships had directed the superintendent of police to consider and provide police protection, it was orally communicated, my lords, but the SP is demanding a certified copy. That is the reason the learned senior counsel had requested for hand delivery.
SP is demanding certified copy.
Secretary sir, ಮೇಲೆ ಹೋಗ್ಬಿಡುತ್ತೆ.
Lord, my colleague appeared, my colleague appeared. Sharad Maktoum, Allah court.
Sharad Magdoum had appeared. Tell him to inform me. Certified copy, Bharat. If anybody goes on insisting on certified copy,
My lord, I will inform you.
that old practice needs to go.
My lord, serial number 88,
Great,
my
my
lords.
lord.
ಏನ್ ಹೇಳಿ?
88, very short point, my lord.
ಎಲ್ಲ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್.
My lords, no, my lords. I'll not take more than a minute, my lords.
92 elections are stalled. This is the election.
One submission.
My lords.
Serial number 63. They made a submission that they are seeking for quashing of the final notification and award. Pursuant to which, my lord, we have deposited the amount before.
They have not passed any order when it.
They are not even accepting, since there is an internal dispute between their family members who are the owners of that property. They are not accepting the money.
They are saying that the money is there now. If you want to accept.
ಇಲ್ಲ,
you
ಇಲ್ಲ.
accept.
Allah deposit to ಮಾಡಿದೆ ನಾವು.
There is no
Civil court ನಲ್ಲಿ.
My lord, I may be submitted, and it may be fixed on 12.
The details.
12/2, my lord, it may be have it on 12/2.
Boss.
Last time, page wise, page wise. ಇಷ್ಟು ಸಣ್ಣ ಪಾಯಿಂಟ್ ಐತೆ.
72, 29.
ಈ ವೀಕಲ್ಲಿ ಯಾವ್ದು ಕೊಡಲ್ಲ, ಫೆಬ್ರವರಿ
58.
12/2 ಗೆ ಏನಾದ್ರು ಕೊಡಿ.
Serial number 58. 12 ಕೊಟ್ಟಿದೆ. 58, 58.
72 ಮೂರನೇ ತಾರೀಕು. 72 3 32
72.
32.
ಕೊಡಿ ಸರ್ 32 ಕೊಡಿ ಅಂತಂದ್ರೆ
6-2 ಹೇಳಿದ್ರಲ್ಲ.
ಇದು actually short point.
68.
ಈ ವೀಕಲ್ಲಿ ಯಾವ್ದು ಕೊಡಲ್ಲ.
7-2.
68.
ಬರೀ 68 ಅವ್ರು ಹೇಳಿದ್ರು. 68 ಕೊಟ್ಟೆ ನಾನು ಹೋದೆ ಮುಂದೆ.
62.
Sir, 90.
ಡೇಟ್ ಬರುತ್ತೆ, ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ
Entry ಮಾಡ್ರಿ.
ಸರ್ 72 ಯಾಕೆ ಕೊಟ್ರಿ?
ಈ ಕಡೆ
5-2 ಅನ್ನೋ ಅದು ಬಿಟ್ಕೊಳ್ರೆ 10ನೇ ತಾರೀಕು ಕೊಟ್ಟೆ. 12.
ಈ ಸುಮ್ನೆ ಬೇರೆಯವ್ರಿಗೆ ಡೇಟ್ ಕೊಡ್ಸಕ್ ಹೋಗಿ ಅವತ್ತು ಇದು ಮಾಡ್ಬೇಕು.
30th ಅಥವಾ 31st.
ಶ್ರೀರಾಮ್ ಸರ್.
ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಮಂಡ್ಯ ಹಾಕ್ತಾರೆ ಬಿಡ್ರಿ ಅಂತ.
ಶ್ರೀರಾಮ್ ಸರ್.
88 ಬಂದಿದೆ ಸರ್.
4ನೇ ತಾರೀಕು ಇಟ್ರಲ್ಲ.
ಸಾಟರ್ಡೆ ಬಂದಿದ್ ಮ್ಯಾಟರ್.
4ನೇ ತಾರೀಕು ಹಾಕಿ.
31st. ಅದೇ ನಮ್ದು.
ಸರ್ 90 ಡೇಟ್ ಐತೆ, ನಾನು ಅರ್ಜರ್ನ
ಮೆನ್ಷನ್ ಮಾಡಾಕಿದ್ದೆ ಮಂಡ್ಯ ಹಾಕ್ತಾರೆ ಬಿಡ್ರಿ ಅಂತ.
90
ಸರ್
ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ.
ಹಾ, ಎಂಟ್ರಿ ಮಾಡೋ ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಎಲ್ಲದ್ರೊಳಗೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
ಶ್ರೀರಾಮ್ ಸರ್.
ಜ್ಯೋತಿ ಮುನಿಮನಿ ಮೇಡಮ್ ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿ
ಮತ್ತೆ ಯಾಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋ?
ಅವ್ರು ಮಾಡ್ಬಿಟ್ಟಾರ ಅದು ನಾವು ಟೈಮ್ ಇಲ್ದಿದ್ದಕ್ಕೆ
ನೋಡಿ ಮಾಡಿದ್ದಾರೆ.
ಸರ್
ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಇತ್ತು ಮುಂದೆ ಅದು ಹಂಗೆ ಮತ್ತೆ ನಾ ನೆನಪಾಗ
6-2.
Sir, 79.
6-2.
79, interim order extension.
Sir, no, 34. 79 ಅಲ್ಲ?
ಹಾ.
ಶ್ರೀರಾಮ್ ಸರ್.
ಒಂದೇ ನಿಮಿಷ ಸರ್, ಒಂದೇ ನಿಮಿಷ ಇಲ್ಲಿ ಕಳಿಸ್ಬಿಡ್ತೀನಿ.
ಡೇಟ್ ಎಂದ ಹಾಕ್ತೀರಾ ಸರ್?
ಡೇಟ್ ಫೆಬ್ರವರಿ.
ಫೆಬ್ರವರಿ ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ಸರ್ ಪ್ಲೀಸ್.
34.
ಅದಕ್ಕಿಂತ ಜಲ್ದಿ ಬೇಡ ಸರ್.
ಇಲ್ಲ ಫೆಬ್ರವರಿ.
ಹಾ, ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
34 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇತ್ತು, ಅದು GM RES ಆಗಬೇಕು, ಅಲ್ಲಿ ಹೋಯ್ತು.
ಸರ್ ಯಾರ ಮುಂದೆ ಹೋಗ್ತದೆ ಸರ್? 6ರಾಗ GM RES 6ರಾಗ. ಅಚ್ಚಾ
ಒಂಟಿ ಸರ್ ಹೇಳಿ.
ಸರ್ 72
ಹಾ
7ಕ್ಕದು ಹಾಕ್ತಿರೇನು ನೋಡಿ ಸರ್ ಫ್ರೈಡೆ ದಿನ.
32 ಅಂತ ತಗೊಂಡ್ ಹೋದ್ರು ಅವರು. 32
ಸೀರಿಯಲ್ ನಂಬರ್ 9.
ಶ್ರೀರಾಮ್ ಸರ್ 57.
ಹಾ ಓಕೆ ಸರ್ ಹೇಳಿ. ಸಂತೋಷ್ ಸರ್. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲದನ್ನು ಸೆಕೆಂಡ್ ವೀಕ್ ಫೆಬ್ರವರಿಗೆ ಬರುತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ.
ಶ್ರೀರಾಮ್ ಸರ್
ಹಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 57 ಸರ್. ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ ಸರ್.
12th ಸರ್. 12th ಆಫ್ಟರ್ 12th ಸರ್.
ಹಾ ಓಕೆ.
ಎನಿ ಡೇಟ್ ಸರ್.
ಸರ್ ಮಂಗಳವಾರ ಇನ್ನು ಹಾಕ್ತಿರ ನೋಡಿ ಸರ್. ಮಂಡೇ ಬಹಳ ಬೋರ್ಡ್ ಇದಾಗ್ಬಿಡ್ತೈತಿ.
32 ಬೇಡವಾ ನಿಮಗೆ?
ಮಂಗಳವಾರ ಏನ್ ನೋಡ್ತೀರಾ ನೋಡಿ ಸರ್. ಈಗ ಅವ್ರಿದ್ರೆ ಇಲ್ಲ ನಡೀತೈತಿ. ಇದಾಗಿ
ಈ ವಾರ ಬೇಡ ಸರ್. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್
ಈ ವಾರ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವಾರದಲ್ಲಿ ಮಂಗಳವಾರದು. ಸೋಮವಾರ ಅಂದ್ರೆ ಮತ್ತೆ ಎಕ್ಸಾಮ್ ಹೆವಿ ಇರ್ತದಲ್ಲ ಬೋರ್ಡ್, ಅದಕ್ಕೆ
5th ಕೊಳ್ಳ 5th.
ಹಾ ನಡೀತೈತಿ ಅಂತಂದ್ರೆ.
ಓಕೆ ಆಯ್ತು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
90 ಏನೇನು
90 ಅರ್ಜೆನು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ ಅದಕ್ಕೊಂದು.
ಯಾವ್ದು?
4-2.
4-2.
ಸರ್ 57 ಅಷ್ಟು 12th ಅಥವಾ 13th ಸರ್.
ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಕೊಟ್ಟು 79.
ಮತ್ತೆ ಅವತ್ತು ಅದು ಹೆಂಗೆ ಆಗುತ್ತೆ ರೀಚ್ ಆಗುತ್ತೆ.
ಭಾಳ ಇದ್ದಿದ್ದು
57 12th ಅಥವಾ 13th ಸರ್.
57.
ಹಾ ಸರ್.
13 ಕೊಟ್ಟಿರ್ತೀನಿ.
ಪ್ಲೀಸ್ ಸರ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಅದು.
ಹಾ ಮಾಡ್ತೀನಿ. ನಿಮಿಷ